lordship's list, my lord.
Hmm.
My lord, it's an interlocutory application, my lord. Directions for affidavit were issued, my lord, in September 2023 by Justice Mukherjee.
I am opposing this application, my lord. This mentioning, in fact, my lord, if Mr. Dotto, my lord, should tell your lordship that this notice was served at 9:53 a.m. today morning, and he's mentioning at 10:30.
My lord, I am mentioning only for inclusion. My lord, I don't know what this objection is all about, my lord.
My lord, if my learned friend wants to mention a matter, he should give a notice at least prior in point of time.
My lord, my learned friend is here seeing that notice. I just want
No, my lord.
Despite several my lord, extensions, affidavits have not been filed. If he wants to fight over this issue, my lord, I am ready.
Okay, Mr. Chaudhary, you know, practice of this court mentioning, I am taking as a mentioning, but without the other party, I am not passing any order. It will be taken on one day.
I am only praying, let it appear as to be mentioned, my lord.
I will list the matter as to be mentioned. Let the issue the notice.
Very well, my lord will only kindly just take one thing into consideration. If, my lord, this practice is being allowed, that a party gives a notice at 9:53 and mentions the matter at 10:30, my lord, whether, my lord, I may put it in question form, whether this should be permitted or not.
That is correct. That is correct. You are correct on your side. But if it is mentioned, I am not taking. It will be listed as to be mentioned. Then
no, my lord, I appreciate that, my lord. All that I'm saying is, my lord, we both practice.
Okay. This will be taken note of it.
7 months, his client will not file affidavit. I give him half an hour's mentioning notice. He will make a hue and cry about that.
My lord, this is not the practice, my lord. If this is what Mr. Datta has to say, my lord, then he should follow the procedure.
Okay, Mr. Chaudhary, when you wanted to be listed as to be mentioned, not for any concern, I will.
My lord will put it whichever day your lordship feels it to be convenient. My lord, I don't have a problem with that. What I'm saying is about this practice.
Okay, no problem. I am fixing on 16 as to be mentioned. You come, we'll see.
Grateful, my lord.
Grateful to your lordships.
My lord, may I permit to mention a matter? My lord, in this matter, is the trademark matter. The matter has been settled. We want to withdraw the suit on the basis of terms of settlement. In this matter, the defendant is represented by the outstation counsel, my lord. They have requested to put the matter on Tuesday. Subject to my lord consideration, let it appear on Tuesday, my lord. We will withdraw the suit on the basis of the terms of settlement between the parties. 16, my lord.
Okay, put on 16.
I'm appearing for the respondent, my lord. Much obliged.
My lordship, may I permitted to mention this matter? My lordship, this is a civil suit, and the petitioner has filed this suit.
Which year suit, madam?
My lordship, 2024. My lordship, this suit has been filed without the court fees. Now I'm praying for listing this matter in to be mentioned list so that I can have a direction before this learned court to file the court fees.
There is no report. How without the file, how this court can allow? That's why I'm telling. I have already instructed the office. If any thing is there, if on scrutiny, if the file it is found that any difficulty is there, they have to place the matter before this. You are mentioning. If I will allow something different in the record, so what will happen? Tell the department to bring the file.
My lordship, kindly fix this matter in to be mentioned, and I will tell the department to place this record.
My lord, may I be permitted?
Obliged.
My lord, may I be permitted? Item number 47, non-commercial, my lord.
Yes, 47.
47,
With the listed
Mr. Learned Advocate appearing on behalf of the plenty, my lord, is suffering from dehydration today. So not this week, my lord.
47.
Yes, my lord.
When the matter is called, you mention.
Okay.
Let the matter be.
May I, my lords, kindly leave to mention a matter, my lord, for a small rectification in the order. If your lordship kindly looks at, my lord, I have marked the portion, my lord, which needs to be rectified, your lordship. My lord, in that portion, it is written, my lord, that no, all the parties did not agree, my lord. My lord, but this is the, my lord, recordings of the, my lord, learned commissioner, my lord. Only the, my lord, the defendant did not agree, my lord. Defendant did not agree. Plaintiff agreed to the, my lord, proposition placed by the commissioner, my lord.
So, have you gone through? The plaintiff submitted the commissioner for the purpose of partition of the suit property has given a proposal for appointment of one valuer who was quoted rupees, but the parties were not agreed. What is the problem on that?
My lord, only if a clarification may be given. Grateful, my lord.
My lord, may I take a leave to mention a matter? My lord, I am praying for a leave to file a wakalatnama without no objection, my lord, because previous advocate is not giving no objection, my lord, in spite of giving the several reminder and the request letter, my lord. Even there is no such
Which year suit?
My lord?
Which year suit? Which year suit?
Oh, 2018, my lord.
2018,
my
what
lord.
is the stage of the suit?
My lord, the substitution petition because the sum of the plaintiff has expired. So that's why it was a
Who is
pending.
for the plaintiff?
My lord,
Who is for the plaintiff?
plaintiff was there was as much as 10 plaintiff, my lord.
So, no, who is appearing for the plaintiff advocate? Who is the advocate on record?
Advocate is a Victor Moses, my lord.
Victor, have you issued the notice?
My lord.
You do one thing, you issue the notice to the advocate and the earlier advocate also. I am fixing on 18, that's to be mentioned.
My lord.
You issue the notice to the earlier advocate also who is appearing for the defendant.
My lord.
Hey, इसके ये कागज कहाँ है?
But I'm appearing on behalf of the defendant and petitioner.
I am for the plaintiff, my lord. How to respond?
GI is dismissed.
Get
May it please, my lord. My lord, I appear for the defendant.
My lord, I am for
learned
the
friends, witnesses in the box. Today was kept, my lord, to furnish the photocopies of the conveyance produced by Tata. My lord, even Tata's advocate is here. After
lord,
it
we
is
are told
produced, we
he's
compare
present.
it. Then your lordship may give them leave to take back the original. And as far as the other
The colored Xerox, we are told that it has been done finally. So may we get a copy from your lordship's
done?
court officers? It's there.
Who has done? Parties have done.
Parties have paid, but it has been done by the
I
defendant.
think we should contribute a color printer to the High Court.
It's a PWD requisition.
Solicitors are appearing, they can contribute to the.
I'm told the other subpoena is also here, my lord. So then,
For ECL, I have produced the original copy of the deed.
with
along with
photocopies.
the photo.
Photocopy attested, certified
Certified.
One of the copies
with the color.
color. That's good.
Yes. Then, well, these three things. One is to get the record that the colored Xerox are here and we get copies. And then the second conveyance and the third thing. And,
Third thing is
and
for the
if he
fixing
wants
of
his
the deed.
originals back,
Yes.
then we can give subpoena date, the last notice.
Last notice, affidavit of service. Affidavit of service.
Your lordship's order of 19th February records when Mr. Sengupta had given the
Yes, yes.
other documents.
So this three sets. How many copies have been Xerox colored? Manotosh?
3 sets. 3 sets,
Three
I'm told.
sets.
Oh.
3 sets have been Xerox. So you take one copy each,
Yes.
and one copy will be kept in the court. And with regard to ECL who has produced certified original, certified copy will be here, and one copy.
But he will have to produce his the original subpoena. Anything.
Photocopy of this.
Oh, yeah. File the photocopy of the subpoena and his. ECL if the location you are representing.
Representing ECL,
You have to record that man's name. You have to record that man's name that he has come.
Has to be recorded. Who is there from ECL?
Where is the original? ये आपका है कौन वाला है? This is made by you, made by the court.
So, original.
My lord, to an extent, the first deed is concerned. My lord, if after comparing, my lord, if I may just, lordship may grant me the leave to take back the original for Tatas.
Yes, bullet.
So this is produced by the ECL. ECL. Three sets. And where is the original? So you will get the go through the inspection.
Yes,
be
your
carried
lordship
out.
will carry out the
Correct.
inspection.
Well, your lordship will record the gentleman's name
Name.
who's come, who my learned friend is representing. And this is the at a subpoena copy, the Lord. First.
Yes. What is your good name? But that who has produced the authorized officer is Alam. The as per this so and so appearing for the plaintiff, so and so appearing for the defendant number one, and so and so appearing for the Tata Capital Finance Service Limited, and so and so appearing for the ECL Finance Limited. As per this subpoena issued by this court dated 3rd January 2024, the ECL Finance Limited has submitted the original convenience deed dated 10th February 2018, along with 3 sets of the attested colored Xerox copy, certified, not certified, colored, not attested, certified colored Xerox copy of the said deed. Full stop. The counsel for the respective parties are directed to inspect the certified colored Xerox copy along with the original convenience deed dated 10th February 2018, produced by the ECL Finance Limited. In course of day,
Yes,
Well,
yes.
they can see it just now. They can be released.
Yes.
of day, and after inspection of the original from the certified copy of the deed, comma, the original will be written. The original shall be written to the ECL Finance Company Limited by keeping one certified copy of the deed on record and other two Xerox colored copy of the convenience deed may be provided to the learned advocate for the parties.
Well, on the last occasion, the Lordship had exhibited the subpoena. There was exhibit 11 and the document was 12.
That at the time of evidence I will take.
Yes.
Today,
No, because he won't be there. The subpoenas,
okay, I will
it was marked in the order itself. Your Lordship sees 19th of February, second page, third paragraph. Exhibit 10, neither. 9 and 10. Sorry.
exhibit 11 and
9 and 10 on
Yes,
top,
yes.
the second paragraph.
yes, 9 and 10.
Allah the-
Original deed of convenience, 9th, that is on 9th March.
Yes.
Now this is to be exhibited. You're telling that this is to be
On-
exhibited of
yes,
the
now
ECL
the-
document.
The subpoena and the photocopy can be.
So the ECL Finance Limited has produced the original along with the certified copy of the convenience deed dated 6th February 2018, along with the subpoena. Accordingly, the subpoena and the original and the certified copy of the convenience deed dated 10th February 2018 be marked as exhibit
13 and 14.
13 and 14 respectively.
My lord, so far as the other document is concerned,
In terms of the order dated 21st of March 2024, the Assistant Registrar of this court has got the convenience deed dated. What is the date dated?
What's your date? 9th of March is the Tata Capital.
9th of March of
18.
2018. Get it Xerox. Get the 3 sets of colored Xerox from the outside of this court and has kept with the record. Full stop. The parties are full stop. Let these 3 sets of these 3 sets, na? So 2 sets is to be given. Full stop. The parties are directed to inspect the Xerox photocopy of the document along with the original deed, which has been marked as exhibit 10.
Yes, that was exhibit 10.
And after the inspection by the parties from the original deed, comma, the original convenience deed be returned
To the advocate only.
learned advocate on record of the Tata Capital Finance Service Limited.
Finance
And-
Services Limited.
And the one colored photocopy of the said deed be kept with the record and be marked as exhibit 10.
Yes.
Be marked as exhibit 10 in place of original. in place of original. The other two sets of the copy and Xerox colored copy be handed over to the learned advocates for the parties. Full stop. Cost का क्या है? Payment paid. Then what is the stage of the suit now?
The cross-examination, then I can complete whichever day your lordship keeps.
Let the matter appear on
Except the 16th, any other.
see one any date is अच्छा it's a commercial no? The date fix 23rd of April for cross examination.
Yes, to continue the cross.
Time fix करो ना.
For cross examination. Plaintiff witness.
Commercial
Witness.
plaintiff's witness is being cross-examined.
My lord, may the time be fixed, my lord.
It's a commercial, it'll come in the
But my
morning.
lord, it will go down, my lord, much.
That is
See, comes in. I'm grateful.
देख लेना सर
लॉर्ड,
original
for the
रखना, और वो जो ओरिजिनल देगा इसमें एग्जिबिट 10 कर देना.
My lord, I am for the plaintiff.
Yes.
My lord, the plaintiff in this suit is Cotton Corporation of India Limited. My lord, and my lord, our my lord, job was to my lord, procure my lord, cotton seeds from farmers and my lord, process it into raw cotton in full pressed bale and sell it to the cotton mills. My lord, that is in usual course of business. My lord, we entered into my lord,
This business is still going on.
with my lord different number one spinning mill and my lord government of West Bengal was the guarantor. My lord, they have paid some amount, the remaining outstanding is there. My lord, kindly come to paragraph 36. I'm only claiming clause 12 leave because my lord, apart from all the defendants, only my lord defendant number 2, government of West Bengal, currently is my lord, your lordship knows in Navanno, my lord, Howrah, outside the jurisdiction. All the rest defendants are within, even my registered office is within. And in fact, at the time when the entire transaction happened in 2011-12, the different number 2 government of West Bengal's main center of activity was also Writers Building within jurisdiction. I've mentioned everything in paragraph 36. This is a commercial dispute. Defendants being all government entities, section 80 notice has been given. Page 87, paragraph 24, page 14. Kindly see, my lord, section 80 notice has duly been given, my lord. Page 14, paragraph 24, last, my lord.
Page 80.
Page 14. Page 14, my lord, paragraph 24. Under section 80 of the Code of Civil Procedure 1908 as amended and treat this instant notice as a notice under section 80, failing which the plaintiff would be compelled to initiate appropriate proceedings in accordance with law. Copy of the section 80 notice is at page 87. Your lordship can see. Thereafter, my lord, we went for mediation. My lord, mediation is there is a non-starter report at page 95. Page 95.
Yes.
Last paragraph. So, my lord, I'm only seeking clause 12 leave. Full court fees has been paid. Section 80 notice there and mediation, there is a non-starter report. Last paragraph. In the present scenario, page 95, discussion held in various mediation meetings is concluded. No further meetings are required. My lord, similar prayer in the rest too also. Same, my lord, non-starter, my lord, section 80 notice, non-starter, and my lord, all the defendants are within 7 except defendant number 2. They had their office, as I said. There are
concise statement.
not concise statement is right at concise statement.
Yes.
Yes, my lord, that's there.
But there is no prayer in the concise statement. First matter.
Yes, first matter. My lord, first matter is 613 of 2024. Yes, my lord, concise statement is there.
And see the prayer. Where is the prayer of 12?
My lord, 12 I don't need.
Yeah, 12.
Clause 12.
That has not.
My lord, that, my lord, concise statement they don't give. I've seen it.
Fine, but you not give, but at the time of passing the decree, again it will be
My
difficult.
lord, decree, they, I believe, my lord, subject to correction, they see, my lord. They see the prayers, main prayer. Well, my main prayers, the, my lord, first
There is
prayer.
there, that's why,
Yes,
but
yes.
there is.
But it should have been, my lord. We shall be much more careful.
I am giving the leave to.
My lord, I
correct
shall
that.
correct it. I shall correct it.
So appearing for the plaintiff. Plaintiff is leave under clause 12 of the letter patent, 1865. Consider the submission made by the counsel for the plaintiff for use the plaintiff and the document. Counsel for the plaintiff prays for leave to add the prayer of leave under clause 12 of the letter patent in the concise statement. Leave is granted. The plaintiff is directed to add the prayer in the concise statement. Add the prayer for leave of clause 12 of the letter patent in course of the day. Leave is granted. Clause 12 of the letter patent, subject to scrutiny by the department.
But similar my orders in 3 and 4. 3, 4, and 5. Your lordship has passed in 3, 4, and 5. My lord.
They are also consistent.
Yes, my lord. We have been consistent in our error.
All the three,
All three.
the same.
Court fees paid, my lord. Court
That
fees.
that the department say.
Act number 6, my lord, I'm for the plaintiff, my lord.
Yes.
Item number 6, my lord, I'm for the plaintiff. This is my restoration application, my lord.
Why restoration? Why the suit is dismissed? So
My lord,
application dismissed.
And application dismissed on 4th March, my lord. On 4th March, I had a matter, my lord, before your lordship, my lord, at 10:30 a.m., my lord. And this item was item number 7 before court number 23. But after I completed here, I went there, it was dismissed.
So I am at fault.
No, my lord, I am at fault. I did not take care that it would be called so soon. Dismissed on 4th March, restoration application filed on 6th March. I've served the other side, my lord. Yesterday also the matter appeared, they had taken time.
So appearing for the plaintiff, none appears on behalf of the defendant.
The interim order that was granted on 13 December, that may be also restored, my lord. I prayed. Prayer A and B of the notice of motion.
For recalling of the order dated 4th March 2024, wherein this court has dismissed the interlocutory application GA-COM 1 of 2023 for default. Immediately after the dismissal of the said application, on 6th March 2024, the plaintiff has filed the present application for restoration of the same. This could find that sufficient cause has been shown for non-appearance of the plaintiff before this court at that time when the matter is called. Accordingly, the order dated 4th March 2024 is recalled. GA-COM 1 of 2023 is restored in its original file. Consequently, the interim order passed by this court is also restored. Also restored. GA-COM 2 of 2024 disposed of. List the GA-1 of 2023 along with CS-232 of 2023 before this court on 25th of April 2020.
My application, this is a new application appearing, we haven't been served. But
not served.
My lord, we are serving it here and now, my lord. Let it appear, my lord, any day next week, my lord.
We'll file affidavit.
Yes, yes.
So let directions for
we need to
affidavit.
know what this application is.
Additional
Extension of time to file. No, my lord. Extension of time to file, my lord. My lord, permission to file, my lord.
extension or
Additional written statement to their counterclaim. No time was fixed, my lord knows. It's always a discretion of the court.
No. Under the commercial code, sir.
No.
Well, then,
Commercial
I do
code
not
বলা
want to
আছে।
get into the controversy right now, but my instructions are the application has not really been served on us. But my lord, let them serve it in the course of today, but my lord will give us directions for filing
Yes,
affidavits.
that's what I'm saying.
So,
That's
it
exactly
is
what I've said.
It is served. You are accepting this, then I am passing it.
Yes, we will accept it.
So appearing for the plaintiff, so appearing for the defendant. The plaintiff has served the copy of the present application along with the document to the learned counsel for the defendant in the open court today. And the learned advocate for the defendant has accepted the service. In view of the above, let affidavit in opposition be filed within 2 weeks.
2 weeks.
Yes, Lord.
Reply, if any, there to be filed within a week thereafter.
My lord, so deeply obliged.
This is the matter on 2nd May.
My lord.
Grateful, man.
Grateful.
Next. इसका कागज कहाँ निकल गया? फेंक दिया कोई।
Your Lordship, item number 8, Your Lordship, I appear on behalf of the petitioner, Your Lordship. Your Lordship.
Judgment on admission. Again, the respond number 1, 14,93,000. 18%. Yes. Have you saw the copy?
Yes, Your Lordship, affidavit of service, Your Lordship. Your Lordship, in this matter, I'm being led by Mr. Kumarjit Banerjee, Your Lordship. I seek for a short passover, Your Lordship. Short passover, Your Lordship.
Also,
Oblige, Your Lordship.
My injunction application.
what is the prayer?
Your Lordship, prayer to secure the amount. Your Lordship, may I just in short
Who is
indicate
for the
the
other side?
facts? Lordship, I am moving it ex parte, admitted sum. Your Lordship, I am the distributor of the pro forma respondent, and the defendant number 1 is the company concerned to which I am sold goods. Lordship will kindly come to page 15. Network Bulls is the defendant number 1. They write to the
Page
pro forma
15.
page 15, Your Lordship, Annexure B. Lordship, Network Bulls, this is the defendant number 1. From Harish Pathak to Mukherjee Tarun, which is Honeywell, which is the company of which I am a distributor, pro forma defendant. Lordship, dear Mr. Tarun, referring to our discussion, please share the details below. 1, please share the distributor details. Lordship, may kindly turn over page 16. Lordship, last portion, your Lordship will find the details of the plaintiff is given, Lloyd's Mercantile Corporation. So, Lordship, the pro forma defendant gives the details of the distributor from which the defendant number 1.
Where?
Lordship, page 16, bottom.
As discussed in reply by blue color.
Yes, Your Lordship. Please share distributor details like name and GST details. Your Lordship will find Lloyd's Mercantile Corporation. That is the plaintiff herein.
When?
Lordship, pursuant after the details were given to the defendant number 1, they place a purchase order. Page 17. Your Lordship will find the purchase order issued by the defendant number 1 on the plaintiff. Page 17, Network Bulls Technologies to Lloyd's Mercantile Corporation. That is the plaintiff.
What is the name?
Lordship.
What is the name of the plaintiff?
Your Lordship, Lloyd's Mercantile.
Mercantile.
So a purchase order was placed on me.
Who has placed the purchase order? Network Bulls.
On Network Bulls, Your Lordship, on 27th of June 2022 to Lloyd's Mercantile.
Shipping details is there. Network Bulls, yes.
Lordship, after this purchase order, there were tax invoices raised. Your Lordship will find it at page 27.
Yes.
Your Lordship will find the plaintiff's name at the left-hand top corner, Lloyd's Mercantile. Consignee shipped to...
This is your invoice.
Yes, Your Lordship. These are my tax invoices.
Correct.
Consignee shipped to Network Bulls Technology. That is defendant number 1. Your Lordship, in the right-hand side, Your Lordship will find mode or terms of payment right below the date.
dated 6 July 2022. Your lordship will find on the right hand top corner, and right below that box, there's a box mode or terms of payment 7 days. Your lordship, so the time within which the payment was to be made was 7 days. Your lordship, at the very bottom, your lordship will find that there is an interest clause as well. Please pay by account pay checks in our name only. Payment to the parties will not be recognized. 24% interest will be charged on all overdues. Which have been micro prints at the bottom.
Yes.
So your lordship, interest was also agreed upon that 24% interest will be charged if there is an overdue. So all the tax invoices contain a similar clause. Thereafter, your lordship, from page 30 onwards, your lordship will find the follow-up emails asking for payments. Page 30, email dated 27th of December 2022. This is from Honeywell, that is the pro forma defendant, to Network Bulls. And your lordship will find that I am also marked a copy. Lloyds Mercantile Corporation, the last addressee.
No, who has given this notice?
Your lordship, the pro forma defendant of which I am a distributor. Since the defendant number 1, your lordship, had come through the pro forma defendant of which I am a distributor. Your lordship, may I just explain in short? Honeywell is a company which manufactures cable. I am a distributor of Honeywell. So the defendant number 1 had approached Honeywell asking for goods. Honeywell said, please contact our distributor, gave my details, and thereafter they issued a purchase order on me.
Who has issued Network?
Network Bulls, the defendant number 1, had issued purchase orders on me, the plaintiff. The plaintiff thereafter raised tax invoices, and also thereafter these follow-ups were made for payment.
So now you are claiming against the defendant number 1 on.
Defendant number 1 only, your lordship. Your lordship, here, your lordship will find, dear sir, page 30. Please release the outstanding payment of Lloyds Mercantile. Ledger is attached. Whereas, last line, your lordship, now please release our outstanding payment of us. Now thereafter, your lordship, page 35, their admission. So these are the follow-ups, your lordship. All the emails are annexed.
35.
Page 35, 27th of July 2022. From one Manish Kumar Yadav of Network Bulls. That is the defendant number 1. He writes, Dear Tarunji, as discussed, we have yet to receive payment from the client, but we are chasing them constantly. Kindly allow us some time. We will clear your overdue payment very soon. So they admit that the money is due and payable to the plaintiff.
Then,
your lordship, thereafter, since they were unable to make payment, your lordship, over telephonic discussion, it was agreed that since they are not able to make payment, they will return the goods. So your lordship, may kindly take up page 36, 10th of February 2023. Lordship, this is an email by the plaintiff to the defendant. Dear sir, refer telephonic discussion with Mr. Such and Such. Invoice numbers are given. So please let us know the address from where we can take back the full materials along with contact person name and phone number who will issue the necessary challan and way bill.
so you are
Please.
ready to take back the...
Yes, your lordship. I was even ready to take back the materials. Please return the materials. Since they were unable to pay, your lordship, I said, very well, you return the materials. Lordship, page 37, February 13, 2023, email. Email by Network Bulls, that is the defendant number 1, to the plaintiff, sharing the details. Your lordship will find, with reference to the below mail, please find below the address details. So they give the details from where I can collect the goods.
Correct.
They also give the contact person details, Manish Yadav, contact number such and such. Now, when I contact such person, your lordship, this person does not picks up my call. So, your lordship, I again issue an email, page 38, 9th of March 2023.
Yes. Then, what is
Your lordship, that email in bold last line, Mr. Manish is not receiving calls from the past 3 weeks. Please return the materials. I again request them to return the materials. Your lordship, page 39, 10th March 2023. Manish Kumar Yadav, the representative of the defendant number 1, writes to me, as per our discussion, I am traveling to Kolkata next week and will inform you about the pickup of materials of 1-2 days before. So they say that they will inform me about the pickup, but thereafter again, your lordship, nothing. They have neither returned the materials nor made any payment to me. So I issue a legal notice, which your lordship will find at page 41, 1st July 2023, demanding payment. Your lordship will find the details of the amount. The principal amount At page 42, the principal amount of invoice is 16.5 lakhs. With interest, it comes to 22 lakhs and odd, calculated at the rate 24% per annum. Lordship, the service of this legal notice, your Lordship will find from page 44. It was sent by way of an email.
What was the reply?
No reply received, your Lordship. I file a pre-institution mediation application before the Legal Services Committee. They did not appear and a non-starter report was issued. Page 45.
So what do you want now?
Lordship, I am praying for securing of this amount because it is an admitted due. They have, in fact, not just offered, they've admitted that this money is due. They wanted some time to pay, and thereafter, since they were unable to pay, they offered me to take the materials back, to which I was agreeable. I was following them up that please return the materials. That also they do not do. They do not reply to the legal notice. They do not appear in the mediation. So I was asking for press C. Your Lordship will find the calculations in paragraph 16 of my application. Since the interest is also admitted, since the tax invoice clearly stipulated 24% per annum.
Yes. So for the plaintiff has filed the present application being GA Com 1 of 2024, praying for interim order. Praying for interim order. The as per the discussion between the plaintiff and the defendant number 1, the defendant number 1 has placed the order. Accordingly, the plaintiff has supplied the materials, and after supply of the materials, the plaintiff has defendant has placed the purchase order. What is placed the purchase order on 27th June 2022 to the plaintiff, and accordingly the plaintiff had supplied the said materials as per the purchase order. After the supply of the purchase order, supply of the materials, the plaintiff has raised the invoices, tax invoices, total amounting to rupees 14,58,310.
Lordship 16,50,892. Lordship, there are 3 invoices. Lordship, the total comes to 16,50,892.
16 lakhs.
50,000. Your Lordship will find it at paragraph 16.
16,50,892. For the plaintiff further submit that in the tax invoice, it is also mentioned that if the payment is not paid in due date, 24% interest will be charged. In spite of receipt of the tax invoices, the defendant has not paid the said amount. Thereafter, several correspondences were made by the plaintiff, wherein the defendant, by an email dated 27 July 2022, has admitted the claim of the plaintiff and prayed for some time to pay the said amount. In spite of the admission, the plaintiff and the defendant failed to pay the amount, and accordingly, the plaintiff had requested to return the goods supplied by the plaintiff, but Though several correspondences were made, but neither payment was made nor the material was returned to the plaintiff. Materials were returned to the plaintiff. Finding no other alternative, the plaintiff had issued a legal notice calling upon the defendant to pay the amount of rupees 16,50,892 along with the interest at the rate of 24%. Though the notices were served upon the defendant, but no reply has been served. Subsequently, before filing of the suit, the plaintiff has invoked the pre-mediation process, but in the said mediation process also the defendant has not appeared in spite of the notice, and accordingly non-starter report has been filed. As the defendant has neither paid the amount nor the materials have been returned, nor has come forward for settlement of the dispute, accordingly the plaintiff has filed the present suit. The plaintiff says that the plaintiff is entitled to get the principal amount of rupees 16,50,892 and as well as interest at the rate of 24% per annum, total amounting to rupees 22,47,378 as on date. Plaintiff says that there is every apprehension that the defendants will close their business and the plaintiff will not be able to execute the order passed by this execute the decree if this court pass a decree. Will not be in a position to execute the decree in case this court pass the decree in favor of the plaintiff, unless such prays for a direction upon the defendant to secure the amount of rupees 22,47,378 before the registrar of this court till the disposal of the suit. Consider the submission made by the counsel for the plaintiff, peruse the document. It is fine from the document. The claim of the plaintiff has been admitted by the defendant but has not paid the amount. Accordingly, the defendant number 1 is directed to deposit an amount of rupees 22,47,378 with the registrar original side of this court within a week. Where is the defendant's address? Outside Delhi. Within 2 weeks.
Is located in Midnapur.
Within 2 weeks from date. Within 2 weeks from date, and if the defendant deposits the said amount, the registrar, original side is directed to keep the said amount in the fixed interest bearing fixed deposit in the name of the registrar or the site. Next, the plaintiff is directed to serve the copy of this order along with this application, documents, and the copy of the plaint to the defendant, and to file affidavit of service returnable on the returnable date. Let the matter appear on 10th of May 2022.
Grateful, Your Lordship. Obliged.
Yes.
My lord, action for infringement and passing off and infringement of copyright. My lord, I'm moving ex parte. My lord, I'm just telling your lordship why. My lord, your lordship need not be troubled with the papers for 1 minute. I'll just give your lordship the background. My lord, your lordship must have heard of the PhonePe. But PhonePe, it's a form of payment using UPI. My lord, it's popular across the country. We are the largest. My lord, sales turnover, all of that is huge. Not registered trademarks, including wordmark. Now, Lord, as far as goodwill and reputation and sales is concerned and advertisements, Lord, it's more than Lord, very, very large companies. I'll show your lordship those figures. Now, What the defendant has done is, my lord, he has come up with something which will surprise your lordship why one would want to choose a name like PhonePe for, my lord, snacks, my lord, chips. So, my lord, those packets of chips, now your lordship knows, my lord, under the law as we know it, my lord, earlier, my lord, in the 1940s, there was a theory that infringement and passing off can be only if the products or the services are the same. But not that not theory has been exploded, not in India first in the 60s and thereafter abroad. And my lord, our Calcutta special bench has also recognized it, that common field of activity is not necessary anymore. My lord, I'll be asking for an injunction, and my lord, I'll be asking for, my lord, special officer also to, my lord, take inventory of those packets of chips. Otherwise, your lordship knows, my lord, they flood the market with it. Not the injunction will be very difficult to, my lord, implement. Not this is the situation. Now, my lord, may I show your lordship? My lord, a few things. First, not my registered marks. Not starts at page 68 onwards. Not
Page
64 onwards. Not page 64 onwards. Then, my lord, if your lordship turns the page, page 66, even not this pay logo in Hindi, this is registered.
This is also copied.
But this also is being copied.
So this is your mark.
But page 64, phone pay.
Correct.
Then but page 66 is also pay, the pay logo. Then, my lord, your lordship turns to page 68. I also have a word mark. So it doesn't matter how it's written, but he's also, my lord, copying the style of writing that I'll show your lordship presently. And, my lord, there are more registrations at page 70 and 72 and 74. So there are more registrations. I won't trouble your lordship. My lord, there's a whole number of, my lord, registrations. Now, my lord, if your lordship also turns to page 82, that is registration under the Copyright Act. So the style of writing, PhonePe and pay, both are, my lord, registered. Certificate is at 82. What is not protected is at 83. So the artistic work, my lord, is mine. Then, my lord, 84, your lordship will find pay. That is also registered in my favor. Now, my lord, the defendant, what he is doing is, you have the packets. Now, my lord, if your lordship will keep it along with my registration certificate, my lord.
No, 83 pay, phone pay, and 85 is pay.
Yes, ma'am.
So pay,
That's
phone
copyright.
pay is the similar, and the pay is the different.
Yes, yes, yes. Now, my lord, please see how the defendant is using it. Not very tempting.
That's what.
Mr. Ghosh was trying to not bribe me.
Yes.
Lord, please compare this with my registered mark at page 64 first. Lord, please see. Lord, my capital P, it could have been one word, phone pay. Capital P. Lord, also please see the Hindi pay on top.
Yes.
Please cover it, not copied it in its entirety. Right? Absolute not blatant copy. Lord, not so two things here. Lord, number one, Lord,
Can I go out for the time being?
Blood, two things here, Blood. Let me be frank about it. Frankly, Blood, I don't know who would actually not eat these chips, but not be that as it may, Blood. Blood, the point over here is more than deception, confusion. Please also understand this. Blood, it leads to dilution. But my mark will be diluted because people will start.
Because PhonePe is also selling the chips.
Maybe not one can use PhonePe to buy chips, so people will think, look, I'm in the business of selling chips. It will dilute my mark, Blood. There's no doubt about it. Now, Blood, just to Blood, show off a little, Blood, I would call it showing off. Now, Blood, if your lordship, Blood, please turns to Blood. Blood, please turns to Blood, page 9, Blood. But turnover figures are given. And if your lordship turns to Blood, that these are huge figures, Blood. And even if your lordship sees the advertisement expenses, Blood, 35,323 lakhs, Blood, which I don't know what it works, 353 crores in a year. So, my lord, these are huge expenditures. But I am number one in the market, my lord, for these kinds of things. Lord, sponsors of the Lord World Cup, IPL, all of that, Lord, we spend a lot of money, Lord, in doing this. Now, my lord, for this mark to be diluted, Lord, your lordship will also see, Lord, two other things here. Lord, please see page 3 once, Lord.
Page 3.
Page 3, para 4. And if your lordship turns the page, your lordship will see that, my lord, 6140.97 million transactions have been done through it at page 4 of a value of 9,000 crores in February alone, in 1 month. And my lord, I've given the supporting data. So, my lord, that's 9 lakh crores. My lord, it's not a small amount. My lord. So, my lord, these are large figures one is talking about, huge goodwill and reputation not involved. Now,
I'm the top user.
yes. Now, my lord, I'm also number one in the market. That your lordship will find the data as annexed at page 53. But these are the UPI statistics, and your lordship will find
Page 53.
but right page 53. Your lordship will find that within the UPI system, I'm not top. Number one is not PhonePe. After that is Google Pay, and then Paytm Bank, then Axis, etc.
PhonePe is the number 1.
Yes, PhonePe is number 1. Your lordship will find the volume given, not 6140.97 million.
Correct.
And below that is not Google Pay. Google Pay is less than that. But of course, I have very little idea. I've never used either of them. But Mr. Ghosh here promises to make a large transfer to me using Google Pay today, Lord. Now, but in these circumstances, Lord, 3 things only I am not say. Number 1, passing off, not blatant copy. Not number 2, there can't be any possible reason for him to adopt not the same mark and write it in exactly the same way, other than to trade on my goodwill and reputation. Number 3, this will be infringement within the meaning of the Trademark Act. I'm covered squarely by 29(4). If I may, trouble your lordship once with 29(4). Now, your lordship knows 29(1) deals with a situation where both goods are in the same class. But as your lordship knows, under the new Trademark Act, these categories were expanded. Earlier, it was only 29(1).
Correct.
Now, please see 29(4). A registered trademark is infringed by a person who, not being a registered proprietor, or person using by way of permitted use, uses in the course of trade a mark which is identical with or similar to the registered mark, not which is satisfied in this case, and is used in relation to goods or services which are not similar, for those to which the trademark is registered. I fall within that. And now this is the third condition which I have to show your lordship. The registered trademark has reputation in India, and use of the mark without due cause takes unfair advantage of or is detrimental to the distinctive character or repute of the registered mark. So, this is the concept of dilution which has been brought into the Trademark Act. So, for this, the courts have held, including the Supreme Court, what I need to show is I have a reputation in India. I've showed your lordship, I am number 1.
Yes.
And, number 1. Number 2, I've showed your lordship, the huge volume of transactions done through this. So, I fall within C, in view of that, your lordship will also find something strange here. If your lordship compares it with 29(2). Under 29(2), there is a requirement of showing that it is likely to cause confusion. Under 29(4), there is no such requirement. No requirement to show confusion. It's good enough if I have a reputation, because it is going to be detrimental to the distinctive character of my goods.
But how you will be affected?
My lord?
How you will be affected?
My trademark is affected, because someone else is using it. Let's take an example. Let's take an example. Let us say in every street corner, my lord, someone opens up a chai shop called PhonePe, not a slipper shop called PhonePe, nothing to do with financial businesses, completely, my lord, in different line of business. Lord, it leads to something which is called dilution, where, my lord, everyone then says, I'm free to use it. Lord, tomorrow, let's say if he's permitted to use this, tomorrow he may expand his sphere of operations. He may start taking payments, my lord, on UPI using PhonePe. Now, what will the consumer think? He's purchasing directly from PhonePe. Number 3, let us say someone falls ill, not eating this product. But people will think it's a PhonePe product, my product. So, this is what the concept of dilution is, where even without there being actual passing off, if any ill effect is caused to my mark because others are using it, that is known as concept of dilution. It brings down the value of my trademark. And this is the concept behind 29 form, Lord.
Yes.
But I won't trouble your lordship with judgments. There are judgments not on this area. This is an absolutely clean case. That's why I'm not troubling your lordship. But the only other hurdle is, I'm moving ex parte. I've showed your lordship in another matter, Lakshmikant Patel's case. In these matters, it is not usual to seek a ex parte order of injunction, and once a prima facie case is made out, your lordship is aware, injunction followed by receiver,
That
is
is only
regular.
receiver at this stage.
Only to go make an inventory so they can't get rid of it. May I just give your lordship Lakshmikant Patel's case, if I may just read from para 14. What I want. Para 13, the first line, in an action for passing off, it is usual, rather essential, to seek an injunction, temporary or ad interim. Then, principles, etc., etc. And then, my lord, if your lordship turns the page, my lord, turns the page, your lordship will find the third line from the top. Once a case of passing off is made out, the practice is generally to grant a prompt ex parte injunction followed by appointment of local commissioner.
Yes.
Now, my lord, here there can be no doubt it's more than a prima facie case of passing off. About that, there is no doubt. The Supreme Court says, it's the practice to grant a prompt ex parte order of injunction followed by commissioner in these matters. That is the situation. If your lordship is not inclined to appoint a special officer, my submission would be there is at least one place which he needs to go to. If your lordship takes the cause title, my lord, the defendant number 1, carries on business from Shatopati, Malopara, Purvo, Kadgachia, Bardhaman. That is where his factory is. If he goes and makes an inventory, I'm not saying that the goods are seized or destroyed, that your lordship will decide once they come. But at least what amount is there. So the market is not flooded with this. Because the usual tendency is injunction passed, and then they go and sell it in the villages or places where I can't detect. Your lordship knows it's very difficult to detect because they will say it's already been sent to the shops before.
Correct.
So that's why it's essential that an inventory once be made.
Yes.
One thing I forgot to add, like I said, passing of infringement and infringement under the Copyright Act, I have a registered copy. So the prayers are also framed that way. Prayers are also framed that way. If your lordship please takes the prayers once. Prayer A is wide, but prayer B was not infringement. Prayer C, if your lordship sees, is infringement of copyright. And D is passing off. E is special officer. But prayer A would be wide enough to cover B, C, D in a way.
A is the main.
Yes.
A is the main.
Yes. The reason I understand the reason these separate prayers are framed is sometimes a court may be inclined to say it's only copyright infringement, it's not passing off. That's why the prayers are broken up. But A would be not good enough for the time being.
Yes, that's all.
No, those are. I'm open to all UPI payments by আমি এখনো বলছি তোমার কাজটা করে দিচ্ছি
The plaintiff has filed the present application being GA-COM 1 of 2024, praying for ad interim injunction as well as for appointment of a special officer for appointment of a special officer for taking in for making inventory of the product of the defendant. And it says that the defendant and the plaintiff is having the registered mark PhonePe, this one, page 64, as well as pay. Then PhonePe and pay, and also the word mark PhonePe. 68, 64, 66, and 68. Which the mark of the plaintiff has registered as 83 and 85. Correct? The plaintiff says that the plaintiff is having the number one business in his category, and as on February 2024, the plaintiff is having the transaction of 6140.97 million transactions valued at 9,67,467.18 crores. The the plaintiff came to know that the defendant is selling the chips of Mr. A. Niket, but in the chips packet, the defendant is using the trademark of the plaintiff, Pay and PhonePe. Pay and PhonePe. It is there, page 84 and 80. Pay 78 and PhonePe. Take the counsel for the plaintiff has relied upon several documents, wherein it reveals that the plaintiff is having the trademark of Pay as well as PhonePe, and having good reputation in the market. Having good reputation on the full stop. The counsel for the plaintiff submits that due to the wrongful and illegal action of the respondent, the plaintiff is suffering serious loss and damages, which continue to cause loss and damages of the petitioner. The petitioner says that, the plaintiff says that using the trademark of the plaintiff as Pay as well as PhonePe, the defendant is getting benefit for which the plaintiff is suffering damages in the business. The plaintiff is relied upon the judgment reported in 2002, Volume 3, SCC 65, and submits that in an action of the passing of, it is the usual, rather essential to seek an injunction, temporary or ad interim. The principle for grant of the injunction are the same as in the case of any other actions. Any other action. The plaintiff submits that it is settled law that once a case of passing off is made out, the practice is generally to grant a prompt ex parte injunction followed by appointment of local commissioner if necessary. In the present case, it is found from the record that the plaintiff is having the registered trademark as well as the word mark, and the product which the plaintiff has produced reveals that though the defendant has selling the chips business, but in the packet the defendant is using the word mark of the and the trademark of the plaintiff as pay as well as phone pay in the packet of the chips. This court find that the plaintiff has made out a good prima facie case, balance of convenience and inconvenience in favor of the plaintiff with regard to passing off, infringement as well as copyright against the defendant. As per the averment made by the plaintiff came to know about the selling of the set.
Para 21.
Chips by the defendant in the month of March 2024, and immediately the plaintiff has filed the present suit. In view of the above, this court finds that the plaintiff is entitled to get ad interim injunction in terms of prayer A of the present application by restraining the respondent and each of them, their owners, officers, partners, servants, agent, assigns, successors, and legal representative, stockists, distributors, and anyone claiming through or under them from using the packet of the chips of the defendant by using the name of and by using the word mark and trademark of the plaintiff pay as well as phone pay. This court find that the defendant is selling the said product in the open market, and accordingly it is necessary to safeguard the interest of the defendant, and a special officer is urgently plaintiff, and a special officer is also required to be appointed to make the inventory of the said product of the defendant. Accordingly, who is about 7 years of the practice?
En route.
You are how many years of practice?
3.
Huh?
3 years.
Okay.
Pandey here.
Can
I
you
think
do?
he can go, Mlad. I think he can go.
So and so.
But your lordship will only provide that not he will be entitled to seek police protection if required.
So and so.
Junior.
Give the name, number. Give the name and number of is appointed as special officer to make inventory of the product of the defendant from its godown and to submit before this court. Full stop. It is made clear that if the special officer required, he can make a request to the concerned police station, and if the police station received any request from the special officer, the concerned police officer shall provide necessary police protection to the special officer for making inventory from the godown and shop of the defendant at
Blood,
the address
not factory.
factory of the
Blood,
where is the factory?
blood address not is
Factory
blood,
of the defendant number 1 at
not the first address in the
Satapati. In this regard,
But just one thing, but your lordship has said will provide us assistance for making inventory. If your lordship just adds, will provide assistance in entering the premises, the factory premises of the defendant number. And
police protection by allowing the special officer to enter into the premises / factory of the defendant and to make inventory at the address mentioned below. Okay, the identity model passed by this court is continued till 10th of May 2024. The plaintiff
the lordship has fixed a remuneration for the
the plaintiff is directed to the remuneration of the special officer is fixed at rupees 50,000 for the present. For the present, the special officer is directed to file the report on the written verdict. The plaintiff is directed to serve the copy of this application along with documents and the copy of the plaint to the defendant and to file affidavit of service on the next date.
Obliged. Okay.
Take back this.
I would have been very happy to, but some of them who have consumed it said it's not very nice.
Lord, I am opposing this. Lord, GA number.
It's my application.
GA number 5.
Yes.
I am only seeking an accommodation today. Mr. Thakkar is leading me. I'm the petitioner. This is my petition. 5 minutes.
This is an application for disclosing additional documents. My lord, he wanted to disclose it for 2 matters. One is the GA, which has already been disposed of, and the other matter for the written statement. Now, my lord, kindly, I cannot without application may have been disposed of, but the written statement is there. My lord, my primary objection is that all these documents were available to him before filing of the written statement for January.
You want to file?
Yes, kindly.
Mr. Ghoshe's leave, may I be permitted to appear online? And just only add one thing, the defense, your lordship has already, their defense have been struck off. Now, your lordship has already rejected their written statement. They were only to cross-examine. So, today, as of this day, GA5 has become infructuous.
My written statement is on record. I am only beseeching
because that has already been
wants to file a response to my application. Let him file a response and we can come back.
It is yesterday's.
No, but that is GA number 6, the next matter. This is a fresh matter. Yes, this is
connected with the same suit.
No, you connected with the same suit.
Yes.
GA7 was disposed of yesterday.
Dismissed. Disposed of.
Yes. This is GA5.
So what you will what
my learned friend is trying to say that although his written statement is on record, but your lordship has by way of GA3 has struck off his details.
Yesterday's order.
I am only beseeching Mr. Thakkar is leading me in this matter. He is
for
before
that only. For that only, I did not object.
He is on before the Honorable Apex Court.
Yesterday also we stole a march over him. That's why I did not.
Okay.
All that I want him to let him file his
reply. And he will be available.
Next week.
No reply.
But no reply is required.
As per the prayer made by the counsel for the petitioner defendant, let the matter appear on 18th.
No, not the yes.
18th April. Petitioner defendant.
Petition defendant.
Well, at GA6, the next matter, already your lordship has passed an order yesterday.
GA6 already disposed of.
Yes.
No, it's fixed on the 26th.
23rd.
Not this.
Well, at 18th, I have some difficulty. Can it be 19th? The GA5.
19th?
Yes, madam.
Then it may take on 22nd.
22nd.
22nd. Take the 22nd.
Very well, my lord. Grateful.
Grateful.
Lordship, this is my application. Lordship, this is my application under Order 7, Rule 11. Lordship, this is
I would be seeking directions for filing affidavit, my lord.
Order 7, Rule 11.
Lordship.
Let they file affidavit.
Lord, well, Lordship will give a slightly longer date because my client's son is very seriously ill, suffering from liver cirrhosis.
Your all clients are like this?
No, that was my brother, my lord. He was seriously ill. My lord, he died. He is no more.
It is a purely point of law.
Point of law, definitely, but I have to.
Thank you very much.
I'm not asking for long, too much.
Census
3
and
weeks
suffering
time.
for the
only.
plaintiff, census and suffering for the defendant. Plaintiff has filed an application being GA Form 4 of 2024, praying for rejection of the plaintiff. And the defendant has filed an application praying for rejection of the plaintiff. Full stop. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks.
3 weeks.
Within 3 weeks, reply if any there to file within 2 weeks or 1 week.
Actually, 1 week thereafter.
Within 1 week, let the matter appear on 14th May.
My lord, I have also filed a GA, my lord. To that, he has filed an affidavit in opposition. Lord, she will give me 3 weeks time to file reply.
It's listed today.
It is
Lordship,
listed.
it's not appearing. I think only GA4 is appearing. That's my application.
GA4 is appearing.
My
I
learned
shall
friend-
file it. License. Well, unfortunate circumstances sometimes arises, my lord.
Okay, no.
Lord, my brother, he was sick for 7 months in the ICU.
Unfortunate.
And he was at a very young age, my lord, he died. He was only 49 and my lord, in fact, he was the advocate and record in all the matters.
Yeah,
That
that's
is
why
why,
I
my
find
lord, all the difficulties had arisen.
That's why I find it.
Yes.
Every matters.
I'm grateful. Your Lordship.
Yes.
This is, my lord, my application for
I'm the
dismissal of the suit as against, my lord, the defendant number 2. In the alternative for deletion of the name of the defendant number 2 from the array of the parties.
Yes. Who is appearing?
My lord,
and I'm the plaintiff.
affidavits have been exchanged between the
For
parties.
the
my lord.
defendant number 2.
I'm for the defendant number 2.
So, but is you are having objection?
I'm objecting to that because according to me he's a proper party. May not be a necessary party, but a proper party.
Okay. So, you are ready?
So affidavits have been exchanged, my lord. We are
Ready?
right. Well, my lord will find the plaint at page 9 of my application.
Yes.
I'm for the defendant number 2. And my lord will see first, my lord, the reliefs which have been claimed. That's at page 58.
Defendant number 2.
Yes.
Defendant number 2. Who is the defendant number
Defendant number 2, my lord, is SGS India Private Limited. Wash.
SGS India Private Limited. Yes. And what is the description?
Yes.
Providing service of inspection, testing, verification.
Yes. Now the pleadings in respect of, my lord will first, my lord, see the prayers ones, the reliefs claim.
Where is the prayer?
Page 58. Running page 58, my lord, the internal page 44 of the plaint.
58.
Yes, of the
Yes,
application.
Yes.
Decree for recovery of money against defendant number 1. Decree against mandatory injunction for taking delivery of the items against defendant number 1 and interest. All reliefs only against the defendant number 1. The suit in a nutshell is that, my lord, that there was a contract between the plaintiff and the defendant number 1 for pursuant to which, my lord, the plaintiff had manufactured certain couplers. These are used for railway tracks for supplying to Tanzania Railways. Now these couplers, according to the plaintiff, were manufactured. Some, my lord, delivery taken, a part of which delivery not taken. Now they're seeking a decree for money in respect of the part which delivery they have not been taken by the defendant number 1, and also on a direction upon the defendant number 1 to make payment to take delivery also for that. Now where does the defendant number 2 come in? Now in terms of the contract, the defendant number 2, that is my client, was appointed as the testing agency.
Correct.
Testing agency for the purpose of carrying out testing of the materials. Now, there is no dispute in the plane that I have not carried out testing, or there is any dispute as to my test reports or test certificates.
You are connected with the rights, no?
No, nothing. I've absolutely not. I've only carried out testing whenever, as and when they have manufactured, and I've given my test reports. Now, their case is that despite of my test reports, I have my certifications as to the equipment. Defendant number 1 has not taken delivery or lifted the materials. So, apropos this is in nutshell what is the case about in relation to the defendant number 2. My lord will see the pleading on the basis of which I have been impleaded, or I have been sought to be pleaded as a party. Paragraph 77 of the plaint, which is, my lord, at page 55.
Yes.
The plaintiff submits that inasmuch as the defendant number 1 took delivery of the goods of the plaintiff on the basis of the report issued by the defendant number 2, the presence of the defendant number 2 is crucial for adjudication of the present dispute. As such, the defendant number 2 is a proper and necessary party to the present proceeding. Now, if they have taken delivery on the basis of my reports,
yes,
or on what basis why should I be dragged into a litigation as one of the defendants when there is no claim against me? Because it's like I'm being forced to contest the proceeding or be party to the proceeding, spend money on litigation. And even I had to file a written statement also without prejudice to my rights, because I've not been made as a pro forma defendant also. I've been made as one of the defendants. And here, if test certificates are all on record, it is not the case that there is any dispute as to the test certificates.
Correct.
And yes, some other, my lord, pleadings in respect of the defendant number 2, my lord, if I may show, my lord, paragraph, my lord, will see, my lord, paragraph 3, page 17.
Yes.
The defendant number 2 is, there is an inspecting agency for inspecting, testing, verification, paragraph 3. Then paragraph 9 at page 20. Paragraph 9, my lord, at 21, part of paragraph 9, E. Inspection by so-and-so, SJS being the defendant number 2 here, the plaintiff. So that is one of the terms that I'll be inspecting. Yes. Paragraph, then, my lord, will, if I may, my lord, show paragraph 39 at page 36.
Yes.
Yes. 5th line, my lord. 5th line, my lord, from the top. Or I'll just place the whole paragraph. By an email dated such and such, the defendant number 1 inter alia requested the defendant number 2 to send its most experienced inspectors having good knowledge of couplers to inspect the couplers manufactured by the plaintiff. Such a request was made by the defendant number 1 to ensure the couplers were manufactured by the plaintiff were in accordance with drawing and so and so. That was approved by the defendant number 1's client. Is Tanzania Railways. The defendant number 1 had forwarded the said email to the plaintiff. Then para 40, the defendant number 2 on February 17, 2020 caused inspection of the first lot of 50 sets of couplers at the plaintiff's plant, the jurisdiction. The defendant number 2 handed over a copy of the inspection report to the plaintiff. The plaintiff, by its email dated 17 February 2020 inter alia, forwarded the inspection report to defendant number 1 and requested the said defendant to provide details of the shipping agent. The plaintiff further informed the defendant number 1 that dimensions of the containers required for transportation of the said couplers. Then, my lord, the photocopy of the was annexed. Thereafter, my lord, paragraph. Yes. In fact, my lord, I have my junior rightly points out, my lord, para 38, my lord, I also possibly should have shown page 35. Ultimately on 31st January 2020, the plaintiff received an email from defendant number 1. Para 38, my lord. I had shown, my lord, 39 and 40, but I also possibly should have shown, my lord, para 38. Jurisdiction, wherefrom it appeared that the defendant number 1 had appointed the defendant number 2 as the inspecting agents for inspection of the finished goods under purchase order dated 18 June 2019 in place and stead of rights. So and so.
That's why I'm asking whether you are the party to the right, connected with the rights or not, because inspection.
Oh, I'm sorry, I couldn't actually follow, my lord. It was, yes, earlier rights, generally rights was the inspecting agency. So SGS, it's a private organization. Now it also carries out inspections.
Yes, next.
Now, para 52 also refers to the inspection carried out by the defendant number 2. That's at page 43.
Altogether, you are the inspector agency and you have inspected the prima and then the materials and issued the certificate.
Yes.
And this is the case
Yes, and para 55, 56 also, my lord will
There's
find
no
that
allegation with regard to
there is nothing, no allegation, nothing. Now, in the affidavit in opposition, my lord may take up, my lord, the affidavit of the plaintiff affirmed by one Rajendra Prasad Gupta on 26 July 2023. One paragraph, my lord, I will show. Page 4, para 5E. Yes, I'll also show, my lord, let me first show 5A, the first paragraph, page 3. I state that although no reliefs have been paid against the defendant number 2 in the suit, the defendant number 2 is a proper party to the present proceeding, inasmuch as the cause of action of the present suit is intrinsically connected with the defendant number 2 herein. Now, apropos this, E, page 4. I state that it is true that no reliefs have been paid for as against the defendant number 2 herein, but however, the presence of the defendant number 2 is crucial for proving the fact that they have taken inspection and approved the couplers which were offered for inspection by the plaintiff herein.
Yes.
The question, my lord, I put to myself here, I am an inspecting agency. I have taken inspection. I have given the reports. Inspections, the reports are all on record, which they have relied upon in the plaintiff. Now, for proving the case of the plaintiff, it is for the plaintiff. If there is no dispute regarding the inspection report, my lord, the reports will automatically be proved. I'm not like, there is nobody's case. Even their case is also not that the defendant number 1 has disputed the inspection reports. Even assuming there is a dispute, like, I can't be impeded as a party for forcing me to give evidence in respect of this.
Okay. Any further?
No, these are my submissions.
Madhul, yes, these people are inspecting agencies. My claim is against the defendant number 1, not the defendant number 2. There is no two doubts as to that. But my lord knows that when I have a claim against a person, that person becomes a necessary party. Or if my claim, if the order pass directly affects the party, he becomes a necessary party. But when it comes to a proper party, probably that test is not there, whether he will be directly affected by the reliefs claimed by me or not. So just stating that just because my no reliefs have been claimed against me, that does not make him a non-proper party as well. He may not be a necessary party, but he remains a proper party. May I cite one judgment? 1995, volume 3.
Can you think the otherwise? See, what is your case? Your case is that the material was inspected by the defendant number 2 and they issued the certificate. So there is, as per your case, the material is perfect. There was no defect. Correct. So if you go extremely, so the defendant number 2 would be your witness. To prove the certificate.
The only thing is that, my lord, not all of these goods have been inspected. Some have not been.
Might be.
So the
defendant. It is not the case that he has sent the good materials to the defendant number 2 and the defendant number 2 has inspected the material for some materials and he has not inspected the other material due to which you have suffered the loss.
No.
Or
That is no reliefs against them. No reliefs against them. The only thing is that when it comes to delivery of any goods to basically these are, my lord, couplers. The couplers which bind two compartments of a train together, my lord. Couplers, the dimension of couplers in Indian railways is completely different than that of Tanzanian railways. So if I manufacture couplers couplers with the dimensions and the specifications of Tanzanian railways, my lord, that cannot be sold or utilized in India. So, my lord, when I have manufactured that, and there was a purchase order, they have to, I have to give it to them, and they have to pay me the price. They cannot now say that we will not take delivery after placing the purchase order, because I will not be able to utilize it elsewhere as well.
That's
The-
your case is good with regard to the defendant number 2, subject to. Defendant number 2 is the best witness for your side. Best witness for your side, you can put the certificate, and your certificate can be proved that it has been approved by the defendant number 2, because the plaintiff and defendant number 2 cannot claim the counterclaim against the defendant number 2. Defendant number 1 cannot claim the counterclaim against the defendant number, and he has not made a counterclaim here.
Defendant number 1,
Has not
unfortunately,
made a counterclaim against the defendant number 1, and he cannot.
they have not filed a written statement.
Whatever it may
In
be.
fact, we could not serve them. We have made out an application for service through the embassy that has not yet been successful. We intend to take out an application for substituted service because nothing else is working. Even the embassy could not deliver the summons to them.
Don't think. Yes, what is the citation you are relying upon?
The only thing, the citations I will be relying upon is that what is the test for a proper party, my lord. That is the only.
But here proper party, if that is required, but here the is not a proper. He is the proper witness for you.
My lord.
He's the proper witness for you as per the government also.
My lord will kindly for once take up the plaint. I'll just show a few paragraphs which probably my learned friend has missed.
Yes, show me.
Paragraph. My lord will kindly take up page 42, paragraph 51.
Yes.
The plaintiff states that while the inspection for the balance quantity of 33 sets of couplers was in progress and 24 sets have been duly inspected by the defendant number 2, the plaintiff received an email dated July 15, 2020 from the defendant number 1. The plaintiff was shocked to go through the contents of the said email. In this email, the defendant number 1 inter alia alleged that the TRC couples manufactured by the plaintiff were not fitting on the wagons. So this is contrary to the report of the inspector, who thinks that this will fit. So probably, my lord, subject to correction by my lord, probably the defendant number 2 needs to uphold its report to denude this contention of the defendant number 1.
Not because how he can approve. It is your case to approve the document of
course,
the defendant number 2. Making the defendant number 2 party to the suit, you are going against the defendant number 2.
Of course. I have made a party, but I have not claimed any relief.
See, think it.
I have not claimed any relief, but the presence may be required for complete adjudication. That is the only.
Complete adjudication. You have made out this case. You have made out the case. Your case is totally based on the certificate issued by the defendant number 2. Now the defendant number 1 has made out a case that is not been fitted.
Not been fitted. So they are basically disputing the certificate.
That's why disputing the certificate
of their own agent.
So on reason, then he has to test the certificate, not by you only. You have to prove the certificate. Testing is with the defendant number 1. Yes, this certificate is forged one or not in accordance with law. You are not authority, but that will come later on. Even though if the defendant number 1 takes that plea also, if the defendant number 1 will take that plea also in the written statement, he is not an authorized person. The certificate is not that. So how the defendant number 1, 2 will prove here?
The only thing is the veracity of that certificate or the correctness of that certificate.
So you have to prove.
I have to prove.
So you have to prove from whom? From the defendant number 2? From the defendant number 2 only, not by the other party.
From the documents provided by the defendant number 2. But if the defendant number 2 is present, he'll probably be. If the defendant number 1 later on comes and challenges the veracity of the contents of the certificate, he'll probably be able in a better position to defend his own certificate rather than me.
Think it. You want the adjudication? I will adjudicate here. How do you think? You want to think? You think it.
That I will keep it on any other day.
Think it. Because it will be better for you. It will be the good witness for you to prove the certificate.
Right.
That is
Correct.
turning
And
my
if you
client
made-
hostile will
if
not
you
serve
made
its
the
purpose.
defendant number 2 as a party, it will against
Yes.
go against you.
My client is already turned hostile.
Correct. See that. As per the prayer made by the counsel for the plaintiff, counsel for the defendant number 2 argued the matter and concluded his argument. So, counsel for the plaintiff prays for time. In view of the submission made by the counsel for the plaintiff, let the matter appear on 6th May.
Grateful, my lord. But possibly it has gone down as counsel for defendant number 1. It should be defendant number 2.
Counsel for the defendant number concluded his argument.
Grateful, my lord.
Next.
Plaintiff, my lord, my lord, I'm just waiting for my terms. It has been signed by both the parties. We have also received the check, my lord, no, rather the demand draft, my lord, of 22 lakhs. My lord,
Check is difficult.
we have received the, my lord, the demand draft. That's important, my lord.
Yes.
We're waiting for the terms, my lord. It's going to come in the record.
Pass it.
Short passover, my lord, is going to
Pass it.
Great.
Next.
I'm for the defendant number 1, my lord. And my lord, I appear for the plaintiff in this matter, my lord. Now, my lord, it's a suit, my lord, for goods sold and delivered. My lord, I have taken out an application which is GA1, my lord, seeking for appropriate orders and a judgment upon admission. Now, subsequent to me having taken out this application, the defendant number 1 has come in and filed GA3 seeking for deletion of his name from the array of the parties. So, my lord, similarly placed insofar as the earlier matter is concerned, but perhaps I can demonstrate. Let my learned friend continue with his submissions, because
You are appearing for the plaintiff.
I'm for the defendant number 1, my lord.
Number 1. Who has filed an application? GA1?
GA1 is my application, my lord, for judgment upon admission, and GA3 is their application, so perhaps that needs to be taken up first because it's in the nature of a demur.
GA3.
GA3, my lord.
There is a GA3. Yes. You are the defendant number?
1, my lord.
1. So you want to be deleted
My lord.
from this suit? Yes. Deleted from array. Yes.
My lord, as my learned friend has submitted that the suit is for price of goods sold and delivered. The case of the defendant number 1 is that the goods were sold and delivered to defendant number 5 and 6,
Correct.
and not to me. I am nowhere connected to the transactions which had taken place between the plaintiffs and other defendants.
What is the averments against you in the plaint?
My lord, I am led by Mr. Banerjee in this matter. I will just catch your breath. Besides working on law, we need to work on our fitness, my lord. In fact, Mr. Banerjee has already started taking steps on that. I've been taking for a while. Nothing is working, my lord. My lord, this is my application for deletion of my name from the array of parties. The principal ground on which I'm seeking deletion of my name is the fact that there are no cogent specific
You are
allegations.
seriously opposing?
Yes. Very much, because my primary claim is against the defendant number 1. Primary claim? Yes. Very well. Now, there are no point. The first point is the pleadings and averments taken in the plaint to be true and correct. There are no specific and cogent allegation as against defendant number 1. I'll show that. B, more importantly, the entire transaction document clearly shows that there is no jural relationship whatsoever between the defendant number 1 and the other assailed defendants. Now, if there is no jural relationship, my submission would be such a party, A, does not remain a necessary party on a meaningful reading of the plaint because no relief can be claimed against them, and B, not even a proper party, since the test of proper party is to show there is some legal interest in pleading them, not mere commercial expediency, not merely the fact that they were in the know-how of the transaction. that will render them at best a necessary witness. These are the conspectus of my argument. Allow me to first show your lordships the plaint.
Yes.
After this, your lordship will kindly take the plaint. The plaint is disclosed at page 34 onwards of my application. GA number 3 of 2022-23.
Yes.
Lordship will kindly see. Techful Trading Proprietary Limited Incorporated and applicable laws of Australia. This is really a transaction for procuring Australian scoured wools of various specifications. May I just give a very brief overview of the transaction so that the plaint makes some sense in the context. The entire transaction is for procurement of scoured wools, Australian scoured wools of different specification. There is 20 micron, there is 21 micron. 3 separate orders were placed. It is not in dispute that these wools were not meant for defendant number 1. It was meant for some foreign purchaser. Their case is that defendant number 2, 3, and 4 approached them to place these orders. They acted as brokers, for agent of foreign buyers, placed this order at their behest. They supplied the goods to the foreign merchant buyers, the plaintiff. The transaction documents are accordingly executed. Transaction document does not find even a whisper about the defendant number 1. And these transaction documents includes the bill of lading, which is a document of title. Invoices, I will show all of that. Now the basis, it seems, it appears, there is a vague pleading that defendant numbers 2, 3, 4 were officers of the defendant number 1. And in the past, when the plaintiff has dealt with defendant number 1, defendant number 2, 3, 4 has represented defendant number 1. Now, whether that suffices even to be true and correct, suffices to provide sufficient ground to implead me as a necessary party and or proper party is the question. Now, in this light, your lordship will kindly see the array of parties. Techful, this is the Australian company. The supplier, Universe Textiles Limited. This is the defendant number 1. This is my application. I'm for the defendant number 1.
Yes.
2, Chanchal Khandelwal working for Gain at Universe Textiles. Shiv Sharma working for Gain at Universe Textiles. 4, Ajay Lohia working for Gain at Universe Textiles. 5, 6 are the buyers. Response International LLC and Elite Ventures Limited. One is operating out of Dubai, respondent number 5, and Elite Ventures, Chimchachui, Hong Kong.
Yes.
So these are the buyers. Now, Indoworth is respondent number 7. I'm not concerned with Indoworth. Now, your lordship will kindly take page 37. Your lordship will straight away come to para 4. This is really the genesis of why perhaps defendant number 1 is in the picture. The defendant number 2 is one of the directors of the defendant number 1 company, whereas the defendant numbers 3 and 4 are the main agent of defendant numbers 1 and 2 involved in the daily operations of defendant number 1. Defendant numbers 2, 3, 4 are all working for Gain at the office of defendant number 1 at so-and-so. 5. Defendant number 5 is a company. I'm skipping that paragraph, your lordship, for the purpose of this application. Your lordship will kindly take para 6. The plaintiff and the defendant number 1 represented by defendant number 2. Now, your lordship will kindly note this paragraph. This paragraph does not make a statement as to the present state of affairs pertaining to the transaction at hand. This pleading is pertaining to a general course of business that had transpired between the parties in the past. The plaintiff and the defendant number 1, represented by defendant number 2, had been, they're not saying in the case of this particular transaction they had represented, had been involved in business transactions over a substantial period of time, whereby the plaintiff would be exporting different qualities and varieties of wool to the defendant number 1 at the agreed rate and at the destination prescribed by defendant numbers 1 and 2. Defendant number 3 and 4 were also involved in such negotiation and discussion. Now, Your Lordship, two things. It is evident from this pleading that this pleading does not pertain to the transaction at hand, because this is not a transaction for supply of goods to defendant number 1. Yes, say in the past this was happened, this is how the business has been carried out. And this is innovative, clever drafting. Sometimes in or around February 2020, the defendant number 2 had negotiated. Now, insofar as the pleading pertaining to the transaction at hand is concerned, the pleadings are unequivocal and clear. Sometime in or around February 2020, the defendant number 2 had negotiated to place an order on plaintiff, whereby plaintiff would be required to effect of supply of wool of requisite quality and quantity to different entities as prescribed in defendant number 2. No mention that the defendant number 2 is doing this in capacity of a director or representing the defendant number 1 in any manner whatsoever. Your Lordship will kindly note that. It was also agreed that orders would be placed in the name of different entities across the globe, whereby the defendant number 2 undertook to make payments through defendant number 1 for such supply effected by plaintiff. In fact, the mode of operation agreed to by and between the plaintiff and defendant number 2 can be laid down as follows. These two paragraphs are really the cause of action as to how I'm involved. The defendant number 1 is involved. The defendant number 2 and or his men agents would inform the plaintiff about the requisite specification of wool and the required quantity on behalf of the defendant number 1. This is a general course transaction practice that has been followed, and this relates to 6 and 7, which I showed. The defendant numbers 2 and or his men agent would also specify the name of the purchaser to be recorded in instrument of order confirmation and the invoices issued by the plaintiff. The goods required to be supplied by the plaintiff would be shipped to the desired destination of the defendant number 2, acting through his men agent, whereby the defendant number 1 would make payment for the supplies affected by the plaintiff. Now, I pause here, Your Lordship. The immediate response would be the averments taken to be true and correct seems to suggest that these payments were supposed to be made through defendant number 1. So why is defendant number 1 not a necessary party? Because the payment obligation, it appears from the bare perusal of the pleadings and averments, lies squarely with the defendant number 1. That would be the immediate thrust of the argument on the part of the plaintiff. I appreciate. Now, Your Lordship, to assuage this, because this really, apart from this, if I can quickly, I'm flagging this issue. I'll answer that issue. But before I do that, I'll just quickly show that apart from this, there is really no nexus that has been disclosed in the plaint insofar as defendant number 1 is concerned. Those are confined to these paras.
Yes.
Now, I'll answer that. Now, if Your Lordship quickly takes the other paras, it gets into the transaction, 9, 10 onwards. 2 orders placed at para 10, UN 609, UN 610.
Yes.
Another electronic mail, 11, 12, 13, 14. Your Lordship will note.
What is the prayer against you?
No specific prayer, defendants. And hence it will relate back to my answer to the first. Your Lordship will kindly take the prayers. Now, in the pleadings pertaining to the nature and transaction, the purport of this transaction, there is no mention whatsoever of defendant number 1. The defendant numbers 1 mention is only in respect of the usual course, that I was supposed to be liable, this was on behalf of me, etc. That ultimate payment was to be made by me. Now, your lordship will kindly come to the prayers once. Your lordship has posed that query. Prayer is at page 57, your lordship.
Yes.
Decree for a sum of USD so and so as pleaded in para 42 hereof. Now, at para 42, defendants, no specific reference. A broad brush statement, defendants are liable. In respect of what? That is very important. UN 609, 610, 611. Now, I'm certain if I have missed out to any specific reference to any specific obligation of the defendant number 1 in the transaction at hand, my learned friend will certainly point that out. But my understanding is this is the sum and substance of the cause of action as against me.
Yes.
Defendants liable for UN 609, 610, 611, and it was placed on behalf of defendants, payment to be made by defendant number 1. Para 8, para 6, 7, 8. Now, your lordship will kindly see the transaction document. Now, my question is, I pose this query to myself. Correct. Come. My learned junior very rightly pointed out that I had flagged that somewhat cursorily as a clever drafting. Now, your lordship will kindly take the transaction document, how the order was placed, because that forms the basis of the para number 8. And thereafter, I'll show your lordship the transaction documents as well. Now, your lordship will kindly see page 67. This is a mail by the defendant number 2, your lordship.
Yes.
Now, this is the genesis of the entire transaction, and this forms presumably the basis for the pleading at para 8. This mail is addressed by one Mr. Chanchal Khandelwal, defendant number 2, to Ken Welch. Exports Shiv Sharma, defendant number 3. Dear Ken, we would like to place indent order as below. To be processed in Australia, quality as per our specification. Now, I'll be remiss in not pointing out that the content and purport of this mail is not what is written in para 8. There is no mention that this is being done at the behest of defendant number 1, or the final payment will be made by defendant number 1. Your lordship will kindly take para 8 once.
Yes.
Now, your lordship will kindly bear with me the next couple of pages till 70. The entire course of transaction I'll show pertaining to the first 2 orders.
Yes.
Michael Jang to defendant number 2 and defendant number 3. Hi, thank you for your order, and please find below the order numbers allocated. 609, 610, the subject matter.
Yes.
And would you please confirm with us below the detail for these orders at your earliest convenience? This is very important. I'm grateful to my learned friend for pointing this out. Buyer's name, shipping mark, payment terms, scoured in GWSA or EPR, destination, question mark. Thanks a lot, Michael Jang, for the plaintiff. Now, your lordship will kindly turn that over.
Michael Jack for the plaintiff.
Yes.
Yes.
Then Ken Welch, again, 13 February. Good afternoon, Shiv Chanchal. Today we saw better spec, fleece 19, and broader trend, slightly dearer. Finer, better fleece 10 to 15, AC dearer. The high CVH tender wools were 10 to 15 cheaper. These were mainly finer than 18.5 micron. The better prices remained firm. Low spec, berry 15, AC cheaper. Crossbred sold. Commercial jargon, slightly technical. Managed to complete below so and so. Now, the last couple of orders, your lordship will kindly see 609610. Again, no reference whatsoever. Now, the next mail is of utmost importance, your lordship. Defendant number 2 now informs. What is this order on account of? Dear Michael, please note shipping marks UN 609610, buyer Elite Venture. Payment terms will be TT, but add 40 days later, 40 days interest like CADA. As the docs are not being sent to bank, but on receipt of TT payment directly to us. Now, I pause here for a second, your lordship. No reference insofar as the payment terms are concerned with defendant number 1.
Yes, next.
Next, your lordship, I will skip the balance emails because
The similar.
this is what I
Okay.
just 74, your lordship, one states. This is the final confirmation, schedule, etc. The first, your lordship kindly takes the email below the other. That is a email prior in point of time.
Yes.
Please confirm schedule. Hi Chanchal, defendant number 2. Please confirm the schedule ASAP. 609610 OCL Panama. ETA Kolkata via Port Kelang. Again, complete stoic silence as to involvement of defendant number 1 in the course of transaction in any manner. Now, the obvious upshot of all these communications would be, does this flow from these communications that any representation in the nature that the payments would be made by defendant number was at all made? And the document speaks for themselves. And parole would be of no relevance because this is documentary. Now, your lordship kindly takes the transaction documents. So there is no tribal issue here insofar as this is concerned. Now, your lordship will take the transaction documents once, and this will further clarify the conspectus of facts. Page 75, confirmation of order. This is UN 609, your lordship. I will show that.
Yes.
Confirmation of order. 2, it is being issued by the plaintiff to Elite Ventures, the defendant number 5.
Elite Venture is defendant number 5?
5.
Or 6? 5.
I'm sorry, your lordship. 6. I'm sorry, I stand corrected. Response is 5. UN 609, your lordship has seen that. Australian scoured wool 20 micron. The details and particular specifications, rates, etc. provided. Your lordship. Now, your lordship, in the fine print, I know it's slightly, if your lordship can, is it legible on your lordship's copy, the fine print below the confirmation?
That is, yes, please.
Could have been blown up a little bit, but this document confirms our mutual agreement on the terms of this contract.
Yes.
So the contractual document, the transactional document disclosing the jural nexus between parties in the instant transaction is this. And the privity is between Elite and plaintiff number 1. And there is absolutely no reference to payment being made on behalf of Elite by defendant number 1. Now, your lordship will kindly turn over the next page. Identical. This is in respect of UN 610. I'm not repeating. It's identical. The same fine print is there. Thereafter, your lordship will kindly take page 77. This is the commercial invoice. issued by the plaintiff to whom? Elite Ventures, defendant number 6. Your Lordship, on the top left-hand side, your Lordship will kindly find the name of defendant number 6, Elite.
Yes.
And this corresponds to the right-hand side, UN 609.
Yes. Found it.
The entire specification corresponds to what I had just shown. The confirmation, order confirmation, the contractual document. The next page, the commercial invoice in respect of UN 610.
Yes.
Once again, addressed exclusively to Elite.
Yes.
And your Lordship will find price and the beneficiary, together with beneficiary bank, everything is provided under the transaction document. It's a transaction that is between Elite and TechVol. Plaintiff is not expecting any money from defendant number 1. They're issuing this commercial invoice on the original buyer. Now, your Lordship, most important, kindly sees the document of title, the bill of lading, at page 79. Kindly sees. The issuance is by towards left top, TechVol Trading Pty Limited.
Yes.
The reference is UN 609610.
Yes.
Right hand. Bill to order. Notifying party. Your Lordship will find third row from top. Notifying party, Indoworth India Limited. I'm not Indoworth.
Yes.
I'm not even required to be called. Since I'm not a notifying party. I'm not a consigner. I'm not a purchaser. I'm not a notifying party even to the bill of lading. The bill of lading is issued Adelaide to Kolkata. No mention whatsoever of any jural relationship to the goods at defendant number 1. Now, insofar as the other order is concerned, I'll just give the page numbers, your Lordship. I'll not repeat that. The transaction emails are from page 81 to 85. This is in respect of UN 611. There are 3 subject orders, your Lordship. UN 609, 610, and 611. 81 to 85 is the
610 and 610.
communication between parties. Once again, no reference to defendant number 1 in these pages.
Yes.
Thereafter, the transaction document starts.
So as per your contention, you are nowhere in the document.
I have no jural nexus to this transaction. That is my submission. Now, I just will give the page number, your Lordship. UN 611. The document is at page 86 and 87. Thereafter, the bill of lading is at page 89.
Yes, similar.
Similar. That's why I'm not taking your Lordship. Commercial invoices are also there. Now, what is the upshot of this? Let me make my submission on this. Settled principles, the averments of the plaint have to be read meaningfully. The documents disclosed with the plaint forms a part of the plaint. They have to be read together. And there has to be a meaningful reading taking into account the documents disclosed.
Correct.
I will show one case. It's not required, but for my satisfaction, 2020 7 SCC 366. These principles are now well settled. Meaningful reading of the plaint. Plaint has to be read meaningfully together with the document. Your Lordship will grant me one moment, your Lordship. I'll just open the case. So a bald averment which is ex facie contrary to or does not appear to bear out what is the content of the document regarding which no evidence in any ways is permissible, sorry. Yes, your lordship. Found it. Your lordship will straight away take para 23 of the Dahiwell.
Yes.
23. We have heard the learned counsel for the parties peruse the plaint and documents filed therewith, as also the written submissions filed on behalf of the parties. We will first briefly touch upon the law applicable in deciding an application under Order 7, Rule 11. Your lordship will now kindly take
Your application under 7 Rule 11.
Rule 11, Order 7, Rule 11, enunciating the nature of the pleadings. Mine is also Order 1, Rule 10 for deletion of my name from the array of parties, because it in law does not disclose a cause of action as against me. So 23.4, the principle as to how a plaint has to be read
As a whole.
as a demurrer. Azhar Hussain versus Rajiv Gandhi, this court held the whole purpose of conferment to ensure litigation which is meaningless. 23.5, 23.6. A duty to determine whether the plaint discloses a cause of action, the scrutinizing the averments in the plaint, read in conjunction with the documents relied upon. Read in conjunction. Now, your lordship, and this has partaken specific import now, because under Commercial Courts Act now, documents have to be disclosed upfront. 23.7, Order 7, Rule 14 provides for production of documents on which the plaintiff places reliance in his suit, which reads, now, Rule 1, where the plaintiff sues upon a document or relies upon a document in his possession or power to support of his claim, he shall enter such document in a list and shall produce. 23.8 is perhaps important. Having regard to Order 7, Rule 14, the documents filed along with the plaint are required to be taken into consideration for deciding the application and so on. So, when a document referred to in the plaint forms the basis of the plaint, it should be treated as part of the plaint.
Yes.
23.13, if on a meaningful reading of the plaint, it is found that the suit is manifestly vexatious and without merit and does not disclose any right to sue, the court should be justified in exercising power under so and so. So, meaningful reading has to be taking into consideration the document. Now, what does the document disclose here? Document does not disclose any jural nexus between the parties. I will not replicate this case. There is a subsequent case. I'll give a reference if required. Now, the second part is, I believe the more important part is, now, if that being so, am I a necessary and or proper party? My first submission is taking the documents together with the averments made in the plaint, there is no right to relief as against the defendant number 1. So defendant number 1 automatically gets expunged from being a necessary party. Now the question remains, the more convoluted question remains, am I still a proper party? Your lordship will kindly take Order 1, Rule 10 once. All this confusion stems from the fact in the definition of proper party, the word necessary has been used. That's a suits in the name of wrong plaintiff. May I read, your lordship? Sub-rule 2, your lordship. The court may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that name of any person who ought to have been joined, whether as plaintiff or defendant, whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all questions involved in the suit be added. So my submission is,
You're not the necessary.
A, not necessary, and the definition of this after the disjunctive or, your lordship, whose presence before the court may be necessary, in order to enable the court to effectually and completely adjudicate upon and settle all the questions involved in the suit be added. Now, my submission is this part after the disjunctive or is really the test as to who is a proper party, whose presence before the court is necessary for effective and complete adjudication of. Now, what is the purport of this? Whose presence has it been deemed? What kind of interest has it been deemed necessary to be present before this court for complete and effectual in view of the definition of proper party? 1992 wala to. Now, this is slightly older authority, but discusses this proposition. 1992, two Supreme Court cases, 524, fairly celebrated decision, Ramesh Hirachand Kundanmal versus Municipal Corporation of Greater Bombay.
Page number?
I'm sorry, Your Lordship.
1992 SCC.
1992, 2 SCC 524, Your Lordship. I'm handing up a copy. Now, in this case,
yes.
Now, the issue in this was there was a tenanted property. Now, Municipal Corporation of Greater Mumbai, they gave a notice of destruction, etc. It is a list between the plaintiff and Greater Mumbai. The tenant sought to implead itself, saying that I have an interest. They say, no, you have colluded because the notice of destruction was given at your behest. Now, in the conspectus of these facts, it came for consideration whether the tenant is a necessary and or proper party or not. Your Lordship will kindly take para 6.
Yes.
Subrule 2 of Rule 10 gives a wide discretion to the court to meet every case of defect of parties and is not affected by inaction of the plaintiff to bring necessary parties on record. The question of impleadment of a party has to be decided on the touchstone of Order 1 Rule 10, which provides that only a necessary or a proper party may be added. A necessary party is one without whom no order can be made effectively. Now, that is not the case here. An effective order can be made against respondent numbers 5 and 6. A necessary party is one without whom no order can be made effectively. A proper party is one in whose absence an effective order can be made, but whose presence is necessary for a complete and final decision on the question involved in the proceeding. Now, what is the meaning of this? Now, Your Lordship will kindly take para 8. Now, para 7, it is in the facts of that particular case, the tenant was not a necessary party in the sense that without the tenant, no order of destruction, etc. can be passed. So it came to be considered whether he is a proper party. Para 8, the case really turns on the true construction of the rule. In particular, the meaning of the word whose presence before the court may be necessary in order to enable the court to effectually and completely to adjudicate upon and settle all questions involved in the suit. So it considers what is the definition, what is the meaning and purport of a proper party under Rule 10(2). The court is empowered to join a person whose presence is necessary for the prescribed purpose and cannot under the rule direct the addition of a person whose presence is not necessary for that purpose. What does it mean? In the present case, the subject matter of the dispute between the appellant and respondent number 1 is demolition of the unauthorized construction. In pursuance of notice dated so-and-so, respondent number 2, the lessee in possession of the service station, asserts that the appellant has made an unauthorized construction and respondent number 2 is in possession of material evidence to that effect. No notice has been issued to the respondent number 2 by MCGA and no case of collusion before appellant and municipal corporation is alleged. On the other hand, it is the case of the appellant that respondent number 2 is instrumental in initiation of the proceedings of municipal corporation against the appellant and the present application is for collateral purposes. In light of such averment, it has to be considered whether the respondent number 2 is a necessary or proper party in the construction. The power of the court to add parties under Rule 110, Order 1 Rule 10, CPC came up for consideration in Razia Begum. In that case, it was pointed out that courts in India have not treated the matter of addition of parties raising question of initial jurisdiction of the court, and that it is firmly established as a result of judicial decision that in order that a person may be added as a party to a suit, he should have a direct interest in the subject matter of a litigation, whether it be questions relating to movable or immovable property. Now, this was the classical rule. Now, when it related to property, thereafter it came to be diluted.
Correct.
When there is a declaration of status, etc., is concerned, it need not be a direct interest. Then the concept of legal interest came in. So, your lordship will find at para 13 that distinction and the evolution of law in that regard has been said. A clear distinction has been drawn between suits relating to property and those in which subject matter of litigation is a declaration as regards status or legal character. Because in Razia Begum, the issue was whether wife was declared to be a wife, etc. And it was a suit by wife and the son. In former category, the rule of present interest as distinguished from commercial interest is required to be shown before a person may be added as a party. This is former category property. It cannot be said that the main object of the rule is to prevent multiplicity of actions, though it may incidentally have that effect. But that appears to be the desirable consequence of the rule rather than the main object. The person to be joined must be one whose presence is necessary as a party. What makes a person necessary party is not merely that he has relevant evidence to give on some of the questions involved. That would only make him a necessary witness. It is not merely that he has an interest in the correct solution of some questions involved that has thought of relevant arguments to advance. The only reason which makes it necessary to make a person a party to an action is so that he should be bound by the result of the action, and the question to be settled, therefore, must be a question in the action which cannot be effectually and completely settled unless he is a party. Now, what does that mean? The next sentence, the line has been drawn on a wider construction of the rule between the direct interest or legal interest and commercial interest. It is therefore necessary that a person must be directly or legally interested in the action, in the answer. That is, he can say that the litigation may lead to a result which will affect him legally, that is, curtailing his legal rights. Thereafter, quotes the Justice Wineperry's decision. The test is, may the order for which the plaintiff is asking directly affect. So the test that has been adopted is one of legal interest. Will I be affected? Will I consider myself to be affected? Now, my submission is that once I have shown from the meaningful reading of the plaint that there exists no jural nexus, there cannot be any question of making me a proper party. My involvement in the mere transaction might be in some other capacity. I don't know why. Nothing is disclosed in the plaint. But it does not disclose any jural nexus between the defendant number one and the transaction at hand on a meaningful reading of the plaint. If that be so, the test for proper party is one of existence of a legal interest. There is none insofar as the defendant number one concerned. So the suit can proceed. Insofar as the other defendants are concerned, they may be expunged insofar as the defendant number one is concerned. So my name be deleted from the array of parties. Those are my submissions.
Yes.
Now, whether insofar as the contention relating to a necessary party and the proper party is concerned, that is an undisputed settled proposition of law. But my contention as a plaintiff in this particular suit is completely based on the fact that the defendant number one is a necessary party. The pleadings which perhaps ought to have been shown to your lordship, Millard, along with what has been cited, Millard kindly takes up the plaint once. That appears at page 34, Millard.
Yes.
I'll be very candid, Millard. There are several documents. And of course, Millard, with the advent of the Commercial Codes Act, I have been required, Millard, which I have, along with my plaint, disclosed all the relevant documents. Why I say, Millard, that the defendant number one is a necessary party and not merely a proper party is because the defendant number two has acted in the capacity of being a director of the defendant number one. The defendant number one, being merely a juristic entity, Millard, cannot act in its own behalf until unless its principal officers acts on its behalf. That is exactly what my case is in the plaint as well. Your Lordship kindly takes up the plaint. I'll just reiterate a couple of paragraphs. Page 37, my lord. I've specifically pleaded at paragraph 4 that the defendant number 2 is one of the directors of the defendant number 1, whereas the defendant numbers 3 and 4 are the men and agents of the defendant numbers 1 and 2 involved in the daily operations of the defendant number 1. The defendant numbers 2, 3, and 4 are all working for gain at the office of the defendant number 1 at such and such.
Yeah, that you pointed out.
Yes. Now further to that, my lord, because it has also been contended that what has been the the jural nexus of the defendant number 1 insofar as this particular transaction is concerned. I have pleaded that in paragraph 6. I wouldn't take your lordship in details through that. Paragraph 6, paragraph 7. Thereafter, paragraph 8 is the modus, my lord, by dint whereof the transaction was sought to be executed. That the defendant number 1.
My lord, I'm so sorry. I do not wish to interrupt. I have missed out a point on section 230. It's a point in addition to what I've taken. I'll just elaborate it once.
Yeah, perhaps that wouldn't form the subject matter of of this particular application, because this is in the nature of a demurrer, my lord,
No, it
wherein they have
perhaps-
sought for, because
perhaps will, but I will take it.
Perhaps the point
We can
perhaps
deal
might
with
be
it later.
urged in GA3, GA1. I'm sorry, my lord. Now, insofar as paragraph 8, my lord, is concerned, that lays down, my lord, the modus operandi of the transaction.
Correct.
The defendant number 2, as the director of the defendant number 1, had approached the plaintiffs and had sought to.
But what the transaction, the details?
I will, because I need to show each and every document to your lordship, because
Have-
without showing that.
Have you addressed to the defendant?
Yes,
one
yes, yes,
company?
yes.
Where?
That is exactly what I'll say
He may
and
be-
show, my lord.
He may be director, but these
Yes.
transactions.
Why I say so, my lord, kindly takes up page 67.
67.
That is the first email which has been pointed out by my learned friend.
Yeah.
Because a document, my lord, has to be read in totality.
Correct.
And it
That's-
forms a part of the plaint, because it has been annexed to the plaint, and it forms a part of the plaint.
Correct.
From, my lord, Chanchal Khandelwal, the defendant number 2, has your lordship got it, my lord? Page 67.
Yes, I am there on.
Yes. Chanchal Khandelwal kindly, my lord, takes note of the email ID. Chanchal Khandelwal, which is ca.khandelwal@rpruniverse.com. So he's acting in the capacity of being a director of the defendant number 1. So now the defendant number 1 coming up and taking a stand. In fact, defendant number 2 till date right now is the director of the defendant number.
Written statement is filed.
Written statement they have filed without prejudice to,
filed.
yes, that they have. That they have. That is exactly, my lord, why it makes it a tribal issue.
No, it would have been barred.
Yeah, that's a separate issue altogether.
Now, in the written statement, what is the
Their defense, my lord, is solely based on this particular point.
no, in the written statement, what is the reply to the
That is the ploy, my lord. The defendant numbers 2 to 7, 8, my lord, are not appearing. It is only the defendant number 1 which is appearing.
Okay.
It's a very clever ploy, my lord. I wouldn't get into that because I know, my lord, that doesn't form a part of the pleading, but nonetheless.
Okay, continue.
Ploy resulting in ad interim orders being passed against all other defendants. I
And
don't know
ploy, my
how
lord,
it's
to
been-
stall the proceedings so that the CIRP goes through. And I am in a position where I don't get any relief in this suit.
There is no subsisting. No, nothing. There is no subsisting CI.
Might not. Proceedings have been initiated.
Yes. Next.
Yes. So, my lord, the contention over here is that the defendant number 2 has been acting in his official capacity as the director of the defendant number 1. At no given point, your lordship now thereafter takes up page 69. The document has to be taken in totality, my lord. Page 69.
Yes.
From Ken Welsh to Shiv Sharma, Chanchal Khandelwal exports, my lord, the subject, today's Uniworth purchases. Not in any of the contemporaneous document has the defendant number one come in and challenged and said that, no, look here, you are acting in your independent capacity.
Yes.
Thereafter, my lord, kindly takes up page 70. Documents galore, my lord, which will go on to show that the defendant number 2 had been acting in his official capacity as the director of the defendant number 1, page 70. Again, my lord, the electronic mail has been issued by the defendant number 2 in his official capacities, Chanchal Khandelwal @rpruniverse.com.
Yes.
My lord, in the event, assuming but not admitting to their contention, my lord, that they say that, look here, the defendant numbers 2, 3, and 4 have been acting in their independent capacity. In that kind of a scenario, I'll ask myself this question, my lord, whether a person not acting in his official capacity would use the email ID of the company or not. Further, my lord,
Sue against the company.
I beg your pardon.
Sue against the defendant number 2.
I'm suing against everybody and against the defendant number 1 as well. I won't let him off the hook.
Yes, next.
Documents of such nature, my lord, galore, page 74 as well. Your lordship will find those documents galore. Now, your lordship will find page 75, the confirmation of order which has been placed by my learned friend. Your lordship will find, has your lordship got it, my lord? Page
Yes.
75. This document has been placed before your lordship, but the destination, my lord, is Kolkata. Now, pausing here for a moment, my lord, it's Elite Ventures, which is the consignee, the purchaser. If your lordship takes up the cost title, your lordship will find that Elite Ventures is based in Hong Kong. There couldn't have been any cause for the purchaser to have the goods shipped to Kolkata. And now, your lordship, I'll take your lordship to the bill of lading.
No, what you want? What is the submission on page 75?
Well, the goods were to be shipped to Kolkata itself. That was the understanding. Now, Malad, I, as the seller, I cannot be concerned with the understanding vis-a-vis, apropos, whatever is there between the different numbers 1 to 8.
Correct.
All that I'm concerned with is that I have sold the goods, I've delivered the goods, and I'm entitled to the money. In their official capacity, I'll go on to show that, Malad. They have issued electronic mails that their company, the defendant number 1, is not in a sound financial condition. Their factories at Raipur, their factories at Nagpur are not functioning properly. The goods were shipped to Kolkata, taken to their own warehouse, used up, but payments not made. Those are the documents which I've annexed. Perhaps the defendant number 1 cannot feign ignorance now. Page 76 as well, the other order, your lordship, that's again to Elite Ventures. The destination is again at Kolkata. Thereafter, page 77 onwards, your lordship will find these are the commercial invoices. The destination is Kolkata.
Kolkata is your office.
Kolkata is their office. I am there based in Australia, Malay.
Correct. That Kolkata is their office.
D1, only D1, defendant number 1. Now your lordship will take up the bill of lading at page 79. Very interesting. Now they cannot feign ignorance. Kindly takes up page 79, my lord. Your lordship will find the notifying party is Indovat, the consigner, my lord. Page 79, my lord.
Yes.
The bill of lading has been placed by my learned friend, but what has not been placed, my lord, is the port of discharge and the pace of.
Specifically referred to.
No. Thereafter, I'll point out something more, which was not referred to. My lord, port of discharge is Kolkata Seaport. Place of delivery is Kolkata Seaport, India. Now, very interestingly, my lord, the email ID provided, my lord, kindly takes up the table just below that, the description of goods. Has your lordship got it, my lord?
Yes.
Just a few lines thereunder, my lord will find the email ID provided. Shipping underscore import @ngp.universe.com.
Where it?
My lord, the email ID just under the description of goods.
Description of goods.
Goods.
Particular shipment description of goods. Yes.
My lord, the email ID is that of the defendant number 1. Shipping underscore import @ngp.universe.com.
Which column?
My lord, it's the 4th column, my lord. Description of goods just under, my lord, the place of delivery, Kolkata Seaport, India. There, just there under, my lord, we'll find the description of goods. The 4th column from left.
It's not clear yet.
My lord, it's there. This is the one. Well, it's just in the middle of that particular page, your lordship. The table is there. The description of goods.
Description of goods.
Just there under, my lord. It has gone a little blurred. The GST, the PAN, then thereafter, my lord, email ID. Shipping underscore import, my lord, @ngp.universe.com.
Yes. So company mail.
Absolutely. Thereafter also, my lord, your lordship will find the defendant number 2 acts in the capacity of the defendant number 1. As the director of the defendant number 1, my lord, page 81. The next order is placed. Wherein also, my lord, the defendant number 2 acts in the capacity of being the director of the defendant number 1. My lord, page 81, my lord. Just at the very beginning, my lord, from Chanchal Khandelwal.
Correct.
The email ID is the same that of the.
Correct.
Now again, my lord, kindly takes up page 83. These are the correspondences exchanged. My lord, go exchange, my lord, through the domain name of the defendant number 1.
So you mean to say that all the emails of the company has been used
at all given point of time. And thereafter, my lord, what
the director of the defendant number 1.
So, my lord, I am not concerned with whatever the arrangement that might exist by and between the defendant numbers 1 to defendant number 7. I'm only concerned with the fact that I was approached by the defendant number 2 and as the authorized agent of the defendant number 1 to carry out these transactions, which I have. I have already sold the goods. I've delivered the goods. And my lord, thereafter, what I'm required to show to your lordship, in fact, in case of the other bills of lading as well, my lord, similarly placed conditions, the email ID is that of the defendant number 1.
Now further, what is the further?
I beg your pardon.
What further document you are relying?
Further documents, my lord, wherein they have indicated that they need some further time, my lord, to make the payment.
The goods differently.
So the issue, my lord, at large over here.
Defendant number 1 has not written a letter to you.
My lord, the defendant number 1 is a company. How can the defendant number 1 company write a letter?
No, that's why there is no. You heard. It's correct. It is all the defendant number 1's email has been used. But is there any document that he has acted as a defendant number 1 director as any document? No.
My lord, he is.
It is there or
My
not?
lord,
I am telling.
If I now pausing here for a moment, my lord, I had indicated this earlier as well, my lord. I am acting as the director of the company. I would use the email of the domain name, the email ID of that of the company.
Not difficulty.
And in the event, and my lord, that is exactly, my lord, what I can gauge what is falling from your lordship, my lord. Perhaps the nexus. That is why I say, my lord, it becomes a tribal issue from the bare reading of the plaint and the documents that I've annexed.
Okay.
I'll be citing a few judgments, my lord, which I thought my learned friend, I'm not equipped with that, but I'll elaborate. I need to show your lordship a couple more of documents, my lord, wherein I can demonstrate that the defendant number 1 was acting through the defendants, wherein it goes on to say that the other defendants go on to say that, look here, the defendant number 1, I am one of, in fact, there is another email, my lord, that I am one of the executive directors who is on a vacation due to the COVID at Dubai. So naturally, I'm not in a position. Please, it's in a the company is in a trying situation because of the COVID. So kindly help the defendants to sail through this particular phase of time. I'll actually, in fact, what I'll do, my lord, is that might assist your lordship. I'll just make a 1-page pointer, bullet points, my lord, which will go on, which will refer to the pages wherein it will demonstrate that the defendants have been acting in concert with one another on behalf of the defendant.
That's all.
I'll come back with that particular note and judgments. That's it.
Further come back. 1 hour.
I need to.
That's why I ask. It is ready.
Hand up the judgment. I will deal with it.
I'll give you the judgment beforehand, so that you can deal with that on the next one. Grateful.
So I will respond to him once he completes.
Of course. On the point of law, I suppose.
Yes, yes, absolutely. And on facts.
No, of course not.
So suffering for the defendant number 1.
Fact refer করলে তো করতেই হবে।
The defendant number 1 has filed an application being GA3 of 2023.
Decide করার জন্য আমাকে
Saying for deletion of its name from the suit. Counsel for the defendant number 1 has concluded his argument. Counsel for the plaintiff has argued at 10 and prayed for some time. In view of the submission made by the counsel for the plaintiff, case is adjourned. Let the matter appear on 24th April.
24th.
Any date apart from 24th, your lordship. I'm sorry.
Then 26.
26. Grateful. Very well.
Under the
I'm deeply obliged.
It's not 21. The Passover मतलब 14 मतलब ना 2 मिनट मैं ये देखने जो जस्ट सबमिट करता हूं
Item number 8. Item number 8.
Lordship, I'm for the plaintiff petitioner in this matter, your lordship. Despite repeated service, the defendant has not been appearing. The pleadings of the application are complete. This is my application for injunction and judgment upon admission, your lordship.
Have you served the copy? Defendants.
We have handed up
Yes.
the affidavit of service, your lordship. If your lordship wishes to hear me, I can make my submissions in the matter.
Fixing a date next.
Very well.
So appearing for the plaintiff, so appearing for the defendant. In spite of the notice, none appears on behalf of the defendant. Let GA number 1 of 2023 along with CS number 43 of 2023 be listed on 29th.
Very well. I'm deeply obliged.
Next.
So the terms, my lord, plaintiff, my lord.
Lord, I appear for the defendant.
But we have received the demand draft of 22 lakhs, my lord. A decree may be passed on the terms of the settlement, my lord.
What was your suit?
There is a money, my lord, dues, my lord, goods sold and delivered, money not paid. They had, my lord, acknowledged the sum of 22 lakhs in an electronic mail, my lord.
So
That is the amount, my lord, they have paid.
as per work case, 49 lakhs.
49 lakhs with the interest portion, my lord. The interest portion is waived off, my lord. And the 22 lakhs is the principal sum which was there, my lord.
26 lakhs principal was
26 lakhs.
26 lakhs, my lord.
26, 81, 278. Now
22 lakhs is the final.
settled on 22.
Yes, 22 lakhs, my lord. Yeah.
Sole plaintiff, sole defendant.
The sole defendant, my lord.
Concession suffering for the plaintiff, concession suffering for. What is the GA5?
My lord, GA5 is my lord, application under order 13A, my lord. All will get disposed of, my lord, definitely, my lord.
Suffering for the plaintiff, concession suffering for the defendant. Full stop. The both the parties have filed the terms of settlement entered between the parties dated 2nd April 2024, wherein the dispute between the parties have been settled as the defendant has paid the amount of rupees 22 lakhs by way of demand draft in the name of the plaintiff, and the plaintiff has accepted the said amount being the full and final settlement. It is fine from the suit. The principal claim of the plaintiff was 26,81,278, and with interest, the plaintiff has claimed an amount of rupees 49,86,649, but 49,86,649. But now, during the pendency of the suit, the parties have settled the dispute for a total sum of rupees 22 lakhs by executing the terms of settlement. In view of the settlement, terms of settlement filed by the parties, the suit is disposed of by making the terms of settlement entered between the parties as part of the decree.
Grateful, my lord.
The department is directed to draw on the decree by making the terms of settlement as part of the decree.
Grateful, my lord.
CS
Grateful,
number
Lord.
181 of 2022 is disposed of.
Grateful, my lord.
See then,
Obliged.
consequently, all applications are disposed of. See the consumer, the commercial number also, otherwise it will be difficult.
My lord, the matter is.
My lord, I am appearing for the plaintiff petitioner, my lord. My lord, there was a direction for exchange of affidavit on March 12th, my lord. The affidavit of opposition has been filed by the defendant respondent, my lord. I am seeking extension of time to file the reply, my lord.
But I have.
GA2.
Yes.
My lord.
GA2. What is the GA2?
It's about judgment on admission, my lord.
And the matter is in a little mess. I tell you, Lordship, my lord, why? Because the sole defendant, my lord, in the suit is not in existence. Was not in existence, my lord, before institution of the suit. My lord, this was a partnership firm which has since dissolved. My lord, much prior to institution of the suit, was not, my lord, personally known to me. After, my lord, going through the affidavit in opposition, I could discover that, my lord, the partnership firm, my lord, has dissolved and, my lord, has rather, my lord, merged with a limited company.
What?
Merged with a, my lord, limited company. My lord, will kindly take, my lord, two documents once. Kindly, my lord, take the trouble to have a look at the plaint once. My lord, this is a suit for, my lord, implementation of, my lord, a terms of settlement filed in course of mediation. Firstly, my lord, the suit is not maintainable because of, my lord, subsection 5 of section 12 capital A. Suit is not maintainable. Be that as it may, my lord, it's an award.
If it is a mediation,
It was my lord. It was an award, my lord. But since it's a company based in Nepal, my lord, so it was when it was the
that mediation in the suit also.
Yes.
So what happened to the suit if the mediation?
No, my lord.
No,
No,
my lord,
it was
pre-institution.
pre-institution mediation, my lord.
It's an award. It's an award, my lord, under subsection 5. My lord, suit is not maintainable. That's one. Now, my lord, in course of mediation, kindly may just have a look at page 40 of the plaint. My lord, things are to be set right. My lord, may I hand up? My lord, just need to, my lord, look
Okay,
at
you
one.
do one thing. Now you have filed the affidavit.
My lord, the opposition.
Opposition has been filed, my lord. I'm praying for leave to file.
My lord, I do not stand in the way. My lord, I have captioned my opposition as the opposition of the respondent, which I cannot say. Kindly, my lord, allow me, my lord, to correct it. My lord, only, my lord, by the respondent at the heading of the opposition, I must, my lord, strike out. Because the respondent, my lord, the defendant is no more there. My lord, I do not know how, my lord, a vokalatnama could be filed, how, my lord, appearance could be entered. Has been filed, my lord, on behalf of a dissolved firm. My lord, I need to sit with my learned
And
advocate
you have
on record.
disclosed all the things in the affidavit.
Yes, I have.
Take steps.
Yes, my lord.
You take steps. So what you want now?
My lord, kindly allow me, my lord, to strike out, my lord, that by the respondent in the heading. My lord, I cannot.
Of the
Yes, yes, on behalf of the
So what
respondent.
do you want?
Only affidavit in opposition. Only I can't file.
My lord.
And my lord, kindly take out one line that, my lord, we are, my lord, informing this honorable court that, my lord, the firm has dissolved prior to, my lord, the completion of the mediation.
Suffering for the plaintiff. So and so suffering for the defendant. Full list of plaintiff has filed the present application being GA2.
Yes.
Form 2 of 2023 for judgment on admission.
Judgment on admission.
Saying for judgment on admission. Full list. Counsel for the defendant. No. So and so submits that the defendant form Messrs. History, Trade and Exports have been dissolved
and merged with the
prior
limited
to
company.
the institution of the suit
Right.
and it has been merged with
a company.
Merged with a company.
And the name is disclosed in my affidavit.
Merged with a company, namely.
When did I tell your lordship? What? But this is Drishti Projects and Advisory Services Private Limited.
Drishti
Projects
where you
and
mentioned
advisory. My lord will get it, my lord, in my opposition, page 17.
page 17.
Page 17, my lord, the last clause at the bottom of page 17, clause 4. My lord, this is the, my lord, deed of dissolution of partnership.
Drishti Project and Advisory Services Private Limited. ठीक है Counsel for the defendant submit that though they have filed the affidavit in opposition by mentioning as affidavit in opposition on behalf of the respondent, but the respondents are not in existence.
Sole respondent.
The sole respondent is not in existence. Accordingly, he may be granted leave to delete the words on behalf of the respondents in the affidavit in opposition. Accordingly, leave is granted.
In course of today, Miller, the
advocate on record of the defendant is directed to delete the word in the affidavit in opposition, word on behalf of the respondents in the affidavit in opposition.
Miller, in the last order passed, Miller, it has gone down that Miller, you are appearing for the respondent. Miller, that order may also be Miller read accordingly.
Full stop. The counsel for the plaintiff prays for time to file affidavit in reply. Let affidavit in reply be filed
within 1 week, my lord.
Within 1 week. Full stop. Reach the matter on 29th April 2024. Full stop. Counsel for the defendant submitted in an order dated
12th of March
2024. This court has recorded that Mr. Subir Banerjee appeared for the defendant, but it may be recorded as but
the appearance may be there not on behalf of Miller, a date person.
Let it be random.
And suit is not maintainable in any case.
Last. Yes.
Grateful.
Next. Next.
I appear for the defendant.
Yes.
I was the defendant.
All the applications have been dismissed.
Before your lordship rises, may I have your lordship leave to mention item number 12? Your lordship, a slight correction needs to be done.
Which one?
Item number 12, your lordship.
Item number 12 of?
Your lordship, the ordinary list, your lordship. Original side, ordinary list, your lordship. A slight correction needs to be done, your lordship. Your lordship passed an order on 3rd April, where your lordship has recorded that the respondent entered appearance on 20th May 2024. It has to be, your lordship, 2022.
Where is the order?
Lordship, I handed over the order on last occasion when I mentioned the matter. I have handed the order.
There?
Lordship, only that correction needs to be done, your lordship.
Which line the order is there?
Lordship, fourth paragraph, your lordship, of the order. Defendant have entered appearance on 28th May 2022. It has gone down as 2024, your lordship.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Full stop. This court, full stop. In क्या बोला? The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff for correction in the order dated 3rd April 2024. Full stop. Counsel for the plaintiff submitted in the order dated 3rd April 2024 at paragraph 4, last line, the date is mentioned as date recorded as 20th May 2024 instead of 20 May 2022. Accordingly, in the order dated 3rd April 2024, in page 1, paragraph 4, last line, the date shall be read as 20th May 2022 instead of 20th May 2020.
Much obliged, Your Lordship. Much obliged.
This order may be incorporated with the order dated 3rd April 2020.
My lord, we'll take that matter, the next matter.
Tip number 7, Lordship.
This is made an appearance before my lord.
3 p.m.
3 p.m. Yes.
To come 3 p.m.
My lord.
Very good.
May it please, Your Lordship.
Yes.
I'm appearing on behalf of the plaintiff in a suit for recovery of money lent and advanced. And this is, my lord, my application for judgment upon admission that is filed under Order 12, Rule 6. This is, my lord, GA3 of 2023.
GA3?
Yes.
What is the
Yes,
GA1?
my lord, GA1 is my application for injunction and security along with attachment before judgment. But since today I am praying before Your Lordship for the decree on for judgment upon admission, my lord, may I proceed with the judgment upon admission application? If Your Lordship kindly takes up GA3 of 2023, my lord.
Yes.
Now, this is a simpliciter case for recovery of money lent and advance. If Your Lordship sees the first paragraph, we have set out, my lord, the claims which we have sought in the suit. That is, my lord, a decree of rupees 9 crore 99 lakh 97,678, together with interest at the rate of 15% per annum, because I shall demonstrate, my lord, from my pleadings and confirmation of accounts that 15% per annum was the agreed rate of interest to be paid by the defendant to the plaintiff at 4 monthly rests. Now, my lord, kindly comes
After
to the
4 months.
Yes, at 4 monthly rests, this particular amount of interest was to be paid. If Your Lordship takes up the plaint, my lord, it begins from page 9.
Yes.
And may I draw Your Lordship's kind attention to page 10, paragraph 3. From May 2015 to 27 December 2018, this was the time period within which rupees 6 crore 84 lakh odd was lent and advanced. Page 10.
3rd July 2017.
Yes, was lent and advanced. And in an aggregate, my lord, a total amount of rupees 10 crore 44 lakh 1,288 was received by that's page 11. We have given the total. This is the total amount which was received by the defendant from the plaintiff.
Yeah.
Now, my lord, I'll just show 2 instances because we have annexed the bank statements. My lord, will find the first loan which was advanced is dated 6th of May 2015. That is at page 10 in the chart. Now, this is an amount of rupees 50 lakh, and Your Lordship will find that, my lord, at page 47, which is an extract of the bank statement. Page 47 of the application.
Yes.
Well, it is the 7th. Sorry, it is the 7th entry from the bottom, and it is booked in the name of Shudha Kankaria, rupees 50 lakh is debited. It is from the bottom, the 7th entry. Shudha Kankaria is the name of the defendant.
Yes. Transfer to Kamal Parekh.
Just on top of that, BRN RTGS UTI BH 151, and the number is there, Shudha Kankaria, and check number is 199,657. Amount is rupees 50 lakh.
Yes.
This matches with the first entry in the chart.
Yes.
Now, the last entry of the chart, which is at page 11, is dated 27th of December 2018.
Yes.
And that is, my lord, an amount of rupees 5 lakh, which was last advanced. My lord, that is also appearing at page 84.
Yes.
Which is again a part of the bank statement. But that is the last but one entry. 27/12/2018, Shudha Kankaria.
Yes.
Now, my lord, the transactions which we have mentioned in the chart at page 11,
yes,
my lord, accordingly are there disclosed in this particular bunch of bank statements.
Yes.
Now, next, my lord, relevant paragraph or page is page, again, my lord, page 4, if your lordship kindly comes to the chart, which is the details of loan repaid because an amount of rupees 3 crore 60 lakh admittedly is repaid by the defendant. And just to show an instance, my lord, if your lordship takes up page 12, the first repayment was on 17th July 2015.
Yes.
And your lordship will find that corresponding entry at page 49.
My
lord, it would be in the middle. 17/17/2015, the second entry of the same date, Shudha Kankaria Devank, 23 lakh. In the middle, my lord.
Yes.
So this is, my lord, the first repayment which was made as far as the principal loan is concerned by the defendant.
Yes.
Similarly, my lord, the last repayment date is 3rd of July 2017. It also appears in the chart at page 13.
Yes.
And my lord, the corresponding entry is at page 74. Yes, my lord.
Yes.
From the bottom, the 11th entry from the bottom at page 74. Shudha Kankaria, 3/7/2017. It's the first entry of that date, 3/7/2017.
Yes.
And it is Shudha Kankaria,
25 lakhs.
25 lakhs. So, my lord, in this manner, the total amount of rupees 10 crore 44 lakh,
Yes.
which was advanced as loan to the defendant, was received by the defendant, and the defendant from time to time has repaid an amount of rupees 3 crore 60 lakh.
Okay.
Now, this, my lord, is for
Out of total 10,
out of total 10,
3 have been
3 crore 60 lakh has been
received.
Now, my lord, kindly takes up page 85, which is my corresponding confirmation of accounts.
85.
Yes, my lord, page 85.
Yes.
This corresponding confirmation of accounts, my lord, is for the period April 2015 to March 2016. And it shows, my lord, that an amount of rupees 4 crore 8 lakh 51,000 odd is due and payable. This includes, my lord, just page 85.
It's April 16.
Yes, 1st April 2015 to 31st March 2016, 1st April 2016. Yes.
Correct.
Yes.
So, what is the amount?
My lord, it is 4 crore 8 lakh 51,753. As on that, but as on 2016.
Where it is in Acha.
My lord, last bottom.
Close barrier.
Yes. And this particular, it is total transaction is, my lord, 4 crore 8 lakh. What is balance is 2 crore 85. My lord, closing balance, total transaction is 4 crore 8 lakh. This includes principal as well as interest which we have received. And the balance is 2 crore 85.
Yes.
Now, my lord, this gets carried forward for the next financial year. And the confirmation of accounts is at the next page, page 86. It's dated 1st April 2017 for the period April 16 to March 17.
Yes.
The lordship will find at the right-hand side, opening balance is the same as the one which was closing. Closing balance is 2 crore 85 lakh at page 85. Page 86, your lordship will find the same figure as opening balance.
Yes, 285.
And this is, my lord, signed and endorsed by both the parties.
Yes.
And here, my lord, since transactions went on increasing, your lordship will find at page 86, the due amount also increased.
Correct.
But your lordship will also find that they have paid interest and they have also paid portions of the principal amount. So as on 1st April 2017, 6 crore 15 lakh was the amount admittedly due. Now, my lord, the next page, page 87, is the last confirmation of accounts by both the parties. That is 1st April 2017 to 31st March 2018. I must point out that these are documents which we have received from the borrower. So Shudha Kankaria, at the top, it is written from Shudha Kankaria. And below the amount, as I had shown, again the opening balance corresponds with the last year's closing balance. And as on 1st April 2018, the amount, which was outstanding is 6,77,51,288. Now, since they were not repaying, we had issued them notices for demand. And those notices for demand, enclosing ledgers, the envelope is at page 92. The letter your lordship will find at page 95. The envelope and the track information, appears to be in to have been placed earlier to the notice, but it is 25th of January 2021, the demand notice at page 95.
Yes.
And in this demand notice, we seek the outstanding, your lordship will find, if your lordship is at page 95,
Yes.
In the middle, we say, I draw your kind attention that a sum of rupees 9,66,24,437 only lying debit to your account as on 31st December 2020, details whereof are as follows. Confirmed outstanding debit balance as on 1st of April 2018. And then comes the figure. I have shown your lordship the figure admitted by the defendant from the confirmation of account. And the remaining figures, are portions which are of the unpaid principal together with the agreed rate of interest. That cumulates to rupees 9,66. Now, this is the letter which was given by the plaintiff himself. And track information report your lordship will find at page 97. The first entry itself shows that item delivery has been confirmed.
Yes.
The subsequent demand is at page 98.
Again.
Yes. Now, for the next time, it is given by the learned advocate of the plaintiff. That is at page 98. It is 3rd of March 2021.
Yes.
And in this particular demand, we again give the calculation, which is at page 99. And we request the defendant to immediately make payment of the dues. That is at page 99, Millard. The calculation is given. Now, Millard, at page 100 is the track information report,
Yes.
which also shows that the amount has been received.
Notice.
The notice has been received by the defendant. Now, my lord, may I draw your lordship's kind attention to the written state, to certain orders which were passed in GA1. Because earlier when the matter was taken up, my lord, there really has not been a hue and cry or contest with respect to liability of repayment. I will try to, my lord, make my submission on that fold by showing these orders which have earlier been passed in these proceedings.
What is the 102?
105. My lord, 102 is a notice which we have received from the Income Tax Department, because Income Tax Department, my lord, holds us to be liable for repayment. Now, we have advanced money. We have shown it in our books, but we have not received the money. That's why we received this notice. And this notice was, my lord, disclosed by us for ad interim reliefs to show that we need security to meet our obligations towards statutory obligations towards Income Tax Department.
Okay.
And it's a part of the plaint. That's why we didn't remove it. When my lord kindly comes to page 105, these are the orders which has been passed. Heard Mr. Such and such appearing on behalf of the respondent. It is submitted that there is a piece of land with regard to which discussions are going on between the parties for transfer of the same in lieu of satisfaction of the amount claimed in the suit. Particulars of the same shall be provided by him on Monday when this matter shall be taken up again. Now, my lord, may I pause for a moment? As on this particular date, and as has been recorded in this order, there has not been any contest with respect to liability. Lord, that is the reason why, my lord, they wanted to satisfy the decree by selling off the land to us. This is direct sell. My lord, the next page is at page 107, the next order. Mr. Such and Such his client has offered a piece of land as security to the plaintiff petitioner. In my view, the details of the land along with the valuation should be filed by way of an affidavit. The respondent is directed to serve a copy of the affidavit on such and such date to the petitioner. Now, my lord, kindly takes up the next order, page 108. In my view, the properties that have been provided by the defendant for the purpose of security is not suitable one, as the same is a right of the defendant in an undivided property. In my view, let affidavits be exchanged in the matter. Affidavit in opposition be filed within such and such date. Well, two things comes out of this particular series of orders. First, there was no real contest because they wanted to sell their land. When we had a look of the document disclosing the details of their land, we found that it was undivided property. And we brought it to the notice of the court. The court declined that particular piece of land to act as a security. So, my lord, as on when this matter was taken up, that is GA1 was taken up, there was no real contest with respect to liability to repay. My lord, that is the same reflection which comes out even in the written statement. The written statement, my lord, is from page 109. I shall just show a few paragraphs of the written statement.
Your application is 12.6.
Written statement or otherwise, my lord, I am trying to cover both.
No, you are relying upon written statement. That's why I'm asking 12.6.
Yes, yes. Both pleadings as well as, my lord, otherwise, because confirmation of accounts are there, bank statements are there.
Okay.
And now pleadings are also, my lord, helping me to some extent. If your lordship takes up page 112, may I place from paragraph 5A? The defendant states that the defendant was in need of financial assistance for her business, and accordingly sometime in May 2015, one Shanti Kumar Surana, who is a financial broker and known to the defendant since lifetime of her deceased husband, had proposed to the defendant for arranging loan from one of his acquaintance, namely Surinder Singh Bengani. This Surinder Singh Bengani, my lord, is the plaintiff. The defendant had agreed to the proposal. My lord, kindly takes a note of this because this is the agreement which even the plaintiff conjoins. The defendant had agreed to the proposal of Shanti Surana. Accordingly, Shanti Surana facilitated transfer of funds in tranches commencing from 6th May 2015 to 8th February 2018. Your lordship, I have shown your lordship both these two dates. The defendant further states that as per the instruction of Shanti Kumar Surana, the defendant has made repayment of said loan amount on time to time. As on 3rd of July 2017, a total of sum of rupees 3 crore 60 lakh was repaid to the plaintiff out of the total sum advanced besides interest. Sometime in the month of 2000. So, my lord, the first two paragraphs clearly show that the existence of the loan agreement, the fact that loan has been received, and further the fact that there has been performance on part of the defendant to repay a portion along with interest is completely admitted. Now, my lord, the next paragraph.
But paragraph page 113.
Yes.
6/5/2015 to 8 February 18.
Yes.
Correct. And as per your statement,
that is 27th December 2018. Sorry, my lord. That is 3rd July 2017. That is what we say as the 25 lakh last received from them.
Yes, 27 July 2017.
Yes, because that amounts to 3 crore 60.
No, that is repayment.
Last payment of advance.
Payment given by
yes,
you.
27 December 2018. Yes.
And here is the
And they have, my lord, preponed that particular amount.
February 18.
Yes. But I have shown bank statements. I have also shown, and your lordship has noted,
Okay,
it was
okay.
exactly transferred to the same person, that is the defendant.
Then
And there is
record or
confirmation of
admitted?
accounts.
A repayment is admitted.
Repayment is admitted,
Yes.
and even receipt is admitted, because confirmation of accounts has to be considered. Now, my lord, sometimes in the month of February 2018, plaintiff herein, through financial broker Shanti Surana, started insisting for immediate repayment of the outstanding principal amount to the tune of rupees 6 crore 77. So, my lord, they are deducting from 10 crore 44 minus 3 crore 60.
So this
10
is
crore 44 amounts to 12 to the chart which I have given. It
So
doesn't end in
because
February.
Your last demand was 677. As per the
Yes, my lord. And that is as per
balance
the
confirmation.
balance confirmation. So they admit the existence, contents, and even truth of contents of the balance confirmation.
Correct.
Repayment of the outstanding principal to the tune of rupees 6 crore 77.
Correct.
The defendant was unable to pay. My lord, page 114. The defendant was unable to pay the said amount in one go, and therefore a meeting was held between the plaintiff and the defendant on 20th February 2018 at the office of the defendant. The respondent expressed her inability to refund the loan amount in one go and proposed to transfer her land at Koshba towards satisfaction of the dues. Thereafter, the plaintiff inspected the land with Sri Pankaj Bhattacharya of the defendant on 12th March 2018. Again, a meeting was held in the presence of the staffs of the defendant, namely Pankaj Bhattacharya and such. In the course of such meeting, defendant and her son proposed to transfer their share, measuring about, this is the description given. Lordship kindly takes up the next page. Till the first three lines is the description. Since the plaintiff has already inspected the said land, and as such, thereafter the plaintiff agreed to purchase the said land at a price of rupees 70 lakh, 7 crore. Thus, an agreement was entered into by and between the plaintiff and the defendant verbally for transfer of the aforesaid land at the aforesaid price in presence of the aforesaid witness, which was agreed to be given effect on and from 1st April 2018. And there are again the story goes on. Most interestingly, my lord, this is the written statement which was affirmed post the affidavit of, post the situation when Justice Saraf had taken up GA1. Now, my lord, a very apparent dichotomy comes here. This particular defendant comes up and says before the court that I have this piece of land which I want to offer
That
to
was
you.
not settled as per
No,
the
my lord,
order.
a very interesting thing over here is, and it's very crucial, it's the same piece of land which they had offered to secure. And now they come up and say that this you had promised to purchase.
That's what I'm telling. That's what I'm telling. Before this court, once there was a first order, second order, it was not cannot be because it is the joint property.
Yes. So joint property of the defendant.
So it
There was
cannot
no
be-
whisper.
So it cannot be materialized.
And there was no whisper, Miller, in my most humble submission, that the plaintiff had entered into an oral agreement for sale. They should have. If this is the believable fact, then they should have, on the very first instance, come up before the court and said that this is one property which you have orally agreed to purchase that property. But they say something completely different. They say that we are the owner of the property and I am ready to give it to you as a security. That's why I had annexed these orders to counter the allegation which is there in the written statement.
Okay.
Milord, in my most humble submission, this particular line of defense which goes on is not the correct scenario. And there are, Milord, pleadings. I have shown 2 paragraphs. They admit the amount which they have received and they admit repayment. Now, Milord, the chart which I had shown your lordship, the summation of the amount which was advanced is rupees 10 crore 44 lakh. If we deduct rupees 3 crore 60 lakh from 10 crore 44, the amount of 677 comes. So, Milord, any amount, and that includes amount which was last paid in December 2018. So, they say that in February 2018, the advancement had stopped. That is what they say, my lord, in page 113.
Yes, I know.
And your lordship has noted that. But the chart shows that payment has been even received by them later, subsequently. And if we add up all the payments which they have received, that is 10 crore 44. And if we deduct 3 crore 60 from there, the remaining balance is 6 crore 77. So they perhaps did not do the calculation properly. This is my most humble submission. This is the defense I have shown your lordship. This is their only defense. Now, my lord, the judgments which I wish to rely on, may I hand up? 8 judgments are being appealed. Right. Justice Sanjeev Banerjee judgment. Justice Deepanshu Bhatt, Justice Sanjeev Banerjee. The copy din na. Ami দিয়ে দিছি check din. But this was also an application for judgment on admission. May I place, my lord? But paragraph 3 kindly takes up this judgment, my lord. Paragraph 1. This is this is an appeal in support of no case at all. And the telltale sign is in the full stamp duty not having been tendered. The balance stamp duty of such and such must be tendered. Paragraph 3. The appeal is directed against a decree of February 19, 2020, passed on a petition for judgment on admission in a suit for recovery of money arising out of a loan transaction under which the respondent plaintiff had made a sum of rupees 2 crore available to the appellant therein. Paragraph 4. In the impugned judgment, the single bench found no defense having been made out to the claim. The court relied on the undated balance confirmation of accounts for the period such and such to March such and such. The certificates evidencing tax being deducted at source in connection with the part payments made and the general lack of any credible defense in the affidavit filed on behalf of the appellant's hearing. Now, will it kindly takes up paragraph 7. I'm just skipping the paragraphs in between.
Yes.
It is true that the appellant claimed that the purported confirmation of accounts was forged. This is one, Miller, very common, but here there is no case for forgery made out and has not been issued by or at the instance of the appellant, but it is plain to see that the appellant acknowledged receipt of an amount of rupees 2 crore and alleged that the entire amount was returned by cash to the plaintiff. Thus, the loan transaction, or at least the receipt of a sum of rupees 2 crore from the plaintiff, was acknowledged by the appellant, though the appellant asserted that such money had to be returned. Now, mirror paragraph 8. It is here that the belated reply of the appellant to the demand notice of January 12, 2019 may be referred to. The rather cryptic response may be seen in its entirety. And then, Millard, the entire is set out. Now, Millard, paragraph 10. The stand taken in the said reply of July 23, 2019 is a stark contrast to the defense on substance sought to be made out at paragraph 3A of the appellant's affidavit filed in opposition to the plaintiff's petition for judgment on admission. Indeed, if the demand contained in the notice of January 12, 2019 was false, ordinary human conduct would warrant an immediate response thereto. At any rate, the belated reply, particularly in its use of words, "I have not taken any loan as falsely alleged," jars against the subsequent assertion on oath by the appellant herein that the entire amount of 2 crore had been returned to the petitioner by cash. The appellant now seeks to pick holes not only in the balance confirmation, apparently signed on behalf of the appellant, but also in the certificates evidencing deduction of tax at source. The appellant claims in this court that those TDS certificates pertain to some other transaction. The parties had nothing to do with the claim carried on by the plaintiff. Such case ought to be made out in the appeal is dishonest and is completely disbelieved. It is alarming that dishonest litigants have the temerity to try and throw wool over the court's eye without having any defense to claim. Not going any further, Milord, ultimately the appeal was dismissed. And this is, Milord, the order which was been appealed against. May I, Milord, just for record, place it before the court. देखिए the copy. देवांशु बसाक. This is देवांशु बसाक.
Yes.
Now, Milord, apropos confirmation of accounts, here confirmation of accounts is not in dispute. But I have shown your lordship that there are two contrary stances which has been taken. One stance was at the very nascent stage when the suit had come up and there was a threat of security or attachment before judgment. They came up with the truth that, yes, this is my property, kindly secure it. Subsequently, the same property they say has been that we are seeking it to purchase. This is a complete dichotomy of pleadings and submissions made before the court. And your lordship can even pass judgment on oral submissions made by the counsel. Now, may I place this particular judgment to indicate what is the effect of what is the effect of an acknowledgement? Milord, only one paragraph, paragraph 19, which is that page, Milord, page 76.
Page 76.
76. Well, this is 1971, volume 1, Supreme Court cases, page 67.
Yes.
But since it is not, the placitums are not given, may I, Milord, place paragraph 19. But the argument was that since the letter called for confirmation of the amount of rupees such and such as being the balance due to the appellant company, and as the appellant company failed to confirm it, the admission of liability was conditional and therefore cannot operate as an acknowledgement. In this connection, the decision in Moniram versus Rupchand was relied on, and in particular, the famous dictum of Justice Mellish in River Streamer Company versus Michel, approvingly cited therein. The dictum was that an acknowledgement to take the case out of the statute of limitation must be either one from which an absolute promise to pay can be inferred, or secondly, an unconditional promise to pay the specific debt, or thirdly, that there must be a conditional promise to pay the debt and evidence that the condition has been performed. The statement relied on in Mariam's case as an acknowledgement was by respondent in a written statement filed by him in an earlier probate proceedings in which it was averred that the applicant Rupchand Nanabai had for the last 5 years opened a current accounts with the deceased, and that the alleged indebtedness did not affect his right to apply for probate as one of the executors. It was held that the statement was sufficient to constitute an acknowledgement. Now, Milord, I draw your attention here within the courts. An unconditional acknowledgement, said their lordships, has always been held to imply a promise to pay, because that is the natural inference if nothing is said to contrary. It is what every honest man would mean to do. There can be no reason for giving a different meaning to an acknowledgement that there is a right to have the account settled, and no qualification of the natural inference that whoever is the creditor shall be paid with the condition when the condition is performed by the ascertainment of a balance in favor of the claimant. Milord, in our case, the confirmation of account is not under challenge, which means that the indebtedness is confirmed. And these are, Milord, my most humble submissions as far as, Milord, the application is concerned. I most humbly pray before your lordship for passing a judgment on admission, and I have given, my lord, the amount which is as on date lying due and payable, because it is no longer 9 crore 90 lakh. We have, my lord, adjusted the interest, and it is as on date an amount nearing about 13 crore. If your lordship sees, my lord, our application, page 5.
1339.
Yes, my lord, this is the amount, because, and we have computed the interest at 15% per annum, which is admitted in their confirmation of accounts. Most.
Yeah. What is your defense?
Milord, my first defense was, Milord, is under, Milord, as I have taken in, Milord, even the suit as well as in application, Milord, the Bengal Moneylenders Act. Milord, I am aware of the proposition that in case of 1 or 2, Milord, tranches of loan, the act doesn't apply. But this is a case is different, Milord. My lord, you'll see my affidavit, Milord. This person has filed, Milord, nearly 7 suits in this honorable court, praying for, Milord, recovery of money grant on account of loan. Milord, all these suits, existence of all these suits, that proves that he is in, Milord, the business of, Milord, lending money. So once, Milord, there are the suits are pending, that is proof, Milord, he is doing a business. So, Milord, the Bengal Money Lending Act will apply.
Where you have taken in the written statement?
Milord, we have in the affidavit, Milord, filed in connection with this application, GA3, we have even, Milord, given paragraph 5, Milord, page 5 in the GA3.
Page?
Page 4, Milord, it's the paragraph 5 start with page 4, Milord.
Yes.
Milord, will say, I further said the suit filed by the plaintiff is for recovery of money alleged to have been paid on account of loan to the respondent, and the present application has been filed essentially seeking a judgment and decree upon admission to the tune of 13 crore 39 lakhs 21,977, which comprises of principal amount purportedly given on loan and the interest thereon. I further said that the plaintiff is entirely engaged in the business of money lending within the state of West Bengal, and therefore comes within the purview of the definition of money lender as defined in under section 213 of the West Bengal Money Lenders Act 1940. The fact that the plaintiff is engaged in the money lending would further be apparent from the fact that the plaintiff has instituted several proceedings before this honorable court against persons and or entity for recovery of money. Details whereof are the given in the different suits are pending are given below, Milord. Now, Milord, CS 6 of 2022, Surendra Singh Bengani versus Jagdish Kumar Gulati. CS 77 2021, Surendra Singh Bengani versus Vikash Bed. CS 88 2021, Surendra Singh Bengani versus Sham Sundar Mundra. CS 50 of 2021, Surendra Singh Bengani versus Jaideep Halvasia. CS 7 of 2022, Milord, Surendra Singh Bengani versus Madhukar Nawalka. And Milord, CS 9 of 2020, Surendra Singh Bengani versus Sunil Marwa alias Sunil Kumar Marwa. The number of the suits involved in the plaintiff involving monetary and financial matters, including the money lent and advance, would suggest that the alleged and purported loan advance to the defendant for recovery on loan whereof was been short for in the present suit is not a single isolated instance of money lending. The aforesaid suit filed the plaintiff and the further conduct of the plaintiff would also suggest that the money lending activity of the plaintiff is systematic, regular, repetitive, and continuous one, and the same is being done by the plaintiff in order to generate revenue by way of interest, Milord. I further say, Milord, then, Milord, I have taken plea of. No, Milord, my first defense is that since, Milord, still apparent from the proceedings, records of the proceeding that he has filed, Milord, at least 6 suits, which we have come to learn, Milord. A person who is engaged in the business, all that, Milord, he has said that it's for lent and advance. Therefore, it is not a case, Milord, where in 1 or 2 occasions he has given loan, where, Milord, the section 13 of the Bengal Money Lending Act does not apply. But this is the case, Milord, where, Milord, the Bengal Money Lending Act would have an application. Milord, the second part, we have also come to learn that is on a subsequent time, after we have filed the written statement. If your lordship see there, Milord, the application, that page 26 is, Milord, the application for transfer under the RTGS, Milord, that they have annexed as page 26 of the GA3.
Application?
Yes, in the application.
Page 26.
26, yes. Milord,
Yes.
My lord will see, my lord, the account type and number of cash. Account number is given as 9100100172745707. This is the account now. My lord, now, my lord, we have come to learn they have, my lord, filed an affidavit in a separate proceedings, my lord, where this plaintiff has stated that he has no control over this account. না না ওই যে এটা বাদ করে গেল না অ্যাস্টেরিক্স Milord, may I just hand over, Milord, a copy of mine, Milord? It's respects the order copy. কত page? Judge, Milord. It is your lordship's order, Milord. At page 7, Milord, your lordship says, Milord, quoted their affidavit. Page 7 of the internal page. The contention raised by the plaintiff in the affidavit in opposition filed by the defendant in connection with the defense statement. Milord, then paragraph D, Milord. Mr. Shurana had the registration with the any stock exchange to act as a stockbroker. My lord has got. Yes, my lord. Exchange stockbroker. However, since 2005, he conducted a part of his business of stock trading through me as my client. This is, my lord, his client's affidavit. In this process, separate bank accounts were opened in my name from time to time with various banks, namely Corporation Bank, Canning Street Branch, ABN Amro Bank, India Exchange Place Branch, IDBI Bank, Park Street Branch, IndusInd Bank, Theatre Road Branch, Karur Vaishya Bank, Shakespeare Sharoni Branch, and Milord Axis Bank, Sharad Bose Road Branch, which is, Milord, I have shown, Milord. This is the Axis Bank, Milord. And Milord Kotak Mahindra Branch, Lardon Street Branch, to the name of few. Mr. Shurana used these accounts for which were in my name to trade his stocks and conduct his business of accommodation of loan. At all material point of time, the bank accounts were under the control of Mr. Shurana. The blank checks and blank RTGS forms signed by me together with the passbook and all relevant documents of the bank accounts were kept under the custody of Mr. Surana at his office. The books and accounts of the statutory liabilities were also maintained by Mr. Shurana from his office. In May 2010, Mr. Shurana instructed me to open a bank account with Axis Bank, Sharad Bose Road Branch, a bank account having account number 91001-00172745707. Milord, the same account number. Hereinafter referred to as the said bank account was thus opened in my name. Mr. Surana was already maintained a separate account in this bank. In addition to that, the companies where he was a director, the other directors of the companies and his HUF also maintained a separate accounts with the Axis Bank, Sharad Bose Road Branch. The account was used for the same purpose of stock trading and providing the accommodation loan. The bank checks and blank RTGS forms signed by me and all relevant documents of bank account was similarly kept under the custody of Mr. Shurana. Milord, this is a defense he has taken, Milord, in a suit were filed against him, Milord, for recovery of money, saying that, Milord, the amount he do not have the control. In the present case, Milord, he says that he has issued a RTGS from the same account to me, Milord. This, to my humble submission, Milord, once he has admitted in a different proceedings in an affidavit that he do not have the control, and the stand taken by him in the present plaint where he says, Milord, he has lent an advance, Milord, is a contrary stand, Milord, in a judgment upon admission case, this, Milord, should not be taken cognizance of. Now, Milord, my learned phrase has relied upon accounts confirmation, Milord, which is appearing from page 86, 80, 85, 86, 87, Milord, of, Milord, the application. It is my specific case, Milord, in my affidavit in reply, Milord, these are not signed by me. My lord will get that defense, Milord, at page paragraph. Even in the written statement, we have taken this, Milord, at affidavit, Milord, page 19. I have said disputed, Milord, of my affidavit, page 19, Milord, the accounts confirmation dated 1st April 2016, 1st April 2017, and 1st April 2018, appearing at page 85 to 87 of the said applications, are not signed by the defendant. In other words, the signature appearing in the accounts confirmation are not the signature of the defendant, as such the same is not binding upon the defendant.
Yes.
In response to this pleading, my lord, in paragraph 11, my lord,
Yes.
in response to my denial, my lord, his only stand is that at paragraph 11 of page 7 of his replies, my lord, that it has been issued under the authority of the representative.
Paragraph page.
My lord, page 7, paragraph 11, the bottom portion. It is stated, my lord, 1, 2, 3. Fourth line from the bottom, my lord, page 7. It is stated that the confirmation of accounts issued by the defendant have been signed by her authorized representative, and there is neither any alleged fraud or no particulars pleaded in the said affidavits. My lord, my specific case in the plaint, he has said, my lord, it has been issued by me. When I deny that, he say, my lord, it has been signed. My lord will see, my lord, he's pleading to the while he has, my lord, annexed, my lord, these documents. My lord, page 14 of the application, paragraph 8 of the plaint, he says the defendant has from time to time issued confirmation of accounts. Page 14, my lord. 14 of the applications, which, my lord, yes, that is my lord, page internal page 6 of the plaint.
Yes. Page 14.
Says the defendant has from time to time issued confirmation of accounts for the financial year 2015-16, 16-17, and 17-18, and confirmed the outstanding balance to the plaintiff. The confirmation for accounts for the financial 15-16 issued by the defendant to the plaintiff clearly shows that the plaintiff has admitted a sum of rupees 677,51288 as on 31st March 2018. He says on the plaint that I have issued. When I deny, my lord, he changed his stand, and then, my lord, says that it has been issued by the authorized representative. He do not name, as my lord, he submitted it, it has been given from the defendant. Then, my lord, he ought to have named, my lord, from whom he has received. When, my lord, I have disputed my signature, my lord, this cannot, my lord, be treated.
But the amount is admitted by you in the
I
written statement.
am coming to that, my lord. If my lord will see the first at page 85, there are several transaction has been mentioned in page 85.
Not this. I am not on confirmation. With regard to the amount 677, you have admitted in your written
Milord, that Milord, I have I'll show Milord that is I have demonstrated make out a case, Milord, that is for the purpose of Milord, a sale of a particular piece of land. Before coming to that, Milord, I am showing Milord, so far as this confirmation of accounts is concerned,
okay.
My lord will see, Milord, he has given various entries, but these entries does not form part of the bank statement.
Which entry?
Milord, page 85,
Hmm.
my lord will see, Milord, the particulars 3rd August interest paid on loan, 68,055.
Yes.
Then in 3rd August interest paid on loan, 614.
Yes.
3rd August interest paid on loan, 83,984. There are no entries, Milord. I may be correct me if my understanding shows, Milord, I have checked. These are no entry on those dates. Again, Milord,
in the bank account.
In the bank account, they have enclosed bank account for those years. Again, Milord, 2nd December 2015, interest paid on loan, 38,014. Up to, Milord, all the 2nd December entries, that is not matching with, Milord, the bank statement. There is a match with regard to 19 December 2015, Milord, that 35 lakhs, which, Milord, they have paid, but all these interest
35 lakh is matching.
Matching. At page 53, it is appearing.
35 lakhs.
Yes, but all these entries doesn't match.
Page 53.
35 lakhs is at page 53, Milord. But all these entry doesn't match. The rest.
Yes.
Again, Milord, if your lordship see on the left-hand side, 23 lakhs, Milord, they have said, Milord, 2 lakhs, 1 lakh, 6, these also does not match. Milord, on the top, left-hand side. So, Milord, these document, when, Milord, they are relying on the back statement and the entries doesn't match, Milord, and on the face of the fact that I have not signed on it, Milord, this cannot be, Milord, treated as a acknowledgement of, Milord, any amount, Milord, the loan payable to them.
Yes.
The other portions, Milord, he has relied on, Milord, are the ledgers. These ledgers which are appearing from page 88, 89, and 90, Milord, these are not even signed by anyone. These are the ledger of the my lord, the plaintiff, not even signed by the plaintiff or my lord, any chartered accountant. So, my lord, this document, my lord, has no, my lord, evidentiary value before your lordships. Page 88, 89, up to 91, my lord, these ledgers are there.
Yes.
Now, my lord, coming to the, my lord, the defense, my lord, on merit which I have taken, my lord, your lordship would see, my lord, there are other application. Initially, when this application GA1 was moved, my lord, on a voluntary basis, we said, my lord, in order to, my lord, avoid all this, we are ready to, my lord, secure this land because, my lord, that is the land, my lord, which was the subject matter of the discussion for transaction. That is my constant. And from, my lord, the affidavit, I have also filed an affidavit, my lord, in GA1. I have taken the plea, my lord, that this land was ready and available to us, my lord. Since they were asking for return, my lord, we have said that you can purchase it. The value was fixed. I have pleaded that. Value was fixed. He had inspected them. Now the issue was also cropped up, my lord. This is a, my lord, a joint property. My son, who is also a co-owner, my lord, we have pleaded that he said, my lord, he will also transfer his undivided portion. My lord, thereafter, my lord, in order to show, this is, I say, my lord, from 1st April 2018, my lord, this loan account has been converted to as a, my lord, the advance. Now, my lord, will see, my lord, in order to, my lord, give an effect. Before that, come to that, my lord had also seen, my lord, there is an income tax notice pending asking money, my lord. I have specifically pleaded when I have received this, my lord, the notice, I went to them that this is the notice I have received, my lord, what should I do? He says, my lord, that I'll be preferring an appeal. You don't have to worry. We will proceed with, my lord, the sale transaction. And that is the reason, my lord, thereafter he has made 2 trans payment. That is on December, my lord, if your lordship, he has given the chart, the last 2 payments, my lord, at, yes, the last 2 payments, that is on, my lord, 3/4/2018, immediately after, my lord, that my lord, paragraph, page 11, he has given the chart of loan payment, page 11 of the application. What today he is showing as loan payment on 3/4/2018 and 27/12/2018 of.
You're telling that the 2, 3, 4 and 27/12.
Yes, 1500 and 5 lakhs was in bad payment towards, me not the remaining payment to the land. That is my case.
Yes.
And Milord, while I'm showing this, where these amount, Milord, these say, Milord, just before that, add interest from 1/12/2017 to 31st March. I also do not find, Milord, this entry in the bank statement, Milord. So, Milord, if your now lordships, Milord, stakes, Milord.
May I just clarify one thing? The dates which are given over here in this chart are the dates which
you have prepared,
which we have prepared. Milord, these entries sometimes take 1 day or 2 days here and there to get reflected in the bank account. Milord, date is the date when we have dispatched, or date is the date when we have received the check. If it is credited in the bank, it may have a few days here and there.
Okay, no.
I'm making a note. I'll show you.
Yes, next.
Yes, Milord. Milord, the fact I have just stated before your lordships, I have taken that, Milord, in affidavit of GA1, Milord, which is annexed also in, Milord, the affidavit in GA3 at page 35, paragraph 10. With regard to the income tax, receipt of income tax notice, Milord. With reference to the contention, Milord, made paragraph 11, I say that save and accept what are the matter of record, my lord. That I say that the notice dated 14/3/2018 issued by the income tax authority received by the respondent on 23rd March 2018, and immediately upon the receipt of the statement, the respondent had contacted the petitioner, whereupon she was informed that the petitioner is taking steps to filing an appeal against the demand of income tax authority, and the petitioner had further assured that the petitioner would proceed with the agreement for sale of land, and in order to show his bona fide and to gain confidence of the defendant, the petitioner has made a payment of rupees 1,50,000 on 3rd April 2018 and 5 lakhs on 27 2018 in furtherance of the agreement between the parties. I further say that since on 12th March 2018, an agreement was entered into by the petitioner and the respondent for sale of a plot of land, and as of said, the question of payment of income tax authority in terms of the aforesaid notice dated such and such does not and could not have arisen at all. I have not paid because, my lord, this amount, my lord, which they are today, my lord, seeking was adjusted against the price of the land. My lord, I have also, my lord,
the land was deed was executed.
Deed, my lord, they have instead of, my lord, executing a deed, my lord, and paying the remaining amount, they have filed the suit. That is, my lord, the immediately.
But the court is recorded otherwise.
My lord, court has recorded that was, my lord, done, my lord, on the first day before, my lord, filing an affidavit. The court, my lord, on the first day, my lord, when the learned counsel, my lord, says, my lord, without going into that.
You're not file an application for recall of the order.
My lord, my lord will see, my lord, the orders, my lord, which are there. Lord, on 17th February 2022, the first order, where from all these, my lord, comes in, that is our, my lord, volunteer. There is no direction prior to that. We have voluntarily, my lord, submitted before the court. We are ready to, my lord, secure this land. Since, my lord, it is the subject matter of the dispute. My lord, on 17th February order, my lord, we'll see Mr. Shah has submitted that there is a piece of land with regard to which discussion are going on between the parties for transfer of the same in lieu of satisfaction of the amount claim. So these also records in suit in the suit particulars the same shall be provided by the Monday, my lord. Since, my lord, this suit land was the subject matter of transaction, my lord, we voluntarily say if your lordships, my lord, wanted to secure anything, let it be secured. Prior to that, my lord, there was no direction by this honorable court to give any security. Now, my lord, all this come, he says, my lord, since he wanted to, my lord, avoid this transaction by filing this suit, that was, he said, my lord, it's a joint property, I cannot take. Then court says, my lord, you file the affidavit. In the affidavit, we take the steps, my lord, as well as, my lord, in the written statement and this affidavit, my lord, we are maintaining this stand. So, my lord, that fact that we have offered doesn't admit, my lord, that there, my lord, only provide that there was a, my lord, the transaction was going on, which they are, my lord, trying to take shelter. And, my lord, so far as, my lord, they have said, my lord, that they have written a legal notice, my lord, asking for demand. In the affidavit, we have taken the plea, my lord. My lord will see, my lord, the dates of those legal notice, my lord. It was issued sometimes in January 2021, and, my lord,
January 25th.
Yes, my lord. And 25th, my lord, 3rd March 2021. My lord, my plea is that, my lord, my lord knows, my lord, that time, my lord, the second wave of COVID was going on. And that is why, my lord, the defendant, my lord, could not have taken steps to give reply to this matter. And immediately after, they have filed the suit. So, my lord, after the filing of the suits, there is no question of, my lord, giving any reply to them. Since they have already filed the suit, my lord will file that at, my lord.
Yes. July 21.
Yes, my lord.
Next, anything?
My lord, that's, my lord, submission.
Judgment, anything you're saying?
My lord, today we have received this judgment, my lord. If your lordship done, my lord, these are on the question of, my lord. Yes, my lord, question of, my lord, the acknowledgement. My case is that, Milord, he says here, Milord, the last judgment on 1971 1 SCC, Milord, there was, Milord, the nature of acknowledgement, and he has cited, Milord, Jaideep Halhas. So say, Milord, in those cases, Milord, there was TDS certificate. There, Milord, there is no TDS certificate. There is the account confirmation which was not denied.
No, denied, but the court has not
Milord,
accepted.
here, Milord,
Court
I have
has taken as a first round of first line. You see
yes,
the first
but
word of the
in
court.
my case, Milord, I have denied, Milord, and Milord, I have shown, Milord, this, Milord, the entries doesn't tally. And my, Milord, the main defense of mine, Milord, that after, Milord, 1st of April, it has been converted into an advance, which will prove that it was an advance because, Milord, if a person has grant me 10 crores rupees of an order and loan, I am not paying him. Will he pay, Milord, another 6.50 lakhs? Unless, Milord, there is an agreement to show that where he wants to get, Milord, the land and for this. Otherwise, no prudent man would have paid, Milord, without when he's understanding that I am unable to pay. And I say, Milord, it has already been intimated. So there is no question of making, Milord, the payment back. These are my submissions.
Yes.
Milord, according to us, Milord, as on date, there are no, it actually yes.
Milord, the two things, Milord, if your lordship desires me to give
15 lakhs.
the corresponding page numbers to these entries, I can, but I may just indicate from the confirmation of accounts that they are referring. Milord.
What about this West Bengal money
Milord,
lending?
your lordship's order is there, and I was most certain that this point may not have been raised, but since this point has been raised, Milord, I am relying on your lordship's judgment. Which is reported in 2023 Supreme Court cases online, Calcutta 1881. Kanchan Devi Kochar versus Jaideep Halwasia. 1881. But before coming to this, Milord, judgment, just one point. This, Milord, this order has been shown to your lordship. This relates to a completely different set of facts. Milord, the facts borrow.
No, he is not about the facts. He is telling that the same account which you're relying.
The same account, one party has said in one particular proceeding through an affidavit that the account is not in his control. And over here he's saying that the account is in his control. Now the entire cost papers of those of that particular suit is not before your lordship at the moment. And it would, Milord, be quite unjust
affidavit
to go into just the order and without going into the pleadings and what was the contentions of it. Because parties are different and contentions were different. This application also seems, Milord, to be a different application, not one for judgment upon admission. That is my submission with respect to this. Now, Milord, it had copied in the. May I hand up? The Kanchan Devi Kocha, I have to copy. May I draw your lordship's? This is, Milord, while I'm addressing the point of Bengal Moneylenders Act. Milord, kindly takes up page paragraph 10. Even in this particular suit, while your lordship was passing the judgment, Milord, had multiple transactions. Paragraph 10. Mr. So-and-so has also raised an objection with regard to the limitation and submitted that the transaction was made in the year 2016. Lastly, the payment was made in March 2017, but the suit was filed in August. So, Milord, clearly transactions more than one, not one solitary transaction. And Milord, then I'm not, Milord, traversing your lordship. Your lordship is the author. This, Milord, your lordship has gone into great depth. And ultimately, your lordship has, Milord, taken into consideration several judgments numbering exceeding 10. Your lordship finally has, Milord, in paragraph 25, your lordship has held that 25, which is at page 10, as regard the license for lending money have been decided in preceding paragraph, the defendant has not denied that the plaintiff had lent money in advance to the defendant, but the defendant has taken defense that he has paid the interest as well as principal amount in total in early 2019 to the broker of the petition in cash and the receipt of the notice. Immediately, the defendant has replied to the plaintiff and the defendant has taken the plea for limitation. The defense taken by the defendant with regard to repayment of amount to the plaintiff through the broker in cash of rupees 50 lakh is without any documentary evidence. And the defendant has also mentioned that the said broker was not known to the defendant. This part of the defense of the defendant has no defense, or the defense setup is illusory or sham or practically moonshine. It's a beautiful alliteration by your lordship. It comes out. As regard the point of limitation raised by the defendant himself has admitted that in the early 2019, the defendant has made entire principal amount of rupees 50 lakh in several tranches to the person assigned by the plaintiff, and the suit is filed by the plaintiff in 2020. And in the month of April 2018, the last interest was paid. Thus, the point of limitation raised by the defendant is also a frivolous and vexatious point. Ultimately, your lordship goes on to pass, my lord, a decree on admission.
No, with regard to the money laundering,
Yes.
paragraph 22.
Yes, my lord.
Come to the paragraph 22.
In the present case, it is admitted case of the parties that the defendant through a broker approached the plaintiff for financial assistance of rupees 50 lakh, and accordingly the plaintiff had agreed to pay the said amount at 15% per annum. Neither it is the case of the defendant that the defendant is running the money lending business, nor it is pleaded in the affidavit in opposition that the plaintiff is running the business of money lending. It is a specific case of the defendant that only one occasion the defendant had borrowed the amount from the plaintiff through the broker, and subsequently the defendant had paid the said amount in cash through the broker. Thus, in view of the judgments reported in such and such, the Bengal Money Lenders Act is not applicable in the present case against the plaintiff.
Yes.
Now here, my lord, the point which is taken, and I have shown your lordship from the factual that there was more than one transaction. Here, Bengal Moneylenders Act, the point which has been taken over here also, my lord, is under the, behind that, my lord, there is a clear admission of money being received. There is a clear admission to 6 crore 77. There is further a clear admission of repayment of 3 crore 60.
That is there.
So one or multiple and showing instances may not suffice. And most important, it is not applicable to RTGS. Your lordship already is aware of that.
Yes.
And RTGS forms have been shown by my learned friend to your lordship, specifically which was disclosed by us along with the Bengal Money Lenders Act.
What the document here relied he has referred
Yes.
for.
Now, my lord, one small thing. Since this point was raised, I'm aware that 3 o'clock is there, my lord, but just I'll take one more minute. My lord, kindly takes up the account confirmation, which is at page 85. My lord, your lordship can just take a note of the page numbers. I have already shown 23 lakh, which is at the debit side, my lord.
Yes.
This page number I have already provided. 2 lakh, my lord, is at page 49. I'm again not taking your lordship.
Yes. And 23
One,
lakhs? 23
yes.
lakhs page number?
23 lakh, my lord, 23 lakh. 23 lakh is at page 49.
49. And 2 lakh?
49.
Both.
49, yes, both. Because it is very close, same day.
Yes. Yes. Okay,
Then, my lord, 1 lakh 63. This is, my lord, the summation of the interest. Because on the right hand side, your lordship is finding the interest, summation of interest. It is at page 50.
Yes.
This entry, 3rd August 2015, I'll just show this to your lordship once.
Yes.
Kindly takes up page 51, my lord. This is, my lord, what happens when, because the entries get reflected after a few days. My lord, the last entry from the bottom, my lord, 3rd last entry from the bottom. 5th August 2015.
Page
the amount
number?
is there.
Page number?
50.
Yes.
The 3rd last entry from the bottom.
1 lakh 63.
Yes. And your lordship will find, my lord, it is credited on 5th of August. But we have written the date as 3rd because that was the day when actually in hand we had received it.
Okay.
But it got reflected. My lord, 7 September 2015, 25 lakh, that is at page 51.
Yes.
Again, December, this is, my lord, 10th of December. The print is off because of the Xerox.
Yes.
That is at page 51. So, my lord, in this way, this goes on.
And what about this amount?
The interest again, my lord, is accumulation. Because interest from 2nd December till 2015, 2nd December 2015, and also 2nd December 2015
This
adds up to 9
This
lakh.
interest
13.
has been shown in the account?
No, these three add up to 9 lakh 13.
Okay. In the year.
Yes, that's why they are debited. It's shown in the credit.
Okay.
So they are added, and 9 lakh 13 is paid, and that is at page 51. Page 51, that is the entry in the middle. So below these amounts are very clearly shown in all the.
Page 51 is 25 lakh.
My lord, page 51 kindly takes up page 51.
Yes.
25 lakh I have already shown, my lord. 7/9/2015.
And I have not denied, my lord, so far as left turns.
15 lakhs and 25 lakhs. Yes. So 9 lakh 13,000.
Just a moment, my lord. 9 lakh 13,000 টা কোথায় গেল? তো দেখলাম তো। দাঁড়ান দেখেছি আমি। পরে। Wait. My lord, kindly comes to page 54. 54.
Yes.
And your lordship will find this figure on 10th of December,
Got it.
2015.
Get
My lord, 9 lakh 13,000.
Yes.
So, my lord, this is the explanation. And in this way, all the amounts will be shown in this entire set of bank statements. This is an unbroken set of bank statements.
That's all.
My lord, those are my humble submission.
My lord, only with regard to the judgment line of just last shown, my lord, I am relying on paragraph 22. Your lordship has held that 1 or 2 tranches here, my lord. At least in this particular case, there are several. He has given it at 10 crores in several tranches, and there are other suits pending, my lord. So, my lord, your lordship, yes, my lord.
Census and suffering for the plaintiff. Census and suffering for the defendant. Plaintiff has filed an application being GA3 of 2023. Praying for judgment on admission. Hearing concluded.
My lord, may I just indicate one thing?
Just
There are two
oh,
GAs, my lord. One is GA1, my lord. One is, my lord, is hard GA3. Whether, my lord, GA1.
The necessity of GA1 would arise
If it is
you
allowed,
will not get a degree.
if it is allowed, then automatically over. If it is not allowed, then it will be.
My
Just, my lord, one humble submission. The judgments which I had, my lord, cited have not been distinguished. And that
He has
also.
relied upon.
Yes, but the judgment of the division bench which I had, my lord, shown specifically on the point.
No, he has
of
telling that
forgery.
with regard to the judgment, because in that.
No, lordship
This
judge,
also, my lord,
I'm on
there
the
was an
division
issue-
bench presided by Justice Shonji Panin.
Yes, my lord, the same that
has not been,
judgment, my lord, which has been went up in appeal, my lord. There is issue, my lord. I have said, my lord, why I, my lord, distinguish, my lord, on facts.
Lord, I'm deeply obliged.
Thank you. Yes.
In this matter, my lord, the advocate of the plaintiff is suffering from hydration, my lord. Hydration, my lord. In the morning, I mentioned the matter. But adjournment, your lordship told me that when the matter is called on, then mention it. So that pray not this week, my lord.
Why not?
The advocate is suffering, my lord.
On the last occasion, you have made a submission. The matter is to be fixed today.
My lord, definitely mentioned, maybe doubt, no, maybe, but it is suffering from
The
hydration.
other side.
My lord, I am not opposing the prayer of adjournment, but before that, my lord, something needs to be straightened out. If my lord sees the order of 13th of February 2024,
I am there only.
yes, my lord will see that such and such appearing for the defendant and it could not be taken up. My lord will kindly see the order before that, 5th of January 2024. Has my lord seen the 5th January order? My lord will see that the witness action was concluded and the suit was fixed for argument.
Correct.
Now, in the meantime, my lord, we were served with a copy of the application being GA number 3. My lord, which was supposed to be moved. This is not even an application for issuance of subpoena. My lord will see it was supposed to be moved before my lord. We checked the case status report. It shows that GA number 3 is disposed of, but I do not find any order passed by my lord. So today I am utterly confused as to
What
whether
is the GA3?
The issue is the subpoena, my lord. Subpoena.
Safina.
That has been issued against the
after
witness,
the
my
suit
lord.
is fixed for hearing,
Who has
argument.
issued?
Your lords, before you, my matter was moved before your lordship.
Safina was issued.
I can't say the order, they can.
Might be master. You have taken from the master.
Sir, how can it go with the master when the suit has been fixed for argument by the court?
Cannot. Yes, it's the master. It is not in the court. How it is the master is
But forwarding letter, it is said that it would be moved before my lord. My lord,
it is not listed, but the GA3 is unlisted.
Yes, and I checked the case status report. It shows GA3 is disposed of.
By which order?
I can't say, my lord. I will inquire from the advocate.
I would humbly submit if my lord adjourns the matter today. I am not opposing that, but it should be fixed for arguments, my lord. Arguments of the suit. I've got judgments to show that once the suit is proceeded to
Yeah,
argument, it cannot be
Ankush,
done like this.
See J3 का क्या status दिखा रहा है?
এই তো দেখছো তো disposed of দেখাচ্ছিল তো। দেখাচ্ছে? Status. এই তো GA3 is disposed of on
29th February.
February disposed.
When?
I do not see any order of
The order is
29th
there.
February.
29th February? 29th February order is there? No. No order. That is 13th February last order.
And if it is indeed passed by my lord, that such an order is passed, it is absolutely without jurisdiction.
Correct. Record an order. When it's showing the disposal? 29th February. So and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. Counsel for the defendant has submitted that the defendant has received a copy of application for subpoena filed by the plaintiff on 8th February 2024. The said application for subpoena is marked as IA J3 of 2024. Counsel for the defendant submit that in the system it is showing that GA3 has been disposed of. GA3 of 2024 is disposed of. To confirm the submission made by the counsel for the defendant, this court also checked the set order from the system of this court and found that the GA3 of 2024 is showing as disposed of, but there is no order is available on the website. Full stop. The registrar originals are directed to submit a detailed report before this court as to how the GA3 of 2024 with regard to issuance of application for subpoena was registered and disposed of. Let the report be filed before this court within a week.
Only one request, my lord. My lord will kindly also record that by my lord's order of 5th of January, the suit was fixed for arguments.
That I will
after closure of witness action.
Let the matter appear on within a week, na? 16th of April 2024. No, that 1 week. Today we are in 11. 22nd of April 2024.
Grateful to my lord.
Yes, call the matter.
May I take back that?
Take back. 23rd.
Grateful to my lord.
Why 7? Yes. I can't hear you, sir. Please use the microphone. Yes.
My lord.
Yes.
Now, actually, matter in question already concluded, both sides.
Correct.
Now, only thing situation compelled me, subject to sanction by my lord, that there is a little bit confusion as fallen from the my learned friend appearing for the other side, that regarding fixed deposit. Last occasion, your lordship has passed an order 21st March 2024, directing to issue a check of 10 lakhs.
Correct.
My lord, we have complied with. My lord further directed the concerned bank to submit report. They have complied with. Now, my lord, it appears that fixed deposit in question, which stood in the name of deceased, my lord, they have totally, my lord, withdrawn. It has been stated. I need not require, my lord, because that is part of the document, my lord, handed over to my lord. And so far auditor report is concerned, my lord, I told Mr. Ghosh it's not required. When it is before my lord will, before the judgment, obviously consider this same.
That's all.
Your lordship will consider all the document. It's expected, naturally, no good of use to waste the court's valuable time.
If you are having any doubt that this court will not consider the document,
No. Who am
just
I?
a minute, let the court complete the word. If you are having any doubt that this court will not consider the document available in the file, I am releasing the matter before.
I'm sorry, my lord.
So
I'm
why
sorry.
you are telling this? You
Sorry.
think that this court will consider all the documents? It is the duty of the court. When the court has fixed the matter for the order, the court has to consider all these things.
Now, may I tell?
It is not a bar to say that the court may consider or may not consider.
No. Possibly, I am not in a position to clear your lordship. Kindly don't misjudge me. I told Mr. Ghosh, when the document in question before the honorable court, it goes without saying, my lord. So no need on the part of the Mr. Chaudhary to say regarding the report of the auditor.
That's already Mr. Chaudhary has argued and
Yes. My lord may not release, may not your lordship have that line. And long battle comes to an end.
What is the further for any submission?
No, my lord.
Yes.
Nothing.
But the only thing what we wanted to point out yesterday,
Yes.
with regard to the bank statement, my lord, but kindly have a look at that, my lord.
Yes.
My lord, kindly have a look. My lord, the account 30 lakhs was transferred to the account.
See, that's first you come to the letter dated 4/4.
Yes.
Correct. The point number 1, the fixed deposit receipt number has been credited to the account on 30th April 2005.
Lordship.
Correct. So there is no difficulties on that.
No.
Now second part.
Yes.
Second point. The fixed deposit was credited to the account so and so 30, and the said amount was not remaining in the account till 21st of April because the funds were transferred to SCSSA account. I don't know.
Senior citizen saving scheme.
Yes.
Okay. 10 lakhs on 3/5/2005, 15 lakh on 3/5/2005, and remaining through the clearance check and cash withdrawals. The statement includes. Where is this in statement?
But in my lord's brief, my lord.
This is relating to the 30 lakhs. This is relating to the 30 lakhs, which is the next thing. Data হচ্ছে in the 15 lakhs.
But for the 15 lakhs, there is a separate statement before your lordship, my lord.
That's all the hodgepodge they have given.
But may I find it out for your lordship, my lord?
Yes.
Thank you.
You also tally this.
Absolutely.
I studied it.
It is George Sherwood.
Lordship, may I just mark the documents 1, 2, 3, 4 by pencil?
I'm
Take this pencil.
not very. I have a pencil. I always carry.
Lordship, I have marked the letter 1.
Page.
And I have marked the interest quotient of 30 lakhs. I have marked that document as 2. And your lordship, the rest of it, I am marking it as 3 and 4.
That's fine, Millard. But one thing is very clear. Part of Millard fixed deposits, which we want to delete, were Millard went
That's
into
why
the
I wanted to clarification. That's nothing else. The other thing is already I'm on the concluded.
No, this
stage.
is, I must say, Millard.
Because kindly see the amendment application which you have filed.
Yes.
Page 40 of the affidavit of assets.
Yes, it's 3.
Correct. That is the 30 lakhs. No, page 49, 41.
For page 41, it's
41 of the affidavit of assets. Last one. 30 lakhs 5,589. This is the fixed deposit. So you wanted to delete this.
Yes.
Correct. Now second one is page 42. First 5,73,000.
Yes, Millard.
Correct.
And that's also withdrawn by the testator himself.
And now fourth one is the page 44. Page 44,
Millard,
that is the mutual funds.
43 also, Millard. There's a ICICI Bank.
43, you're not.
Oh, that I'm sorry, my mistake. That's not
44,
correct.
44.
44.
So these are the three entries which you have wanted to delete as per
Yes.
the amendment of application. Correct. So while passing the order, I find this is not on record.
Not on record. That's why your lordship
Why
wanted
all
to
this
see.
Yes.
No, no, absolutely.
As far as the 30 lakh
Milord,
is
this is
concerned,
what he's been doing for 6 years now, making Milord a mountain of a molehill. There is Milord.
perhaps not.
I have to
Perhaps
put my
not.
hand.
6 years. I was removed also once. I had it restored, Milord, before the division bench, where there is no issue. He creates an issue.
That I already taken all the things.
Yes. So
But
what
only
is
with
this?
regard
This
to
is no issue.
This is the only, yes.
Why is he marking 1, 2, and 3? It's clear that what I'm.
this is not hard by me. This is records
me
coming from the
clarify.
bank.
Let
So-
me clarify. Please, you take your seat. Yes.
Lordship will just take one document your Lordship had given in your Lordship's last order about an amount of 30 lakhs.
Correct.
That 30 lakhs has gone to the administrator's account.
Yes.
Lordship, so today they cannot ask for deletion of that amount in the affidavit of
What
assets
are you saying?
because that is the specific allegation. Your Lordship,
Please, Chaudhary, let me. Yes.
Mr. Chaudhary will kindly address when he has his turn.
No, kindly.
Yeah,
So that's why the 30 lakhs. This is the 30 lakhs 5,000.
Lordship, the 30 lakhs which has been there, 30 lakhs 90,920.14. This is what they seek deletion of in their affidavit of assets. Your Lordship will kindly take the application which is marked at 442 and which has been marked now as GA3.
Yeah, that's why page 41. Page 41.
Yes, my lord. GA3 page 41.
Page 41.
Lordship, that page 41.
These are the 3 pages which are the crucial here now.
Yes. Your Lordship has also placed that in your Lordship's last order.
No, all this is fine. Let him show that this was
but
there
Mr.
at the time
Chaudhary
of
cannot
death.
go on interfering every time
you
a submission
are
is made.
making
If a submission is made, that has to be gone. No, this is submission made by him.
Let me clarify. If you are any confusion, I will come. I will not shut the total case here.
That your lordship never does, my lord. This is all after CAV. I mentioned the matter, requested for a chance.
So
Your lordship gave me a chance.
It can't
No,
say that I am not giving.
We never say that.
Even at the time, the court so moto has put the matter as a to be mentioned and call for the report.
No. The only issue which I want your lordship to note before my learned friend submits is he has no allegation.
Not
Creates
allegation.
a hue about
Let
everything.
me clarify.
So what is wrong?
Please, not to take tension.
See this.
Not to take tension. Please take your seat.
I'm hearing this for 8 years now.
Please, you take your seat first. Let me clarify. Yes.
This is my learned friend's application. Kindly take page 41, the amount which is sought to be deleted. Your Lordship will take 30 lakhs 05,589. Categoric statement that this amount was never found. This has to be deleted. Your Lordship will take my learned friend's application. He says he's not made any submissions. Your Lordship will find at page 14 of that application, they have disclosed an FD which they say they have encashed. Encashed before the death. Your Lordship will now take the bank's report which has come forward. Your Lordship will kindly take the report which talks about this amount which has been credited to the executor's account directly. And the bank statement has also been disclosed.
Your Lord wanted to clarify which because
Lordship, this is the bank statement. I marked at item 3. It's been marked as 3 in that.
Item 3. Yes, item 3.
Has your Lordship got it? This is the statement which has been disclosed by State Bank of India.
Let me go to item 2.
14 was equal to 39. Where is 39?
Yes, 3.
Has your Lordship got it?
Yes.
The debit amount 30,920.14. This is the amount which is transferred.
Item 3.
Lordship will find 29th November. This is an amount which shows to have been transferred from the bank account.
2,22,557 debited.
Yes, my lord. And your Lordship will now find the statement of the executors, which has also been disclosed.
मुझे वो कौन सा देखा नंबर ये मिला
Your Lordship has found that statement of the Shonali Datta administrator, which has also been disclosed from 1st April 2018 to 31st March 2019.
Page?
Your Lordship will take second page of that.
No, no, which page number have you in?
Lordship, it's the second page.
No, no, have you marked which mark?
Yes, it has been marked, I believe, as 4, my lord. It's the statement of
Yes,
Mrs.
4.
Sonali Datta, administrator.
4, yes.
Your Lordship will take the second page of that.
Yes.
The fifth entry from the top. The credit amount 30,90,920.14.
Correct.
This is a statement which has also been disclosed by my learned friend clients, admitting that this amount has gone into her account today. It is sought for to be said that no, this money was not received. I do not know how submissions are made contrary to record.
I will tell you, don't make allegations.
No, this is not to be done.
Please. Yes, 30,90,000, 29 November 28 transferred to the transfer death of account holder. Yes.
So it has been received by the administrator, and today what is being sought? An application is filed for correction of the affidavit of assets, saying that this money doesn't form a part of the estate. Lordship, I believe this has been numbered as GA3.
Yes.
Your Lordship will kindly take the prayers of GA3. Prayer A, the proposed amendments as indicated in red ink in a copy of the probate petition.
Correct.
Yes.
That's why I kept this, brought this again, because that has not been proved. That's why I brought this to bring the document.
And now the bank records show that the amount has been taken in the administrator's account. So the bank has disclosed the documents and it has all been. As far as the other amount is concerned, which was recorded in your Lordship's order dated 21st March 2024. Your Lordship, that other amount was for 5,73,021. Those, I believe, those accounts, the amount has been credited to the deceased account much prior to his death. So those have gone into the account. So that there is no dispute, that can be deleted. But as far as this amount is concerned, that is there.
Yes. So now, as per your submission, the 30 lakh was.
It's there in the administrator's account. That cannot be deleted from the affidavit of assets. That has to go. Lordship,
Any further?
Yes, my lord. As far as GA9 is concerned, I would just want to bring your lordship's attention to the auditor's report, which has been filed. Lordship, the auditor's report is at page 37. Your lordship will kindly come to page 42. Your lordship will come to page. This is lordship in GA9. Has your lordship got GA9?
Is the GA9? मोटा होगा. रिपोर्ट का चैलेंज किया वाला. That is exception of the report.
Yes, my lord. Yes, my lord. Push it again.
Page?
Lordship will kindly take the report, starts at page 37, the auditor's report.
Correct.
Lordship, the audit report starts at page 37. Kindly come to page 42.
42 years.
Lordship, today an exception is sought to be taken to this report. Kindly take paragraph D. Out of a total expenditure debits in the bank statements for rupees 1,73,83,819, 75% of the total expenses were without vouchers, invoices, supporting documents, explanations, wherever applicable. So, Lordship, pausing here for a moment, for 75% of this quantum of amount, which translates to about 1 crore 30 lakhs 37,000, there are no vouchers.
2 crore 34,000.
Lordship, I've just taken 75% of 1 crore 73 lakhs, which comes to about 1 crore 30 lakhs odd figure. 25% of it, they are able to show vouchers, which translates to 43 lakhs 45,000. Now, Lordship, pausing here for a moment, the only stand taken by my learned friend to the exception, the only exception taken is at, Lordship will kindly take, is under, what they say is the payments have been made by check. They have nothing to prove as to what the payments have been made for. It's just payments that they have made by check. Lordship, under the Succession Act, they are entitled to make expenses under certain heads. Lordship will kindly take the Succession Act.
That's why, because after taking the original side in this matter, I am afraid of how this type of the order is being passed. See, in the succession matters.
Yes.
For appointing the administrator has to be bound by giving the audit of every 6 months.
Yes.
Lordship, that's a part of section 314.
Yes.
It has to be done within 6
Accounts.
months.
Within 6 months,
And
and
within
every 6 months is as like a guardianship.
After my lord, probate is granted.
If the probate and administrator is appointed, then it has to be
After
no,
probate.
No. Even in the pending, if the administrator is appointed and allowed to
But the
utilize.
Act my lord says after, I think. I'm not sure. I'll check.
Administrator pendant light
Administrator pendant light in pending.
But there's no direction.
That's why I'm telling. After taking this original jurisdiction,
Yes, there's no
several cases I find.
Several-
but
all
I cannot-
cases.
All cases.
All cases.
All cases. And even though, as you have argued the matter and order was passed with regard to the grant of administration,
Yes, that other matter.
that is also wrong procedure. The security, that is only with regard to you have to submit the solvency and with the indemnity.
With an indemnity.
That is enough.
That is enough. Here also, no, it is a healthy practice. If you have to give accounts every 6 months, even as administrator pendenti later,
Nowadays, it is
and
very
it is
difficult.
it
Lordship,
is
it's a
not
different procedure for a probate, that bond is not to be given, but where an administration is granted, only then the bond is to be given.
Bond is given with regard to the security. That I find that the amount is being taken as a security. That cannot be. That is the indemnity with the security, whatever the land document, whatever that is to be as an indemnity with the two sureties.
Lordship, that is not followed in a probate, but in a letters of administration, it is
That
taken.
is to be followed.
If he's finished, I'll take 5 minutes.
Lordship, I haven't finished.
Next, yes. Yes,
Lordship,
which paragraph you are referring?
Lordship, I was referring to the law.
This exception, which paragraph
Yes,
you are referring?
exceptions I was showing your Lordship, page 42D.
That I already taken note of.
Yes, my lord. I was showing the expenses that I made. The only ground that they take as to why they are challenging is because everything was done by payment of check. The relevant is paragraphs. Your Lordship will find that paragraph C at page 3.
Yes.
Page 4, paragraph 7. Lordship, no vouchers are actually shown. What is said is we have made expenses by check.
Okay. That's all. Anything further?
Lordship, just two more things. One is I will just place the relevant provisions of law under which payments can be made. That is under sections 320, 321 and 322. Lordship, 320 is the expenses to be paid before all debts. This is the funeral expenses. There is a limit to which you can take. It's a reasonable expense, not all funeral expenses. The second is 321. Expenses to be paid next after such expenses, the expenses of obtaining probate or letters of administration. This is not the case because both have been granted. This is post that because the executrix refuses to release the properties in her custody.
Yes.
Including the costs incurred for or in respect of any political judicial proceedings that may be necessary for administering the estate shall be paid next after the funeral expenses and deathbed expenses. And of course, 322, wages for certain services to be paid next, and then other debts. Wages due for services rendered to the deceased within 3 months, next preceding his death by any laborer, artisan, or domestic. This is also doesn't come. Lordship, the scope of payment is very, very restricted. Lordship, there is another provision. Generally, when probate is granted, the person taking the probate has to be within the state. And if not, there is another person who can be authorized to take a letters of administration on her person's behalf. The relevant provisions are sections 241, 42, and 43 of the Indian Succession Act. Today, my learned friend's client is staying in UK, has taken the funds and chooses not to distribute the assets.
Okay, now I am not going on to marriage.
Lordship, one more thing I would like to indicate.
Further controversy.
There are expenses. I will just show and indicate why the expenses have been not vouchered for or not shown. Just one instance of where the expenses have gone. Your Lordship will find the legal expenses.
Solicitors.
Lordship, close to 40 lakhs has been paid as legal expenses. Which is not vouchered for and not justified.
That has been recorded.
I don't want to embarrass the other side by bringing more details into it. The details are present. I leave it at that.
Yes. Yes.
As I said, it's going on for 8 years now. I'm sure your Lordship would be feeling that these amendments, my Lord, are in respect of, my Lord, fixed deposits which have been appropriated. But, my Lord, the bank and official records.
Appropriated. That's why because
No, I'll show your Lordship. And, my Lord, this whole exercise was unnecessary. My Lord, please take page 41. Your Lordship has pointed out to me, my Lord, 41, 42, 44.
Correct.
Let me show your Lordship, my Lord. And I'll show your Lordship what he's doing. 41. My Lord, last, my Lord, please, my Lord, see the last entry at 41.
30 lakh 5,000.
Please see the number.
Maturity.
8160.
Correct.
Now, my Lord, State Bank of India's letter. Paragraph 1. 8160 has been credited on 30th April.
Correct.
Now, my Lord, page 42. First entry.
5 lakh.
Yes. And, my Lord, number is ending with 216.
Correct.
Please come to, my Lord, paragraph 3 of this letter.
That is debited.
Yes.
No, that's not. Now kindly come to
I'll show third one now, my Lord. Third one is 44.
44. That is the
44.
Mutual.
My Lord, E.
Mutual fund.
Mutual fund.
Yeah.
For that, my Lord, we have filed supplementary affidavit, pages 28 to 31.
That I have called for.
Yes,
That's why
and
on
he
that
has
day I
put
have
it.
given the.
Yes. So this is there. Now, what does he show your Lordship? He shows your Lordship an entry in the bank statement. My Lord, this, my Lord, if your Lordship comes to the third page of this bunch which he has handed up. My Lord, the figure is, my Lord, 30,90920.14. My Lord, please see the number. Number is ending with 309.
Which document you are referring?
My Lord,
Which document you are referring?
my Lord, here, my Lord, this third page of this bunch, my Lord, please. He's showing your Lordship this, saying, no, 30 lakhs. State Bank has wrongly said so. How is this third? He has taken 30 lakhs.
Yes, 30 lakhs.
That he is saying. But I have always said I have taken this 30 lakhs.
Only 30 lakhs. Now you come to the last page.
No, my Lord, am I asking? I asked myself the question. This 30 lakhs fixed deposit, am I asking for deletion? No.
Kindly see this.
No.
So where this 30 lakhs is mentioned in your affidavit? Assets?
This is accounted for. This is in the bank statement.
That I am not telling that. You are asking for deletion of this 30 lakhs. Okay, I will accept.
Not this, Lord, those three.
41. 41 you wanted to delete?
Yes, but
Correct.
41 is not the same as this.
That's why if it is not the same of this, I will go by you.
Yes.
But
No, your lordship will go by record.
then where is this 30 lakhs?
Accounted for in the accounts.
Where is in your affidavit of assets?
In the
Affidavit of assets, where that 30 lakhs is
Yes,
mentioned.
yes.
So
Yes,
that it
of
cannot be
course,
doubling.
Of
Cannot be
course.
double.
Absolutely. Milord, page 39.
Yes.
Serial number 6. Milord, now, Milord, I'm glad for the question because now, Milord, your lordship will, Milord, tally and please tally the number. Milord, please come to the account number right at the top.
Correct.
Milord, account name, address, date, account number ends with 526. See, Milord, number 6, 526.
Where is the
I'm not asking for deletion. It's accounted for.
Where is the 526?
Milord, at page 39. And on this page, which is repeatedly showing your lordship. Milord, first is account.
Not the 526.
No, Milord. May I see the page, Milord? This is the page I am seeing, Milord. Milord, may I put a small point?
Yes.
Milord, on the left, Milord, I have put. Milord, fourth from the top, small pencil dot I have put, Milord. Account number. Milord, ends with 526.
Correct.
Yes, and Milord, page 39, entry number 6 at the top. 526. Same, I have given. This is part of affidavit.
526.
Yes.
Correct.
Oh. সবাই উত্তেজিত. It is part of affidavit of assets.
No, then how this 30 has come?
Milord, may I now show? Page 39, serial number 6526. The original value, Milord, is recorded in the affidavit of assets. And this money has been taken into the executor's account. I am not asking for deletion. I have, on the other hand, this money is accounted for. He is not showing your lordship that.
That's correct. So now you come to the page 40.
Page 40?
41.
Yes.
Last account.
Yes.
Correct.
Yes.
3018.
It's, Milord, just the figure of 30 lakhs, which is, Milord, confusing.
Confusing.
But, Milord, your lordship would go by the account number, the fixed deposit receipt number and the account number.
Correct.
Milord, that is not showing your lordship. There's some responsibility council also has. Milord, please take the number of the fixed deposit. Now, please take the first page, SBI's letter.
See, this is with this 41 is not the account number. 41 is the fixed deposit number.
Milord,
41, that 30 lakhs is not the account number.
No,
that is
this
the
is fixed deposit number 8160.
8160.
8160.
Correct.
Now, Milord, please see.
So now that has been accounted in 1011. Kindly come to the first page. Letter of the State Bank of India.
4th April 2004 letter.
First one. That has been credited.
The FD number, let us, Milord, tally. Milord,
FD number is correct.
I'll just go to my note, Milord. Page 41 is para 2. Milord, please see para 2. The fixed deposit was credited to account number such and such on 30.
First paragraph 1. Paragraph 1.
Paragraph
Fixed
1.
Deposit
Yes.
receipt number.
Your lordship is right, Milord.
Yes. Fixed deposit receipt number
8160 has been credited to account number such and such on 2005.
That's why. Now this is account number. What is the account number? 101211568887.
Yes.
Correct.
Yes.
So 887.
But when? The testator is alive.
This court has asked for the report with regard to the alive, when the testator was alive, till his death.
Yes.
So till his death, he has given the report which are 30 lakhs. 29 November 2018. Whether this 30 lakhs 90,000
yes
is of this amount or this fixed deposit amount?
No. This, Milord, I'll tell your lordship. Page 41.
So what about this 111? What about this account number?
Milord, this 887. This is one.
Page number 1.
Yes.
Page number 1, serial number 1, the
Yes.
account number
Yes.
10121156887.
Right.
This is the account number?
Yes.
So what about this account number? What has happened?
Miller, this was the testator's account. Whatever
Yes.
was there has been taken into the bank account of the executor. And Miller, there was a balance of 12,52,000 which was taken as on the date of death.
That's why I'm asking. That's why
Miller,
the
that's
bank,
there in the account.
then the bank has to given the subpoena, let they have to appear before this court all report, and even evidence is to be recorded, nothing else.
Miller, evidence on Miller
of the bank, because now this account 2005.
Yes.
After the 2005, where the amount has gone? Where
Miller,
is that?
Miller, I can give your lordship the bank statement that on that date, on Miller, 6th of May 2022, 12,52,088 rupees came into the executor's bank account from this account. From this one, your lordship is asking
Where
for.
is that? Which number?
No, this is in the bank statement. I have the full State Bank of India statement with me. Milord, it's 12 lakhs. Milord, I think the third or fourth from the top.
12,52,000.
Yes.
Transfer, yes, 1187.
Yes.
6 May 2022.
Yes, and we've said, Milord, whatever the balance was has been taken into the executor's account. Now, Milord, after 2005, the executor was alive for several years. I'm sorry, the Milord, the testator was alive for several years. He spent his own money.
So that's why this account is required to be seen.
Yes, and look
This account is required to be seen when on the date of death.
How much was
How
there?
much was there?
That is evident from the bank statement. I'll give it to your lordship. Lordship wants to call the bank manager. Milord,
Give the account.
Milord, I'll just check, Milord, the first entry date from there. I'll give the bank statement. I have it with me. Date of death কত ছিল? Date of death ছিল 18
17
Milord, 7 June 18 onwards.
17 date of
I can
death.
give that. 17 I can give.
That is the account of the testator.
Yes, I have it with me. আছে তো? আরে যে মারা গেল তার পরের দিন থেকে তো আছে তো ব্যাংক স্টেটমেন্ট।
That's why on the last occasion, well, 3 occasions, I am telling the same thing. He's not
I can get it.
understanding.
I can get it. No, I can get it. I can get it. There's no difficulty.
I do not know.
Lordship, the date is 21st April 2017. Your Lordship recorded it in the
Milord,
Lordship.
I don't understand one thing, Milord. Milord, I know your lordship wants to be sure. I appreciate that. I would hate a situation where, Milord, money has been taken away. It's not accounted for. Any direction to produce, Milord, I am ready and willing to honor, Milord, without even asking. I'll go try and get it. Otherwise, your lordship, Milord, directs them to produce, Milord. I'll be more than happy.
Because I wanted to finish it about
Yes,
for
but
all.
what I fail to understand and what I really don't appreciate is it's very clear, Milord, that this fixed deposit, to come back to the moot issue, this fixed deposit was, Milord, encashed prior to the date of death. Now, just because the figure is 30 lakhs, to show it and try to confuse it with something else is wrong.
That's why this court has directed the SBI to give the details as on date of the death of the testator and till date.
I request,
What I-
Milord.
what
No,
I think
nothing.
has
I am
happened
now
is
submitting. Your
My
turn
learned
is
friend
over.
has missed out the order.
No,
The order passed by your Lordship.
No,
based
no,
on
no.
which this has been
Your
disclosed.
whole argument has fallen. It was wrong. And Milord, this was a
This is your
incorrect
Lordship's
submission.
order. Communication to your Lordship, not to
Nobody
my
is
learned
wrong.
friend.
Because still the State Bank of India has not provided the
Let
total
them produce
details.
the full bank statements of all his accounts.
Now this account has come.
Yes, Milord, I had it with me. I
Give
could.
the account from 2017 to
That's
2018.
আছে তো sure আছে তো
2017 onwards আছে মানে
from the date of death. Do you have bank statement or not?
On
Milord,
the
better
date
to
of- on the date of death, what was the amount pending in the name of the testator?
Milord, I have the amount. I don't. If I say I have it and then I'm unable to produce, that's, Milord, wrong. Your lordship directs the bank to submit to forward the copy.
I have submitted, but they have provided.
Milord,
the
I will
values also not-
communicate I will write to them and ask them to produce it. We have communicated with the bank subsequently. We'll show the order and get it. There are no
But
two
that
ways
way,
about
otherwise
it.
I have to issue the direction to appear before this court all documents.
They'll have
so
to
that,
come from.
that can be exhibited.
Yes, I have no difficulty. I have absolutely no difficulty. Now, no, 1 minute before that.
On, and time has been sought over
on and on.
again
You
for this.
you have disrupted
Lordship,
this proceeding for 8
this can
years.
be done on a very easy way. The executrix continues to hold money. Let the executrix deposit the money with the court. Then she can do what she wants.
No, now,
the
please
money
see.
cannot be siphoned away like this.
No, nobody is siphoning away any money.
Please.
Now, my lord, please take up
this
the.
court is not going to that.
No, now, my lord, please, I just request your lordship. My learned friend has shown your lordship an audit report.
You
Just,
do one thing.
Yes.
Your client is having all the details of the testator.
Yes.
You give me what are the accounts available with the testator at the time of death.
Yes.
Give it.
Yes.
Or the statement of account. Give it to me on the within a week. I am fixing it.
Yes.
If it is found, it is otherwise.
Yes,
I
there's
will
no
call,
difficulty.
Otherwise, I will call the bank
No,
officials.
I am
with all
ready
the
to
documents.
cooperate. Your lordship still feels the need. Then your lordship will
That's
direct.
why. That's why I'm telling. What are the accounts?
Give me the bank audit statement.
What are the accounts which the testator was having at the time of death?
This is all on record. I'll point out, but I'll prepare a chart and show your lordship.
And with regard to the when the amount was transferred in the name of the executrix and what are the amount has been spent. This is three things is required.
Now, my lord, just 2 minutes now. This maze which is created, my lord, I want to, my lord, pierce it. The smoke screen must go. My lord, please look at the audit report for once. This is not an auditor. His fees should be forfeited.
Yes. Which report?
My lord, please see, my lord,
Which
page
paragraph?
38 of the application.
Yes.
Audit report.
Yes, 38. Yes.
My lord, firstly, my lord, what is provided? Bank statements are provided. Then, my lord, payment vouchers, valuation report and professional bill, etc., everything. Now, my lord, after all of this, page 42, our observation. My lord, B, inadequate narrations in the bank statement.
That's first you read the A.
A. Bank statement of State Bank of India, Juhutara branch of the administrator Sonali Dotto from 7th June 18 to 30th May 23 was duly stamped and signed by the banker.
Correct.
Explanations were given by Sonali Dotto. No difficulty. Now, my lord, please see B. Inadequate narrations in the bank statement has limited our scope to identify payee and sources of receipts for all the payment receipt entries in the bank statement. May I pause here? I am in a bank check payment for the purpose of upkeep of the flats, for mutation, for payment of outstanding taxes, etc., for share transfers, check payment. Auditor says, I can't understand. You can't understand. Write a letter to me asking for an explanation. You don't do that. And my learned friend says...
That is not the objection you have narrated here.
No, I'll just show your lordship.
The objection which now you are submitting, that is not in the...
I missed that day. Your lordship gave me a chance.
Changing of advocates will change the point
No,
of argument.
I was there.
You were there, but now...
But on that day, I missed.
Now the fourth advocate is also appear before this court. That's why my...
I understand.
Is going high. Every day is coming one advocate and initial Mr. Mitra was argued. Then I have put some 3 questions. Then he bring you brought you. Then I put something. Then thereafter Mr. Bhaskar started. Then I put some question to Mr. Bhaskar. Now the 4th person has come. Now you have started raising another question.
No, just
in the exception.
Just 2 minutes, Milord. Just 2 minutes. There
is some limit, sir. There is some limit for the objection. The court is trying to settle the issue.
Yes.
Still you wanted to go on the merit, then it will be very difficult that this court, then if this court will pass appropriate order, what is to be done, then it is to be done.
Milord, I am also trying to settle the issue.
So you are every day you are bringing one objection. How the court can decide the matter?
I am not objective.
You have filed 3 objections, sir. I think you have not been instructed properly.
Milord, but they have not been brought to your lordship's notice.
What?
What
you are giving.
Very well, I won't say anything, Milord. I won't say. If it is, Milord,
this objection. Prior to this objection, they have filed an objection. They have filed an objection.
Very well, but
challenging the appointment of the
no,
auditor.
fact of
Prior to that, they have filed another
fact
objection.
of the I know it has annoyed your lordship, but the fact of the matter is the report is, my lord, incomplete.
That I will see. That I already
Today,
heard the
when my
matter.
learned friend,
With regard to the report, I am not going to. It is not. I can't say whether I will accept or. But I have heard the matter on merit of both the sides.
Yes.
Let's say I have not heard the matter.
Nobody says so.
Let they say that I have not heard the
So
matter.
today he addressed, so I thought I'll get 5 minutes.
No, you can, but you are taking a new exception now. That is not in the exception.
Give me 2 minutes, my lord. That's all I request. For the ends of justice, give me 2 minutes. And I won't take more than 2 minutes. Look, I actually won't take more than 2 minutes. Milord, just please, Milord, take page 42. Simple. Your criticism is bank statements don't show you where the money has gone. Your criticism is I haven't given you invoices. Why didn't you ask for explanation? Over.
He was at that over. That's correct.
I have everything.
Now, still today the bank and the court is also in confusion with regard to the account. Every day some new account is coming on record.
Milord,
every day.
no.
Kindly see now here the
Yes.
audit report whether he has submitted the account of the deceased. Kindly see whether he has submitted the account of the deceased. You are arguing the matter.
Yes.
Taking the exception. Let's see so the any document that he has given the audit
that is
account of the deceased to the auditor.
Milord, account.
What is the problem, sir?
But we have given the disclosures to the auditor because I'll tell you, Lordship, how. Because I have given the particulars of the executor's account, my account as executor to the auditor. That shows, my lord, transfer of all funds from the deceased accounts.
That has been transferred when? 2018.
Yes.
2017, he died.
Yes.
So 2017, what was the amount pending in the name of the deceased? Where is that document?
I can
That
produce.
is the only document.
I'll produce it.
On the date of the death. On the
I'll
date of
produce
death,
it.
what
Your
is the
lordship wants to
document?
be sure. I'll produce it.
Let you
I'll
produce
run around, get it and produce it.
produce
And my lord, before I part, at the risk of my lord irking your lordship more, I just want to make 3 sentences. Number 1, my learned friend's endeavor today has been that 30 lakhs has gone into his own account and he's asking for deletion of the same amount from the affidavit of assets. I have shown your lordship it's not correct.
That is
Number
the
2.
See, so now you are telling me with regard to the 27
Yes.
lakh.
Yes.
27 lakh. Now it has come as a 30 lakh 9,000 whatever
Yes.
it is. You are telling that.
So
with regard to this
12
this
lakhs
deposit, what is that?
accounted for.
That's why you
Account,
give
I'll
that-
show, my lord, I'll show. I know, my lord, we have not been up to the mark. We have not produced all documents. We have not been organized in our submissions.
Correct.
I argued the point of law and then, my lord, I missed the matter thrice and disappeared.
That's the
It's
point
my
of law,
fault.
The point of law which you have argued before this court with regard to the
But it is-
deduction, whatever be done by the executive, that cannot be taken from the executive. It is from the administrators.
But, my lord, thereafter it is my duty in a parted matter to appear and assist your lordship on the facts. I disappeared. I admit my fault, my lord. I was on legs. So, my lord, this is it. My lord, second issue is, I said 3 points. My lord, the point of law is, my lord, 1. It decides whether I can spend money from the estate. Whether, my lord, 2 daughters, England and France, you have to come. Number 2 is, my lord, what is the criticism?
See, Mr.
Criticism is...
Mr. Chaudhary, you are appearing in all matters. Sometimes criticism is something, it is going on. The court, what the court requires, the document.
Honesty.
That's all.
Court requires honesty.
You give that all these
Yes.
things. You give all the things that the matter ends.
I will.
Correct.
My lord, please keep it after 10 days.
Okay, no problem. But come with that. If you're not
If my lord,
if you're not able to get them within 10 days, you inform this.
I will mention.
Then you mention it so that I can pass an order calling the authorities before this court, bring all
I'm
the
grateful, Your Lordship.
clarification.
I want to clear the air.
That will grateful. So appearing for the petitioner, so appearing for the respondent. Counsel for the executrix. Place for 10 days time. Place all the accounts, all the details of the accounts of the testator as well as the executrix from the date of death of the testator and from the date of testator until date, which is now maintaining by the executrix. Let the matter appear on आज कितना 11 तारीख है ना 24th of 10 है ना 10 दिन 14 let appear on 18th.
Kindly, would it be my Lord's pleasure to fix the time?
Hey, 18th any date can be fixed so that I can also get ready so that energy should be there.
Yes, no. But whatever energy was required, both the councils have
Both of us joined the profession practically together.
within 1 month.
19th what time? 19th at 12. 19th at 12 noon.
Great.
Yes, next.
345. I'm very sorry, my lord, but before my lord, because this matter will go on for some time, the 345 fixed matter. The very next matter, my lord, in the regular list, item 8, that's for fixation of date. My lord,
Yes, what is the that I will come to.
It's my application for judgment upon admission.
Who is for the other side?
It's there.
Mr. Sen, what any matter?
To be mentioned number 11. Like come back another day, not for day after tomorrow.
11. Who is for the other side? Yes. They wanted to argue the matter.
My lord, this has been fixed for CAV.
Correct. It was CAV. They mentioned that they wanted some opportunity to argue the matter. That's why I fixed it to be mentioned. If you say, I will give it, you can also give the reply. There is no problem.
My lord, the notes, I think they'll file a new set of notes of argument. This has already has been filed.
So there was one note which was pre-argument notes. But at the time of argument that I had missed it, they had filed the notes post-argument. I want to file the notes and make short submission on the notes. Whenever your lordship.
You do one thing. I am fixing. You give what the notes you're relying upon. Give in advance to them so that they can also give the reply. So what date can be fixed? When? 22nd, 3:45. 22nd at 3:45. 22nd at 3:45. Note it, huh? It will come tomorrow. Tomorrow difficulty.
Tomorrow is the holiday.
Achha, day after tomorrow. It will come day after tomorrow. Yes.
My application for judgment upon admission will order.
Who is for the other side?
But I am there for the defendant.
Judgment on admission?
Yes, my pleadings are complete. So, my lord, now it's for final hearing. My lord, in a nutshell, my lord, I am a plaintiff. It's a suit for eviction. I don't recognize recognize the defendant as my tenant. There was no landlord-tenant relationship between the plaintiff and the defendant at any point of time. Now, my lord, when I filed the suit, before filing, I wrote him letters that if you have any document in your possession claiming or in support of your claim of tenancy, please supply. He wrote to me that somebody else, some third party inducted him in the property and he doesn't have any relationship with me directly, but he is willing to pay rent to me. That was his stand before filing the suit. Then I wrote to him that I don't want to know who had inducted you. Please tell me what do you have to do with me if there is any agreement between me and you. Otherwise, you are a trespasser. Now, there was no response to that. So, we filed the suit. After we filed the suit, the written statement, they came up with a story of adverse possession. The only defense taken in the written statement, the material defense, is that by adverse possession.
Counterclaim filed?
No. Written statement is there. There is no counterclaim.
Written statement on defense?
On defense.
No
counterclaim.
No counter.
Now, my lord, in the defense is that by long possession, I have become the owner at adverse possession. So you don't have title. It's the defendant who have it is the defendants who now have the title. That now, my lord, while saying so, in effect, what happens? The defendant, my lord,
admit there is no landlord-tenant relationship between the plaintiff and the defendant. Now, my lord, I will show you, lordship, the pleadings. Lordship, from the bare pleading of the written statement, that's the only pleading he has. It has to be come out from the pleadings whether he at all has any defense in that score or not. If he doesn't, then it's an admission that there is no relationship. And that he is a trespasser. In terms of that admission, I have filed this application for judgment upon admission. Now, my lord, for the beginning, my lord, I find kindly come to my lord, page 12 of my, because I as a plaintiff has to show your lordship the title of the property. Kindly come to page 12 of my application, my lord, as the title deed. I purchased the property from my lord, the special officer appointed by this court.
So, there is no denial with regard to ownership because they are asking for the adverse possession.
Adverse possession. So, but I have to, as a title, I have to prove that the title belongs to me. It has always, all along belonged to me, and nobody else had any title. So, he can't claim anything from anyone else. So, that in order to defeat that question of adverse possession, I have to show it. So, page number 12 is the deed by which I purchased the property, 19th February 1998, my lord. On the first page, lordship would find the name of the, my lord,
Title deed, yes.
yes.
So it is between the.
First is the special officer, Sushanta Kumar Basu.
Yes.
He is the special officer appointed by this court. Thereafter, my lord, at the page 15, my lord, lordship would find my name, the plaintiff's name, Amalgamated Films Limited.
Amalgamated Films, yes.
And at page 16 and 17, lordship would find the names of the confirming parties who were the who were the actual title holders of the property. They were the because there were litigations regarding the property. So, special officer was appointed, and through him the sale took place. Now, if lordship comes to the schedule of this deed, that is at page at page 19, page 30 of the application. The schedule is there. Lordship can tally this schedule with the schedule of my plaint. From that, it would come out that it's the same property that I am talking about in this plaint. A portion of the property.
Page
30.
30.
30.
Correct.
Is the schedule of my property.
Yes.
Middle portion, lordship would find 87B, A, B, A.
Premises 87A, 87B, 87C.
Yes, the entirety belongs to me. The entire premises belongs to me.
Correct. Now, which is the property here?
Yes. Now, Miller, page 46 is the schedule of my plaint.
46.
46. After purchasing, there was an amalgamation. So now, Miller, it is entirely as known as the premises number 87 of Park Street.
So now it has become 87.
Yes. I'm not in that property, 450 square feet. It's an outhouse on the ground floor of the property.
450 square meters.
That's the suit premises. So entirety is mine. Within that, he is in possession of this 450 square feet.
Yes.
Admittedly in possession. I just take you through lordship through the plaint once. It's very short plaint. The lordship at page 39 the pleading starts. Page 40 at paragraph 4, my lord. The defendants are in exclusive.
Showing the written statement.
No, plaint 2 paragraphs I will show, my lord.
Yes.
Page 40.
Yes.
The defendants are in exclusive occupation and possession of an outhouse at the ground floor of the suit property consisting of 450 square feet, more or less described such and such. The defendants are occupying the suit premises illegally and without any authority. There is no jurial relationship between the plaintiff and the defendants. The defendants are not entitled to remain in occupation or possession of the suit premises. So this is what I allege. The defendant, there is no jurial relationship ever. Now, that apart from that, the plaint only talks about thereafter the prayers, because I don't have to prove anything. I prove the title. I prove I said what I want from the plaint. Now, that kindly comes to the written statement, which is the subject matter 76. It starts at page 76.
Page 76. Yes.
First, nine paragraphs are Miller usual defenses. I am ignoring them, Miller. Kindly come to paragraph Miller 11. But 11, but out of 12, Miller, paragraph 12. That is the material paragraph.
Yeah.
But fourth line from top, it is stated that the defendants are in occupation and possession of the suit property by the acquisition of title of the suit property by adverse possession. The defendant is occupying the suit property peacefully, openly, and extensively, and the general public has adequate knowledge of the same. The acquisition of title in the suit property by the defendant is by prescription. The defendant is holding the suit property as a matter of right on his own as the owner, hostile to and in denial of the title of the real owner. The defendant's right and entitlement to the suit property by adverse possession is corpus possessendi and animus possessendi continuously for over statutory period. Thereafter, my lord, next paragraph, is just the next paragraph. The defendant has acquired and perfected its title by way of adverse possession. My lord, that's all.
Yes.
This is the sole defense taken.
Correct.
That is my application. Now, my lord, in order to lordship, I'll show you lordship the law on adverse possession, my lord. Merely by saying this, he does not become a owner of adverse possession, because my lord, he has to say on which date he entered, how he entered, who had allowed him to enter, and which is the date from where from he becomes the owner through adverse possession. Nothing on those pleadings are not there. Lordship has seen. I've read. These are all that he has said. No particulars, nothing. Now, my lord, in absence of those particulars, what happens? The judgments are very clear up to 2024 Supreme Court. These are very clear. I'll show you, lordship, those judgments. I'll, my lord, in order to show that this stand is absolutely, my lord, false, kindly come to page, kindly take my affidavit in reply once, my lord. Falsity of the case, my lord, it would come out, my lord, from the papers itself written and from the letters written by the defendant itself. My lord. Page 9 of my affidavit in reply. I'm not showing the pleadings, my lord. But I write to him, this is before filing of the suit, 30th October 2019 letter. I am writing to him that as per our records, said portion under your occupation possession was given to Opipuri by us. However, the said Opipuri no more resides in the said portion, which is being occupied by you, along with the family members. You are not entitled to use and occupy the said portion. There is no contractual relation between us. You are requested to send relevant documents with regard to your status and justifying your occupation in respect of said portion within 15 days from the date of receipt of this letter. This is I write to him. In reply, next page, page 10, kindly see the reply and then lordship kindly remind what he has written in the written statement. Kindly read the reply. Page 10 and 11 are the replies. I, Dr. Abdul Kader Mullik, he is the defendant number 1 here. The flat in question being occupied by me on the extraordinary circumstances occupying the said flat are stated herein below. 1. Lorian Datta, wife of such, was residing in this flat. Said person had said Mrs. Opipuri had been suffering from various diseases like sugar, high blood pressure, and such. In 2001, Lorian Datta convinced Opipuri about homeopathic treatment, and thereafter I was introduced. Since 2001, I was giving homeopathic treatment to Mrs. Opipuri for diabetes along with some other doctors. During this course of time, I was compelled to visit her frequently as I did not have shelter, so sometimes it was very difficult for me to visit her. Later, Mrs. Opipuri came to know about my residential status from Mrs. Lorian Datta, and it was found that I did not have an accommodation, and then she offered me to reside in her residence along with Mr. and Mrs. Datta. Mrs. Opipuri also informed me that I can stay there rest of my life in this flat because Mrs. and Mr. Datta will be moving to their new residence very soon. As per suggestion, I have been residing in this flat along with Mr. and Mrs. Datta since 2001. Unfortunately, Mrs. Opipuri passed away in 2003. In 2007, Lorian Datta introduced me to Shashi Puri, relative of Opipuri, and told me to pay 5,500 per month monthly rent to Shashi Puri, as Mrs. Datta was paying the same rent to her. Mr. and Mrs. Datta shifted to the new flat at Picnic Garden. Both Mrs. Opipuri and Mrs. Shashi Puri never issued any receipt of rent bill against the monthly payment by me or Mrs. Lorian Datta. I am paying 500 monthly rent. This is what he is writing in 2019, that he is paying rent to Shashi Puri from 2007 up to 2015, and thereafter I paid a rent of a sum of rupees 1,500 per month till middle of 2017. Sometime in July to August 2017, Mrs. Shashi Puri wanted to eject the undersigned. As a consequence, Mrs. Shashi Puri refused to accept the monthly rent from me. Now that he is paying rent to someone, I don't recognize that someone as well, but whatever he is paying rent according to him. As I have no other residential accommodation in the city of Kolkata, I requested her to allow me to stay in the flat, but she didn't listen to me. As I do not have any shelter other than that present one, so I was compelled to stay here. During this time, I requested her several times to take rent from me, but she refused. Since then, I am staying in this flat without paying any rent to her. So, now that was thereafter, I know that you are a good and conscious citizen, and you have run so many charitable organizations for the welfare of poor citizens and financial backward students who needs funds for their welfare and education and higher studies and other welfare activities. In the aforementioned circumstances, I state an appeal before you, Your Honor, that I am single person and senior citizen and suffering from various old age disease. My nephew and brothers are looking after me. In the meantime, I contacted your good sales office at Poddar Court, Ravindra for my own assistance and also various other compound related problems. In the meantime, I received instant letter dated 31st, the letter I showed. Last paragraph, Miller, kindly comes to page 12. But this is most hilarious. At this juncture, I am appealing to your honor to be kind enough to permit me to occupy the said flat till my death as tenant in respect of the said flat, and I am ready to pay rent of rupees 1500 per month, and I'm ready to pay a sum of rupees 20,000 for your charitable fund for charitable purpose. The original demand draft is enclosed herewith for your ready reference.
It's a good writer.
I do not know, Milord, who is the author of this, but Milord, be that as it may, next page is my letter. I said I do not want to know all this. The next page, page 13, I say I do not want to know all this. We are not concerned. What is your arrangement with whoever? You are well aware that you are in illegal possession and occupation and exclusive possession. You are therefore requested to vacate the same and hand over to us the vacant and peaceful possession thereof. Immediately, failing which, we shall be constant to take appropriate legal steps. But then I should show your lordship one more letter. The last document of this. In fact, the demand draft is also annexed here. The draft that he had sent me, 23rd, I did not encash it. Page 16 is the last letter, Milord. This is gone from our end. This has come from defendant number 1. Defendant number 1's letter, page 16. The moment I said I'll initiate appropriate action, now Milord, kindly see this.
How many defendants are there?
There are 2 defendants, most probably their Milord, father and relatives. Milord. I do not know the exact relation, most probably because
This was issued to whom?
But I don't know his identity. He is there, according to me, he is there in the possession. I will show that from that document only how is the possession. But Milord, I do not know the relationship between these 2 defendants. But one is communicating, and the affidavit in reply, the written statement is filed by one on behalf of both, but affirmed by one. Now, Milord, the last page 16, he says that from 2001, I'm in occupation and run charitable dispensary with due knowledge of with your due knowledge. That is the case. Now, Milord, kindly come to now that one defense has been taken in the affidavit in opposition to my application by the defendant number 1, that there are documents in his written statement from which he can substantiate his case. Now, Milord, lordship kindly sees the written statement which I have annexed in my application. Lordship kindly comes to page 85 of my application. Milord. That is the document that my defendant are relying upon for trial. But what are these documents? They are the only documents he has. There are 14 documents. I'm reading one by one. The passport, driving license, electric connection, motorcycle, LIC policy, BSNL telephone, voter ID card, HP gas connection, driving license, Airtel broadband, voter ID card, PAN card, Aadhaar card. Of whom lordship would find that on the right side of the column, Abdul Kader Malik, first 3 names and first 4 names. 4th name is Abdul Basar Malik, who is the defendant number 2. So all these documents belong to only these 2 persons. So all that they have are various documentary evidences wherefrom they can show probably the address of the premises that they are residing. No one is disputing that. What they have to show is that knowingly, knowledge to me, date, particulars, how he has become and then that letter. He has tendering rent to me. He is saying, I'm willing to pay you rent. Please allow me and accept me as your tenant. Adverse possessions case is demolished by their own letter. Now, Milord, in view of that, there is no other case made out in anywhere. In view of that, there is one judgment I want to cite, Milord, in order to just show that the case of adverse possession cannot be pleaded like that. It has to be, Milord, properly. But I'm sure I'll hand over a copy, Milord. 2024 SCC online, Supreme Court 318. It's very recent judgment. Citation ta diye. But I will not trouble you with the facts. Milord, kindly come to Milord, paragraph 9. Milord, plaintiff in that suit, in this judgment, Milord, plaintiff is that suit, where sought for a declaration of ownership based on adverse possession. Now, paragraph 9 says so. The plaintiff can never succeed unless he proves the plea of adverse possession. There is a concurrent finding of the fact on this issue against the plaintiff. As far as the plea of adverse possession is concerned, the constitution bench of this court in the case of M. Siddiq and such, now the law is laid down. A plea of adverse possession is founded on the acceptance that ownership of the property vested in another against whom the claimant asserts a possession adverse to the title of the other. Possession is adverse in the sense that it is contrary to the acknowledged title in the other person against whom it is claimed. Evidently, therefore, the plaintiff in suit number 4 ought to be cognizant of the fact that any claim of adverse possession against the Hindus or the temple would amount to an acceptance of a title in the letter. Dr. Dhavanda submitted that this plea is a subsidiary or alternate plea upon which it is not necessary of the plaintiff to stand in the event, whether their main plea of title is held to be established on evidence. It becomes then necessary to assess as to whether the claim of adverse possession has been established. A person who sets up a plea of adverse possession must establish both possession, which is peaceful, open and continuous possession, which means the requirement of being nec v nec claim and nec perquario. The substantiate a plea to adverse possession, the character of the possession must be adequate in continuity and in the public, because the possession has to be in the knowledge of the true owner in order to fit order for it to be adverse. These requirements have been duly established first by adequate pleadings and second by leading sufficient evidence. Evidence, it is well settled, can only be adduced in reference to matters which are pleaded in the civil suit. And in the absence of adequate pleadings, evidence by itself cannot supply the deficiency of a pleading.
That is the law.
That is the law. That one more paragraph I want to show from this judgment. Kindly come to the paragraph 12. These are the most important factors which my learned friend missed. What he has to say in his pleadings. These are the four conditions.
These are the four conditions of their
Missed, and they missed it. Now, in absence of these pleadings, no amount of evidence can give them any relief. Just that other paragraph I read.
Now the second question is whether they can change the
Stand. Yes,
stand,
that's the question of estoppel. You have said you are offering us rent, requesting us to accept you as tenant, and then when I file the suit, you say I'm the owner as a adverse person. These are I don't think I have to cite. I have other judgments on the same proposition. I don't think those are required.
Yes,
these are.
That's all.
But I'm being led by Mr. Kankani. Mr. Kankani.
But his lordships, kindly, my lord. This is, my lord, the facts of the matter lies in a very narrow compass, my lord. He's offered me rent, my lord. It washes out everything, the entire defense, my lord.
You're not a good man. He has requested you give the charitable and all.
My lord, the entire,
that.
my lord, the entire property is by, my lord, good men. I am a bad man, and that is why I'm out, my lord, today. And I have to come to court, my lord.
He's running the charitable trial, chanting all the.
In fact, my lord, there was an offer from them, my lord, that you allow me to live there till December 2023, which we agreed to, and I will vacate. But that date has also gone, my lord, and grateful.
Firstly, my lord, I do not know about this offer that I will stay till 2023.
I will, very well.
I will. And secondly, my lord, I have not been fortunate to. But now it has been handed over the judgment. My lord, I'll deal with the judgment after I address your lordship on this. My lord, before I get into the merits of the matter, my lord, this application, my lord, it has been argued that this application is for judgment upon admission. My lord, but my lord, I do not find any pleading with regard to judgment upon admission, and neither is the prayer for judgment upon admission. What it appears is that, my lord, this is an application under Chapter 13A of the original side rules. Because, my lord, what they are saying, if your lordship comes to the statements made in this application, in the entire application, there is no pleading that I have admitted to their claims in the suit. But I'll tell your lordship possibly why, my lord, they are making these submissions that this is an application for judgment upon admission, because this is otherwise appears to be an application under Chapter 13A, which has to be filed within a specified time, which they have not. My lord, that is why, my lord, they are now saying that no, this is not Chapter 13A, this is the judgment upon admission. What my learned friend just now murmured is that in paragraph 8 there is a pleading. I'll read paragraph 8 for your lordship. The respondents in their written statement have denied the title of the petitioner and claimed title hostile to that of the petitioner. Apart from mere statements in the written statement, the respondents have failed to disclose any material document in support of its contention. That's a separate matter. In any event, the sole contention of the defendant raised in the written statement is untenable and without any basis and material. The respondents have, in other words, admitted that there is no juror relationship between the petitioner and the respondents. Well, this is the extent of admission which they allege
that I have not admitted the jural relationship between the parties. But my case in the written statement is that since the year 2008, I have documents to show that I was there. And I am claiming title in my written statement hostile to the owner, whoever that may be. Unless that is decided on trial, if I succeed, I succeed. If I fail, I fail. But unless that is proved in evidence, and the case of the plaintiff is proved in evidence, the letter which has been disclosed with the affidavit in reply, I do not know. I do not know who has written it. I do not know whether that is genuine or not. I have no instructions to that effect. So even the plaintiff has to prove that this letter was actually written by me, by the defendant. That even in the year 2017 or 19, I had begged mercy and wanted to stay there till the end of my life. So unless those are proved, the suit cannot be decreed on an application under Chapter 13A. But I'll come to that later. Lordship knows, my lord, my first point was that under Chapter 13A, the application has to be taken out within 10 days. If a written statement is filed by the defendant, it is not permissible after the expiry of 10 days, which they have not. I have filed the written statement for them. But I'll give you, Lordship, the dates. The written statement was filed on 13th April 2022. I had entered appearance on 7th January 2022. This application
WS filed on
13th April 2022.
Yes.
This application was affirmed on 30th November 2022. More than 7 months.
Filed on 22nd November.
Application filed on 30th November 2022. Affirmed on 30th November 2022.
Yes.
So my first point is with regard to the maintainability of this application, is that it is impermissible under the rules.
Why?
And my second argument is
Why impermissible?
because if your lordship kindly takes up the original side rules, Chapter 13A.
This is not Chapter 13.
That is what my submission is. The argument was that it was an application for judgment upon admission. Neither is there a prayer for
So
judgment.
you ask specifically after going to the pleading whether it is Order 12 Rule 6.
No, it is not. It would come out from the pleading itself, from the application and the prayers made. Had there been one prayer, judgment upon admission, decree be drawn up, I would have understood. Even if there is no pleading, I would have understood. I would have still believed. But the prayer made in this application is absolutely similar to the release claimed in the suit. Prayer A, decree for eviction. Prayer B, decree for mean profits. Prayer C, decree for mean profits from further period. D, alternatively, adjudication of the mean profit. E, interim interest. Where is the admission on which my learned friend wants a decree? This is my first submission. And even in the applications, the pleadings made in the application, it will not come out that there is any admission, unconditional, unambiguous admission that I have conceded to their claim. And secondly, the letter which has been used in the reply, that letter has not been written by me. And it has neither been proved by the plaintiff that it was written by me. But in an application, I do not have any chance of sur rejoinder after the reply is filed. I cannot possibly dispute and take out an affidavit disputing the existence of this document. But this matter has to go to trial, and my documents which I have disclosed have to be proved or have to be disproved by the plaintiff. These are the 2 points today it's 4:30 already. Lordship will kindly give me another date. These are the points on which I'll argue.
Senses when suffering for the plaintiff, senses when suffering for the defendant. Plaintiff has filed an application being GA2 of 2022, praying for judgment on admission. Also for the plaintiff has argued.
Yes.
Also for the defendant has argued at length, but due to paucity of time, argument could not be completed. Fix.
That is exactly.
7th May.
I'm grateful.
Grateful, man.